QUAMTO 1. General Principles. Concept of Remedial Law. Question: how shall the rules of court be construed? 1998 bar. Answer: the rules of court should be liberally constructed in order to promote their objective of securing a just, speedy and inexpensive disposition of every action and proceeding. Section 6, Rule 1. Question: what is the concept of remedial law? Distinguish between substantive law and remedial law. 2006 bar. Answer: the concept of remedial law is that it is a branch of public law which prescribes the procedural rules to be observed in litigations, whether civil, criminal, or administrative, and in special proceedings, as well as the remedies or reliefs available in each case. Substantive law is that part of the law which creates, defines and regulates rights and obligations, the violation of which gives rise to a cause of action. On the other hand, remedial law prescribes the method of enforcing rights or obtaining redress for their invasion. Cf. Bustos vs. Lucero, 81 Philippines 540, 650, 1948. Question: how are remedial laws implemented in our system of government? 2006 bar. Answer: remedial laws are implemented in our system of government through the judicial system, including the prosecutory service, our courts and quasi-judicial agencies. Doctrine of non-interference or doctrine of judicial stability. Question: in rendering a decision, should a court take into consideration the possible effect of its verdict upon the political stability and economic welfare of the nation? 2003 bar. Answer: no, because a court is required to take into consideration only the legal issues and the evidence admitted in the case. The political stability and economic welfare of the nation are extraneous to the case. They can have persuasive influence, but they are not the main factors that should be considered in deciding a case. A decision should be based on the law, rules of procedure, justice and equity. However, in exceptional cases the court may consider the political stability and economic welfare of the nation when these are capable of being taken into judicial notice of and are relevant to the case. Jurisdiction. Jurisdiction of courts. Supreme Court. Question: distinguish questions of law from questions of fact. 2004 bar. Answer: a question of law is when the doubt or difference arises as to what the law is on a certain set of facts, while a question of fact is when the doubt or difference arises as to the truth or falsehood of alleged facts. Ramos vs. Pepsi-Cola Bottling Company of the Philippines, General Register Number L22533, February 9, 1967. Question: Good Feather Corporation, through its president, Al Pequino, filed with the Regional Trial Court, RTC, a complaint for specific performance against Robert White. Instead of filing an answer to the complaint, Robert White filed a motion to dismiss the complaint on the ground of lack of the appropriate board resolution from the Board of Directors of Good Feather Corporation to show the authority of Al Pequino to represent the corporation and file the complaint in its behalf. The RTC granted the motion to dismiss and, accordingly, it ordered the dismissal of the complaint. Al Pequino filed a motion for reconsideration which the RTC denied. As nothing more could be done by Al Pequino before the RTC, he filed an appeal before the Court of Appeals, CA. Robert White moved for dismissal of the appeal in the ground that the same involved purely a question of law and should have been filed with the Supreme Court, SC. However, Al Pequino claimed that the appeal involved mixed questions of fact and law because there must be a factual determination if, indeed, Al Pequino was duly authorized by Good Feather Corporation to file the complaint. Whose position is correct? Explain. 2014 bar. Answer: Al Pequino is correct in claiming that the appeal involved mixed questions of fact and law. There is a question of law when the doubt or difference arises as to what the law is on a certain state of facts. On the other hand, there is a question of fact, when the doubt or difference arises as to the truth or falsehood of alleged facts. MRN Philippines Corporation vs. Serio, General Register Number 197598, November 21, 2012. Since the complaint was dismissed due to the alleged lack of appropriate board resolution from the Board of Directors of Good Feeder Corporation, the appeal will necessarily involve a factual determination of the authority to file the complaint for the said corporation. Hence, the appeal before the Court of Appeals is correct. Court of Appeals. Question: give at least 3 instances where the Court of Appeals may act as trial court. 2008 Bar. Answer: A. In annulment of judgment under Sections 5 and 6, Rule 47. Should the Court of Appeals find prima facie merit in the petition, the same shall be given due course and summons shall be served on the respondent, after which trial will follow, where the procedure in ordinary civil cases shall be observed. B. When a motion for new trial is granted by the Court of Appeals, the procedure in the new trial shall be the same as that granted by a regional trial court, Section 4, Rule 53. C. A petition for habeas corpus shall be set for hearing, Section 12, Rule 102. D. In a petition for the writs of amparo and habeas data, a hearing can be conducted. E. Under Section 12, Rule 124 of the Rules of Criminal Procedure, the Court of Appeals has the power to try cases and conduct hearings, receive evidence and perform any and all acts necessary to resolve factual issues cases which fall within its original and appellate jurisdiction. F. The Court of Appeals can grant a new trial based on the ground of newly discovered evidence, Section 14, Rule 124. G. The Court of Appeals, under Section 6, Rule 46, whenever necessary to resolve factual issues, may conduct hearing thereon or delegate the reception of the evidence of such issues to any of its members or to an appropriate agency or office. Question: does the Court of Appeals have jurisdiction to review the decisions in criminal and administrative cases of the Ombudsman? 2006 Bar. Answer: the Supreme Court has exclusive appellate jurisdiction over decisions of the Ombudsman in criminal cases, Section 14, Republic Act 6770. In administrative and disciplinary cases, appeals from the Ombudsman must be taken to the Court of Appeals under Rule 43, Landing v. Ombudsman, General Register Number 141426, May 6, 2005. Fabian v. Tessierdo, General Register Number 129742, September 16, 1998, Section 14, Republic Act 6770. Court of Tax Appeals. Question: Mark filed with the Bureau of Internal Revenue a complaint for refund of taxes paid, but it was not acted upon. So, he filed a similar complaint with the Court of Tax Appeals referred to one of its divisions. Mark's complaint was dismissed. Thus, he filed with the Court of Appeals a petition for certiorari under Rule 65. Does the Court of Appeals have jurisdiction over Mark's petition? 2006 Bar. Answer: no. The procedure is governed by Section 11 of Republic Act 9282. Decisions of a division of the Court of Tax Appeals must be appealed to the Court of Tax Appeals en banc. Further, the CTA now has the same rank as the Court of Appeals and is no longer considered as a quasi-judicial agency. It is likewise provided in the said law that the decisions of the CTA en banc are cognizable by the Supreme Court under Rule 45 of the 1997 Rules of Civil Procedure. Sandiganbayan. Question: the Ombudsman, after conducting the requisite preliminary investigation, found probable cause to charge Governor Matagazing conspiracy with Carpenter, a private individual, for violating Section 3A of Republic Act, RA, No. 3019, Anti-Graft and Corrupt Practices Act, as amended. Before the information could be filed with the Sandiganbayan, Governor Madagas was killed in an ambush. This, notwithstanding, an information was filed against Governor Madagas and Carpintero. At the Sandiganbayan, Carpintero through counsel, filed a motion to quash the information, on the ground of lack of jurisdiction of the Sandiganbayan, arguing that with the death of Governor Madagas, there is no public officer charged in the information. Is the motion to quash legally tenable? 2014 bar. Answer: The motion to quash is not legally tenable. While it is true that by reason of the death of Governor Madagas, there is no longer any public officer with whom he can be charged for violation of Republic Act 3019, it does not mean, however, that the allegation of conspiracy between them can no longer be proved or that their alleged conspiracy is already expunged. The only thing extinguished by the death of Governor Madagas is his criminal liability. His death did not extinguish the crime nor did it remove the basis of the charge of conspiracy between him and Carpintero. The requirement before a private person may be indicated for violation of Section 3G of Republic Act 3019, among others, is that such private person must be alleged to have acted in conspiracy with a public officer. The law, however, does not require that such person must, in all instances, be indicated together with the public officer. Indeed, it is not necessary to join all alleged co-conspirators in an indictment for conspiracy. People of the Philippines vs. Henry T. Go, General Register Number 168539, March 25, 2014. Regional Trial Courts. Question: State at least 5 civil cases that fall under the exclusive original jurisdiction of the Regional Trial Court, RTC. 2016 bar. Answer: The Regional Trial Courts inter alia shall exercise exclusive original jurisdiction in the following civil cases. 1. In all civil actions in which the subject of the litigation is incapable of pecuniary estimation. 2. In all civil actions which involve title to, or possession of, real property, or any interest therein, where the assessed value of the property involved exceeds 20,000 pesos, 20,000, or, for civil actions in Metro Manila where such value exceeds 50,000 pesos, 50,000, except actions for forcible entry into an unlawful detainer of lands or buildings, original jurisdiction over which is conferred upon the Metropolitan Trial Courts. 3. In all actions in Admiralty and Maritime jurisdiction where the demand or claim exceeds 300,000 pesos, 300,000, or, in Metro Manila, where such demand or claim exceeds 400,000 pesos, 400,000. 4. In all matters of probate, both testate and intestate, where the gross value of the estate exceeds 300,000 pesos, 300,000, or, in probate matters in Metro Manila, where such gross value exceeds 400,000 pesos, 400,000. 5. In all actions involving the contract of marriage and marital relations. 6. In all cases not within the exclusive jurisdiction of any court, tribunal, person or body exercising judicial or quasi-judicial functions. 7. In all civil actions and special proceedings falling within the exclusive original jurisdiction of a juvenile and domestic relations court and of the Court of Agrarian Relations as now provided by law, and 8. In all other cases in which the demand, exclusive of interest, damages of whatever kind, attorney's fees, litigation expenses, and costs or the value of the property in controversy exceeds 300,000 pesos, 300,000, or, in such other cases in Metro Manila, where the demand exclusive of the above-mentioned item exceeds 400,000 pesos, 400,000. Section 1 and 19 of Batas Pambansabalang 129, otherwise known as the Judiciary Reorganization Act of 1980. Question: A files an action in the municipal trial court against B, the natural son of A's father, for the partition of a parcel of land located in Taytay, Rizal with an assessed value of 20,000.00 pesos. B moves to dismiss the action on the ground that the case would have been brought in the RTC because the action is one that is not capable of pecuniary estimation, as it involves primarily a determination of hereditary rights and not merely the bare right to real property. Resolve the motion. 2000 bar. Answer: the motion should be granted. The action for partition depends on a determination of the hereditary rights of A and B, which is not capable of pecuniary estimation. Hence, even though the assessed value of the land is 20,000 pesos, the municipal trial court has no jurisdiction. Russell v. Vestal, General Register No. 119347. March 17, 1999. Question: A filed with the MTC of Manila an action for specific performance against B, a resident of Quezon City, to compel the latter to execute a deed of conveyance covering a parcel of land situated in Quezon City having an assessed value of 19,000.00 pesos. B received the summons and a copy of the complaint of January 2, 2003. On January 10, 2003, B filed a motion to dismiss the complaint on the ground that the subject matter of the suit was incapable of pecuniary estimation. The court denied the motion. In due time, B filed with the RTC a petition for certiorari praying that the said order be set aside because the MTC has no jurisdiction over the case. On February 13, 2003, A filed with the MTC a motion to declare B in default. The motion was opposed by B on the ground that his petition for certiorari was still pending. A. Was the denial of the motion to dismiss the complaint correct? Answer: the denial of the motion to dismiss the complaint was not correct. Although the assessed value of the parcel of land involved was 19,000 pesos within the jurisdiction of the MTC Manila, the action filed by A for specific performance against B to compel the latter to execute a deed of conveyance of said parcel of land was not capable of pecuniary estimation and, therefore, the action was within the jurisdiction of RTC, Russell v. Vestal, Supra, Copioso v. Copioso, General Register No. 149243, October 28, 2002. Cabutin v. Land Center Construction, General Register No. 146594, June 10, 2002. B. Resolve the motion to declare the defendant in default. 1997, 2003, 2012 bar. Answer: the court could declare B in default because B did not obtain a writ of preliminary injunction or a temporary restraining order from the RTC prohibiting the judge from proceeding in the case during the pendency of the petition for certiorari. Section 7 Rule 65, Diaz v. Diaz, General Register No. 135885, April 28, 2000. Question: Angelina sued Armando before the Regional Trial Court, RTC, of Manila to recover the ownership and possession of two parcels of land, one situated in Pampanga, and the other in Bulacan. 2009 bar. A. May the action prosper? Explain. Answer: no, the action may not prosper, because under Rep. Act No. 7691. Exclusive original jurisdiction in civil actions which involve title to, or possession or real property or any interest therein is determined on the basis of the assessed value of the land involved, whether it should be 20,000 in the rest of the Philippines, outside of the Manila with courts of the first level or with the regional trial court. The assessed value of the parcel of land in Pampanga is different from the assessed value of the land in Bulacan. What is involved is not merely a matter of venue, which is RIBL, but of a matter of jurisdiction. However, the action may prosper if jurisdiction is not an issue, because venue can be waived. B. Will your answer be the same if the action was for foreclosure of the mortgage over the 2 parcels of land? Why or why not? 2000 bar. Answer: no, the answer would not be the same. The foreclosure action should be brought in the proper court of the province where the land or any part thereof is situated, either in Pampanga or in Bulacan. Only one foreclosure action need be filed unless each parcel of land is covered by distinct mortgage contract. In foreclosure suit, the cause of action is for the violation of the terms and conditions of the mortgage contract, hence, one foreclosure suit per mortgage contract violated is necessary. Question: On August 13, 2008, A, as shipper and consignee, loaded on the MV Atlantis in Legazpi City 100,000 pieces of century eggs. The shipment arrived in Manila totally damaged on August 14, 2008. A filed before the Metropolitan Trial Court, METC, of Manila a complaint against B Superlines Incorporated, B Lines, owner of the MV Atlantis, for recovery of damages amounting to $167,899. He attached to the complaint the bill of lading. A. B Lines filed a motion to dismiss upon the ground that the Regional Trial Court has exclusive original jurisdiction over all actions in admiralty and maritime claims. In his reply, A contended that while the action is indeed admiralty and maritime in nature, it is the amount of the claim, not the nature of the action, that governs jurisdiction. Pass on the motion to dismiss. Answer: the motion to dismiss is without merit and therefore should be denied. Courts of the first level have jurisdiction over civil actions where the demand is for sum of money not exceeding 300,000 or in Metro Manila, 400,000 pesos exclusive of interest, damages, attorney's fees, litigation expenses and costs. This jurisdiction includes admiralty and marine cases. And where the main cause of action is the claim for damages, the amount thereof shall be considered in determining the jurisdiction of the court. Admiral Circular No. 0994, June 14, 1994. B. The METC denied the motion in question. A. B Lines thus filed an answer raising the defense that under the bill of lading it issued to A, its liability was limited to 10,000. At the pre-trial conference, B Lines defined as one of the issues whether the stipulation limiting its liability to 10,000 binds A. A countered that this was no longer an issue as B Lines had failed to deny under oath the bill of lading. Which of the parties is correct? Explain. Answer: the contention of B is correct, A's contention is wrong. It is A who pleaded the bill of lading as an actionable document where the stipulation limits B's liability to 8 to 10,000 only. The issue raised by B does not go against or impugn the genuineness and due execution of the bill of lading as an actionable document pleaded by A, but invokes the binding effect of said stipulation. The oath is not required of B, because the issue raised by the latter does not impugn the genuineness and due execution of the bill of lading. C. On July 21, 2009, B Lines served on A notice to take deposition, setting the deposition on July 29, 2009 at 8:30 a.m. at the office of its counsel in Makati. A failed to appear at the deposition taking, despite notice. As counsel for B Lines, how would you proceed? 2010 bar. Answer: as counsel for B Lines, which gave notice to take the deposition, I shall proceed as follows. 1. Find out why A failed to appear at the deposition taking, despite notice. 2. If failure was for valid reason, then set another date for taking the deposition. 3. If failure to appear at deposition taking was without valid reason, then I would file a motion, application in the court where the action is pending, for an order to show cause for his refusal to the discovery, and 4. for the court to issue appropriate order provided under Rule 29 of the Rules, for non-compliance with the show cause order, aside from contempt of court. Question: how should the records of child and family cases in the family courts or RTC designated by the Supreme Court to handle family court cases be treated and dealt with? Under what conditions may the identity of parties in child and family cases be divulged? 2001 Bar. Answer: the records of child and family cases in the family courts or regional trial courts designated by the Supreme Court to handle family court cases shall be dealt with utmost confidentiality. Section 12, Family Courts Act of 1997, shall not be divulged unless necessary and with authority of the judge. Id. Question: Juliet, invoking the provisions of the Rule on Violence Against Women and Their Children, filed with the RTC designated as a family court a petition for issuance of a temporary protection order, TPO, against her husband, Romeo. The family court issued a 30-day TPO against Romeo. A day before the expiration of the TPO, Juliet filed a motion for extension. Romeo in his opposition raised, among others, the constitutionality of Republic Act No. 9262, the Vaughn Law, arguing that the law authorizing the issuance of a TPO violates the equal protection and due process clauses of the 1987 Constitution. The family court judge, in granting the motion for extension of the TPO, declined to rule on the constitutionality of Republic Act No. 9262. The family court judge reasoned that family courts are without jurisdiction to pass upon constitutional issues, being a special court of limited jurisdiction, and Republic Act No. 8369, the law creating the family courts, does not provide for such jurisdiction. Is the family court judge correct when he declined to resolve the constitutionality of Republic Act No. 9262? 2015 Bar. Answer: no, the family court judge is not correct when it declined to resolve the constitutionality of Republic Act No. 9262. In Garcia v. Honorable Ray Alendrelon, General Register No. 179267, June 25, 2013. The Supreme Court held that the family courts have authority and jurisdiction to resolve the constitutionality of a statute. In spite of its designation as a family court, the RTC remains to possess the authority as a court of general original jurisdiction to pass upon all kinds of cases, whether civil, criminal, special proceedings, land registration, guardianship, naturalization, admiralty or insolvency. This authority is embraced in the general definition of judicial power to determine the valid and binding laws in conformity with the fundamental law. Metropolitan Trial Courts, Municipal Trial Courts. Question: Filomeno brought in action in the Metropolitan Trial Court, METC, of Pasay City against Marcellino, pleading two causes of action. The first was a demand for the recovery of physical possession of a parcel of land situated in Pasay City with an assessed value of 40,000 pesos. The second was a claim for damages of 500,000 pesos for Marcellino's unlawful retention of the property. Marcellino filed a motion to dismiss on the ground that the total amount involved, which is 540,000 pesos, is beyond the jurisdiction of the METC. Is Marcellino correct? 2008 Bar. Answer: no, Marcellino is not correct. Under Rep. Act No. 7691, Metropolitan Trial Court and other courts of the first level have been vested with exclusive original jurisdiction in all civil actions which involve title to, or possession of real property or any interest therein where the assessed value of the property or interest therein does not exceed 20,000.00 pesos, or in civil actions in Metro Manila, where such assessed value does not exceed 50,000.00 pesos exclusive of interest, damages of whatever kind, attorney's fees, litigation expenses and costs. Pasay City, where the action for recovery of physical possession was filed, is part of Metro Manila and therefore has exclusive jurisdiction over the parcel of land situated therein whose assessed value is 40,000.00 pesos. The claim for damages of 500,000.00 pesos for the unlawful retention of the land involved is not determinative of the court's jurisdiction, which is based on the nature of the action. The claim for damages of 500,000.00 is just a consequence of the unlawful detention of the property subject of the action, which should not be taken separately from the land. Philomeno has only one cause of action, which is the action for recovery of possession of the land against Marcelino, with damages. Question: Annabelle filed a complaint against B for unlawful detainer before the Municipal Trial Court, MTC, of Candaba, Pampanga. After the issues had been joined, the MTC dismissed the complaint for lack of jurisdiction after noting that the action was one for Achi and Publishina. Annabelle appealed the dismissal to the RTC, which affirmed it and accordingly dismissed her appeal. She elevates the case to the Court of Appeals, which remands the case to the RTC. Is the appellate court correct? Explain. 2010 Bar. Answer: Yes, the Court of Appeals is correct in remanding the case to RTC for the latter to try the same on the merits. The RTC, having jurisdiction over the subject matter of the case appealed from MTC, should try the case on the merits as if the case was originally filed with it, and not just to affirm the dismissal of the case. Republic Act No. 7691, however, vested jurisdiction over specified Achi and Publishina with courts of the first level, metropolitan trial courts, municipal trial courts, and municipal circuit trial courts, in cases where the assessed value of the real property involved does not exceed 20,000 outside Metro Manila, or in Metro Manila where such value does not exceed 50,000. Question: Plaintiff filed a complaint for a sum of money against defendant with the MTC Makati, the total amount of the demand, exclusive of interest, damages of whatever kind, attorney's fees, litigation expenses and costs, being 1 million. In due time, defendant filed a motion to dismiss the complaint on the ground of MTC's lack of jurisdiction over the subject matter. After due hearing, the MTC, 1. Ruled that the court indeed lacked jurisdiction over the subject matter of the complaint, and, 2. Ordered that the case therefore should be forwarded to the proper RTC immediately. Was the court's ruling concerning jurisdiction correct? Was the court's order to forward the case correct? Explain briefly. 2004 Bar. Answer: Yes. The MTC did not have jurisdiction over the case because the total amount of the demand exclusive of interest, damages of whatever kind, attorney's fees, litigation expenses, and costs, was 1 million. Its jurisdictional amount at this time should not exceed 400,000. Section 33 of Batas Pambansa Big 29, as amended by Republic Act No. 7691. The court's order to forward the case to the RTC is not correct. It should merely dismiss the complaint. Under Section 3 of Rule 16, the court may dismiss the action or claim, deny the motion or order the amendment of the pleading but not to forward the case to another court. Question: Estrella was the registered owner of a huge parcel of land located in a remote part of their barrio in Benguet. However, when she visited the property after she took a long vacation abroad, she was surprised to see that her childhood friend, John, had established a vacation house on her property. Both Estrella and John were residents of the same barangay. To recover possession, Estrella filed a complaint for ejectment with the Municipal Trial Court, MTC, alleging that she is the true owner of the land as evidenced by her certificate of title and tax declaration, which showed the assessed value of the property as 21,000.00 pesos. On the other hand, John refuted Estrella's claim of ownership and submitted an evidence, a deed of absolute sale between him and Estrella. After the filing of John's answer, the MTC observed that the real issue was one of ownership and not of possession. Hence, the MTC dismissed the complaint for lack of jurisdiction. On appeal by Estrella to the Regional Trial Court, RTC, a full-blown trial was conducted as if the case was originally filed with it. The RTC reasoned that based on the assessed value of the property, it was the court of proper jurisdiction. Eventually, the RTC rendered a judgment declaring John as the owner of the land and, hence, entitled to the possession thereof. A. Was the MTC correct in dismissing the complaint for lack of jurisdiction? Why or why not? Answer. The Metropolitan Trial Court was not correct in dismissing the complaint for lack of jurisdiction. It is well settled that jurisdiction is determined by the allegations contained in the complaint. The contention of defendant in his motion to dismiss has nothing to do in the determination of jurisdiction. Otherwise, jurisdiction would become dependent almost entirely upon the whims of the defendant. Medical Plaza Makati Condominium vs. Cullen, General Register No. 181416, November 11, 2013. Relative thereto, the municipal trial courts have exclusive original jurisdiction over cases of forcible entry and unlawful detainer, Section 33, but is Pambansa 129. Hence, the Metropolitan Trial Court is not correct in dismissing the complaint for lack of jurisdiction. Besides, the rules allow provisional determination of ownership in ejectment cases when the defendant raises the defense of ownership in his pleadings and the question of possession cannot be resolved without deciding the issue of ownership, Section 16, Rule 70. Accordingly, the inferior courts have jurisdiction to resolve questions of ownership whenever it is necessary to decide the question of possession in an ejectment case. Serrano vs. Spouses Gutierrez, General Register No. 162366, November 10, 2006. B. Was the RTC correct in ruling that based on the assessed value of the property, the case was within its original jurisdiction and, hence, it may conduct a full-blown trial of the appealed case as if it was originally filed with it? Why or why not? 2014 Bar. Answer. It is settled that forcible entry and unlawful detainer cases are within the exclusive original jurisdiction of the MTC. Moreover, all cases decided by the MTC are generally appealable to the RTC irrespective of the amounts involved, Section 22, but is Pambansa 129. Special Courts. Question. What court has jurisdiction over an action for specific performance filed by a subdivision homeowner against a subdivision developer? Explain. 2002 Bar. Answer. An action for specific performance by a subdivision homeowner against a subdivision developer is within the jurisdiction of the Housing and Land Use Regulatory Board, LURB. Section 1 of Presidential Decrees 1344 provides that the LURB has jurisdiction over cases involving specific performance of contractual and statutory obligations filed by buyers of subdivision lots and condominium units against the owner, developer, dealer, broker or salesman. Manila Bankers Life Insurance Corporation vs. Eddie N. G. Cockway, General Register No. 139791, December 12, 2003, Kukulila vs. Farad, General Register No. 143233, October 18, 2004, Section 1, PD 1344. How jurisdiction over the defendant is acquired. Question. Lonnie filed an action for partition and accounting in the Regional Trial Court, RTC, of Manila against her sister Mary Rouse, who is a resident of Singapore and is not found in the Philippines. Upon motion, the court ordered the publication of the summons for 3 weeks in a local tabloid, Bulgar. Linda, an OFW vacationing in the Philippines, saw the summons in Bulgar and brought a copy of the tabloid when she returned to Singapore. Linda showed the tabloid and the page containing the summons to Mary Rouse, who said, Yes, I know. My Kumaranita scanned and emailed that page of Bulgar to me. Did the court acquire jurisdiction over Mary Rose? 2008. Answer: no, the court did not acquire jurisdiction over Mary Rouse, the defendant. While serving summons by publication is allowed in this case under Section 15, Rule 14 of the Rules of Court, the required sending of the copy of the summons and the order of the court by registered mail to the last known address of the same defendant has not been followed. Service of summons by publication under said rule has not been complied with, thus, there is no valid service. Totality Rule. Question: lender extended to borrower a 100,000 pesos loan covered by a promissory note. Later, borrower obtained another 100,000 loan again covered by a promissory note. Still later, borrower obtained a 300,000 pesos loan secured by a real estate mortgage on his land valued at 500,000 pesos. Borrower defaulted on his payments when the loans matured. Despite demand to pay the 500,000 pesos loan, borrower refused to pay. Lender, applying the totality rule, filed against borrower with the Regional Trial Court, RTC, of Manila, a collection suit for 500,000 pesos. Did lender correctly apply the totality rule and the rule on jointer of causes of action? 2015 bar. Answer: yes. The lender correctly applied the totality rule and the rule on jointer of causes of action because where the claims in all the causes of action are principally for recovery of sum of money, the aggregate amount of the claim shall be the test of jurisdiction, Section 5D, Rule 2. Here, the total amount of the claim is 500,000 pesos. Hence, the Regional Trial Court, RTC, of Manila has jurisdiction over the suit. At any rate, it is immaterial that one of the loans is secured by a real estate mortgage because the lender opted to file a collection of sum of money instead of foreclosure of the said mortgage. Question: at the trial, borrower's lawyer, while cross-examining lender, successfully elicited an admission from the latter that the two promissory notes have been paid. Thereafter, borrower's lawyer filed a motion to dismiss the case on the ground that as proven only 300,000 pesos was the amount due to lender and which claim is within the exclusive original jurisdiction of the Metropolitan Trial Court. He further argued that lack of jurisdiction over the subject matter can be raised at any stage of the proceedings. Should the court dismiss the case? 2015 bar. Answer: the court should not dismiss the case. What determines the jurisdiction of the court is the nature of the action pleaded as appearing from the allegations in the complaint. The averments therein and the character of the relief sought are the ones to be consulted. Navida v. Honorable Teodoro A. Dizon Jr., General Register No. 125078. May 30, 2011. Accordingly, even if the defendant is able to prove in the course of the trial that a lesser amount is due, the court does not lose jurisdiction and a dismissal of the case is not in order. Padlin v. Dingleson, General Register No. 180321, March 20, 2013. Civil Procedure. Personal actions and real actions. Question: what do you mean by A, real actions, and B, personal action? 2006 bar. Answer: real actions are actions affecting title to or possession of real property or an interest therein. All other actions are personal actions. Section 1, Rule 4. Question: Eduardo, a resident of the city of Manila, filed before the Regional Trial Court, RTC, of Manila a complaint for the annulment of a deed of real estate mortgage he signed in favor of Galaxy Bank, Galaxy, and the consequent foreclosure and auction sale on his mortgaged Makati property. Galaxy filed a motion to dismiss on the ground of improper venue alleging that the complaint should be filed with the RTC of Makati since the complaint involves the ownership and possession of Eduardo's lot. Resolve the motion with reasons. 2016 bar. Answer: the motion to dismiss should be granted. An action for nullification of the mortgage documents and foreclosure of the mortgaged property is a real action that affects the title to the property. Thus, venue of the real action is before the court having jurisdiction over the territory in which the property lies. Jimmy T. Go vs. United Coconut Planters Bank, General Register Number 156187, Novs. 11, 2004, QUA vs. Total Office Products and Services, September 30, 2005. In Fortune Motors vs. Court of Appeals, General Register NE. 112191, February 7, 1997. The Supreme Court also held that an action to annul a foreclosure sale of a real estate mortgage is no different from an action to annul a private sale of real property. While it is true that petitioner does not directly seek the recovery of title or possession of the property in question, his action for annulment of sale and his claim for damages are closely intertwined with the issue of ownership of the building which, under the law, is considered a movable property, the recovery of which is petitioner's primary objective. The prevalent doctrine is that an action for the annulment or rescission of a sale of real property does not operate to efface the fundamental and prime objective and nature of the case, which is to recover said real property. It is a real action. Paglom Management and Development Corporation vs. Union Bank of the Philippines, General Register Number 179018, June 12, 2012. Being a real action, it shall be commenced and tried in the proper court which has jurisdiction over the area where the real property involved, or a portion thereof, is situated. Section 1, Rule 4, Rules of Court. The complaint should be filed in the RTC of Makati where the mortgaged property is situated. Alternative answer: the motion to dismiss should be denied. An action for the annulment of a real estate mortgage is a personal action, which may be commenced and tried where the defendant or any of the defendants resides or may be found, or where the plaintiff or any of the plaintiffs resides or may be found, at the election of plaintiff. Section 2, Rule 4, Rules of Court, QUA vs. Total Office Products and Services, September 30, 2005, Orbeta vs. Orbeta, General Register Number 166837, Novs. 27, 2006. Since the plaintiff resides in Manila, the complaint was properly filed in RTC of Manila. Cause of action. Question: distinguish cause of action from action. 1997, 1999 bar. Answer: an action is one by which a party sues another for the enforcement or protection of a right, or the prevention or redress of a wrong. Section 3A, second part. A cause of action is the act or omission by which a party violates a right of another. Section 2, Rule 2. An action must be based on a cause of action. Section 1, Rule 2. Question: a bought a Volvo sedan from ABC Cars for P5.0M. ABC Cars, before delivering to A, had the car rust-proofed and tinted by Z's Detailing. When delivered to A, the car's upholstery was found to be damaged. ABC Cars and Z's Detailing both deny any liability. Who can A sue and on what causes of action? Explain. 2012 bar. Answer: a can file an action for specific performance and damages against ABC Cars since the damage to the Volvo sedan's upholstery was caused before delivery of the same to A, and therefore prior to the transfer of ownership to the latter, Article 1477, and cc. Under Article 1170 of the Civil Code, those who contravene the tenor of the obligation are liable for damages. Hence, an action for specific performance against ABC Corporation to deliver the agreed Volvo sedan in the contract free from any damage or defects, with corresponding damages will lie against ABC Cars. Splitting a single cause of action and its effects. Question: What is the rule against splitting a cause of action and its effect on the respective rights of the parties for failure to comply with the same? 1999 bar. Answer: the rule against splitting a cause of action and its effect are that if two or more suits are instituted on the basis of the same cause of action, the filing of one or a judgment upon the merits in any one is available as a ground for the dismissal of the others. Section 4, Rule 2. Question: A purchased a lot from B for 1,500,000.00 pesos. He gave a down payment of 500,000.00 pesos, signed a promissory note payable 30 days after date, and as a security for the settlement of the obligation, mortgaged the same lot to B. When the note fell due and A failed to pay, B commenced suit to recover from A the balance of 1,000,000 pesos. After securing a favorable judgment on his claim, B brought another action against A before the same court to foreclose the mortgage. A now files a motion to dismiss the second action on the ground of bar by prior judgment. Rule on the motion. 1999 bar. Answer: the motion to dismiss should be granted. When B commenced suit to collect on the promissory note, he waived his right to foreclose the mortgage. B split his cause of action. Question: Raphael, a warehouseman, filed a complaint against V Corporation, X Corporation and Y Corporation to compel them to interplead. He alleged therein that the three corporations claimed title and right of possession over the goods deposited in his warehouse and that he was uncertain which of them was entitled to the goods. After due proceedings, judgment was rendered by the court declaring that X Corporation was entitled to the goods. The decision became final and executory. Raphael filed a complaint against X Corporation for the payment of 100,000 for storage charges and other advances for the goods. X Corporation filed a motion to dismiss the complaint on ground of res judicata. X Corporation alleged that Raphael should have incorporated in his complaint for interpleader his claim for storage fees and advances, that for his failure he was barred from interposing his claim. Raphael replied that he could not have claimed storage fees and other advances in his complaint for interpleader because he was not yet certain as to who was liable therefore. Resolve the motion with reasons. 2005 bar. Answer: the motion to dismiss should be granted. Raphael should have incorporated in his complaint for interpleader his claim for storage fees and advances, the amounts of which were obviously determinable at the time of the filing of the complaint. They are part of Raphael's cause of action which he may not split. Hence, when the warehouseman asks the court to ascertain who among the defendants are entitled to the goods, he also has the right to ask who should pay for the storage fees and other related expenses. The filing of the interpleader is available as a ground for dismissal for the second case. Section 4, Rule 2. It is akin to a compulsory counterclaim which, if not set up, shall be barred. Section 2, Rule 9, Ariza vs. Diaz, General Register No. 133113, August 30, 2001. Question: Rolando filed a petition for declaration of the nullity of his marriage to Carmelo because of alleged psychological incapacity of the latter. After trial, the court rendered judgment dismissing the petition on the ground that Rolando failed to prove the psychological incapacity of his wife. The judgment having become final, Rolando filed another petition, this time on the ground that his marriage to Carmelo had been celebrated without a license. Is the second action barred by the judgment in the first? Why? 2002 bar. Answer: The second action is not barred by the judgment in the first because they are different causes of action. The first is for annulment of marriage on the ground of psychological incapacity under Article 36 of the Family Code, while the second is for the declaration of nullity of the marriage in view of the absence of a basic requirement, which is a marriage license, Articles 9 and 35, 3, F.C. They are different causes of action because the evidence required to prove them are not the same. Pagzihan vs. Court of Appeals, General Register Number L34885, January 28, 1980, and other cases. Joinder and misjoinder of causes of action. Question: P sued A and B in one complaint in the RTC Manila, the cause of action against A being an overdue promissory note for 300,000.00 and that against B being on an alleged balance of 300,000.00 on the purchase price of goods sold on credit. Does the RTC Manila have jurisdiction over the case? Explain. 2002 Bar. Answer: Number The RTC Manila has no jurisdiction over the case. A and B could not be joined as defendants in one complaint because the right to relief against both defendants do not arise out of the same transaction or series of transaction, and there is no common question of fact common to both. Rule 3, Section 6. Hence, separate complaints will have to be filed and they would fall under the jurisdiction on the Metropolitan Trial Court. Flores v. Maller Phillips, General Register Number L66620, September 24, 1986. Question: Give the effects of the following. 1. Splitting a single cause of action, and 2. Non-joinder of a necessary party. 1998 Bar. Answer: 1. The effect of splitting a single cause of action is found in the rule as follows: if two or more suits are instituted on the basis of the same cause of action, the filing of one or a judgment on the merits in any one is available as a ground for the dismissal of the others. Section 4, Rule 2. 2. The effect of the non-joinder of a necessary party may be stated as follows: the court may order the inclusion of an omitted necessary party if jurisdiction over his person may be obtained. The failure to comply with the order for his inclusion without justifiable cause is a waiver of the claim against such party. The court may proceed with the action but the judgment rendered shall be without prejudice to the rights of such necessary party. Section 9, Rule 3. Question: What is the rule on jointer of causes of action? 1999 Bar. Answer: The rule on joinder of causes of action is that a party may in one pleading assert, in the alternative or otherwise, as many causes of action as he may have against an opposing party, provided that the rule on jointer of parties is complied with. The jointer shall not include special civil actions or actions governed by special rules, but may include causes of action pertaining to different venues or jurisdictions provided one cause of action falls within the jurisdiction of a regional trial court and venue lies therein, and the aggregate amount claimed shall be the test of jurisdiction where the claims in all the causes of action are principally for the recovery of money. Section 5, Rule 2. Question: A secured two loans from B1 for 500,000.00 and the other for 1,000,000.00 pesos payable on different dates. Both have fallen due. Is B obliged to file only one complaint against A for the recovery of both loans? Explain. 1999 Bar. Answer: Number jointer is only permissive since the loans are separate loans which may be governed by the different terms and conditions. The two loans give rise to two separate causes of action and may be the basis of two separate complaints. Question: Perry is a resident of Manila, while Ricky and Marvin are residents of Batangas City. They are the co-owners of a parcel of residential land located in Pasay City with an assessed value of 100,000 pesos. Perry borrowed 100,000 pesos from Ricky, which promised to pay on or before December 1, 2004. However, Perry failed to pay his loan. Perry also rejected Ricky and Marvin's proposal to partition the property. Ricky filed a complaint against Perry and Marvin in the RTC of Pasay City for the partition of the property. He also incorporated in his complaint his action against Perry for the collection of the latter's 100,000 pesos loan, plus interests and attorney's fees. State with reasons whether it was proper for Ricky to join his causes of action in his complaint for partition against Perry and Marvin in the RTC of Pasay City. 2005 bar. Answer: it was not proper for Ricky to join his causes of action against Perry and his complaint for partition against Perry and Martine. The causes of action may be between the same parties, Ricky and Perry, with respect to the loan but not with respect to the partition which includes Martine. The jointer is between a partition and a sum of money, but partition is a special civil action under Rule 69, which cannot be joined with other causes of action, see 5b, Rule 2. Also, the causes of action pertain to different venues and jurisdictions. The case for a sum of money pertains to the municipal court and cannot be filed in Pasay City because the plaintiff is from Manila while Ricky and Marvin are from Batangas City, Section 5, Rule 2. Parties to civil actions. Real parties in interest, indispensable parties, representatives as parties, necessary parties, indigent parties, alternative defendants. Question: in 1996, Congress passed Republic Act No. 8189, otherwise known as the Voters Registration Act of 1996, providing for the computerization of elections. Pursuant thereto, the COMELEC approved the Voters Registration and Identification System (VRIS) project. It issued invitations to pre-qualify and bid for the project. After the public bidding, Photokina was declared the winning bidder with a bid of $6 billion and was issued a notice of award. But COMELEC Chairman Jenner Go objected to the award on the ground that under the Appropriations Act, the budget for the COMELEC's modernization is only $1 billion. He announced to the public that the VRIS project has been set aside. 2 commissioners sided with Chairman Go, but the majority voted to uphold the contract. Meanwhile, Photokina filed with the RTC a petition for mandamus to compel the COMELEC to implement the contract. The Office of the Solicitor General, OSG, representing Chairman Go, opposed the petition on the ground that mandamus does not lie to enforce contractual obligations. During the proceedings, the majority commissioners filed a manifestation that Chairman Go was not authorized by the COMELEC and Bank to oppose the petition. May the OSG represent Chairman Go before the RTC notwithstanding that his position is contrary to that of the majority? 2002 bar. Answer: yes, the OSG may represent the COMELEC chairman before the RTC notwithstanding that his position is contrary to that of the majority of the commission members in the COMELEC because the OSG is an independent office, its hands are not shackled to the cause of its client agency. The primordial concern of the OSG is to see to it that the best interest of the government is upheld. COMELEC vs. Quijano Padilla, G. R. No. 151992, September 18, 2002. Question: half-brothers Roscoe and Salvio inherited from their father a vast tract of unregistered land. Roscoe succeeded in gaining possession of the parcel of land in its entirety and transferring the tax declaration thereon in his name. Roscoe sold the northern half to Bono, Salvio's cousin. Upon learning of the sale, Salvio asked Roscoe to convey the southern half to him. Roscoe refused as he even sold 1/3 of the southern half along the west to Carlo. Thereupon, Salvio filed an action for the reconveyance of the southern half against Roscoe only. Carlo was not impleaded. After filing his answer, Roscoe sold the middle third of the southern half to Nina. Salvio did not amend the complaint to implead Nina. After trial, the court rendered judgment ordering Roscoe to reconvey the entire southern half to Salvio. The judgment became final and executory. A writ of execution having been issued, the sheriff required Roscoe, Carlo and Nina to vacate the southern half and yield possession thereof to Salvio as the prevailing party. Carlo and Nina refused, contending that they are not bound by the judgment as they are not parties to the case. Is the contention tenable? Explain fully. 2008 bar. Answer: yes. In case of transfer of interest pending litigation, the action may be continued by or against the original party unless the court, upon motion, directs a person to be substituted in the action or joined with the original party. Section 19, Rule 3. The owners of property over which reconveyance is asserted are indispensable parties and must be joined in the action. Accordingly, the contention of Carlo, who is such party to the action filed by Salvio, is tenable. He is not bound by the judgment because he became a co-owner of the land before the case was filed, and yet he has not been included as a party thereto. Matagina Integrated Wood Products Incorporated vs. Court of Appeals, General Register Number 98310, October 24, 1996, Ma. Valencia Santana Cruz vs. Court of Appeals, General Register Number 120176, July 20, 2001. Nina, however, is a successor in interest of Roscoe and privy to the case. Hence, she is bound by the judgment as against Roscoe although she is not party to the case. Section 19, Rule 3, Cabrasos vs. Taro, General Register Number L46843, October 18, 1988. A judgment is conclusive between the parties and their successors in interest by title subsequent to the case. Section 47, Rule 39. Question: Strauss filed a complaint against Wagner for cancellation of title. Wagner moved to dismiss the complaint because Grieg, to whom he mortgaged the property as duly annotated in the TCT, was not pleaded as defendant. A. Should the complaint be dismissed? Answer: The complaint should not be dismissed because the mere non-joinder of an indispensable party is not a ground for the dismissal of the action. Section 11, Rule 3, Republic vs. Honorable Mangatara, General Register Number 170375, July 7, 2010. B. If the case should proceed to trial without Grieg being pleaded as a party to the case, what is his remedy to protect his interest? 2015 Bar. Answer: If the case should proceed to trial without Grieg being pleaded as a party, he may intervene in the action. Section 1, Rule 19. He may also file a petition for annulment of judgment under Rule 47 of the Rules of Court. In Metrobank vs. Honorable Floro Alayo, General Register Number 141970, September 10, 2001, the Supreme Court held that in a suit to nullify an existing torrent certificate of title, TCT, in which a real estate mortgage is annotated, the mortgagee is an indispensable party. In such suit, a decision cancelling the TCT in the mortgage annotation is subject to a petition for annulment of judgment, because the non-joinder of a mortgagee deprived the court of jurisdiction to pass upon the controversy. Class suit. Question: Distinguish a derivative suit from a class suit. 2005 Bar. Answer: A derivative suit is a suit in equity that is filed by a minority shareholder in behalf of a corporation to redress wrongs committed against it, for which the directors refuse to sue, the real party in interest being the corporation itself. Lim vs. Slim U, General Register Number 138343, February 19, 2001. A class suit is filed in behalf of many persons so numerous that it is impracticable to join all as parties. Section 12, Rule 3. Effect of death of party litigant. Question: What is the effect of the death of a party upon a pending action? 1999 Bar. Answer: When the claim in a pending action is purely personal, the death of either of the parties extinguishes the claim and the action is dismissed. When the claim is not purely personal and is not thereby extinguished, the party should be substituted by his heirs or his executor or administrator. Section 16, Rule 3. If the action is for recovery of money arising from contract, express or implied, and the defendant dies before entry of final judgment in the court in which the action was pending at the time of such death, it shall not be dismissed but shall instead be allowed to continue until entry of final judgment. A favorable judgment obtained by the plaintiff shall be enforced in the manner provided in the rules for prosecuting claims against the estate of a deceased person, Section 20, Rule 3. Question: P.J. engaged the services of attorney St. to represent him in a civil case filed by OP against him, which was docketed as civil case number 123. A retainership agreement was executed between P.J. and attorney St. whereby P.J. promised to pay attorney St. a retainer sum of $24,000 a year and to transfer the ownership of a parcel of land to attorney St. after presentation of P.J.'s evidence. P.J. did not comply with his undertaking. Attorney St. filed a case against P.J. which was docketed as civil case number 456. During the trial of civil case number 456, P.J. died. A. Is the death of P.J. a valid ground to dismiss the money claim of attorney St. in civil case number 456? Explain. Answer: Number under Section 20, Rule 3, 1997 Rules of Civil Procedure, when the action is for recovery of money arising from contract, express or implied, and the defendant dies before entry of final judgment in the court in which the action is pending at the time of such death, it shall not be dismissed but shall instead be allowed to continue until entry of final judgment. A favorable judgment obtained by the plaintiff shall be enforced in the manner especially provided in the rules for prosecuting claims against the estate of the deceased person. B. Will your answer be the same with respect to the real property being claimed by attorney St. in civil case number 456? Explain. 1999, 2000, 2009 bar. Answer: Yes. An action to recover real property in any event survives the death of the defendant, Section 1, Rule 87. However, a favorable judgment may be enforced in accordance with Section 7b Rule 39 against the executor or administrator or successor in interest of the deceased. Question: A filed a complaint for the recovery of ownership of land against B who is represented by her counsel X. In the course of the trial, B dies. However, X failed to notify the court of B's death. The court proceeded to hear the case and rendered judgment against B. After the judgment became final, a writ of execution was issued against C, who being B's sole heir, acquired the property. If you were the counsel of C, what course of action would you take? 1998 bar. Answer: As counsel of C, I would move to set aside the writ of execution and the judgment for lack of jurisdiction and lack of due process in the same court because the judgment is void. If X had notified the court of B's death, the court would have ordered the substitution of the deceased by C, the sole heir of B, Section 16, Rule 3. The court acquired no jurisdiction over C upon whom trial and the judgment are not binding. Faria vs. Ibar Republic Act of 10. The Gonzales, General Register Number L 11567, July 17, 1958. De la Cruz vs. Court of Appeals, General Register Number L 41107, February 28, 1979. Lawaz vs. Court of Appeals, General Register Number L 45809, December 12, 1986. I could also file an action to annul the judgment for lack of jurisdiction because C, as the successor of B, was deprived of due process and should have been heard before judgment. Rule 47. Question: Prince Chong entered into a lease contract with King Kong over a commercial building where the former conducted his hardware business. The lease contract stipulated, among others, a monthly rental of $50,000 for a 4-year period commencing on January 1, 2010. On January 1, 2013, Prince Chong died. Kintu Chong was appointed administrator of the estate of Prince Chong, but the former failed to pay the rentals for the months of January to June 2013 despite King Kong's written demands. Thus, on July 1, 2013, King Kong filed with the Regional Trial Court, RTC, An action for rescission of contract with damages and payment of accrued rentals as of June 30, 2013. A. Can King Tuchong move to dismiss the complaint on the ground that the RTC is without jurisdiction since the amount claimed is only 300,000.00? Answer. King Tuchong cannot move to dismiss the complaint. An action for rescission of contract with damages and payment of accrued rentals is considered incapable of pecuniary estimation and therefore cognizable by the regional trial court. Safarina den Ungria vs. Court of Appeals, General Register No. 165777, July 25, 2011. B. If the rentals accrued during the lifetime of Prince Chong, and King Kong also filed the complaint for sum of money during that time, will the action be dismissible upon Prince Chong's death during the pendency of the case? 2014 Bar. Answer. The action will not be dismissible upon Prince Chong's death during the pendency of the case. When the action is for recovery of money arising from contract, and defendant dies before entry of final judgment in the court in which the action was pending at the time of such death, it shall not be dismissed but shall instead be allowed to continue until entry of final judgment. A favorable judgment obtained by the plaintiff shall be enforced under Rule 86, Section 20, Rule 3. Relative thereto, since the complaint for sum of money filed by King Kong survives the death of Prince Chong, the case shall not be dismissed and the court shall merely order the substitution of the deceased defendant. Attorney Rogelio E. Sarsaba vs. Favda. Dete, General Register No. 175910, July 30, 2009. Venue. Question. Distinguish jurisdiction from venue. 2006 Bar. Answer. Jurisdiction is the power of the court to decide a case on the merits, while venue refers to the place where the suit may be filed. In criminal actions, however, venue is jurisdictional. Jurisdiction may not be conferred upon a court by consent through waiver, but venue may be waived except in criminal cases. Question. Angela, a resident of Quezon City, sued Antonio, a resident of Makati City before the RTC of Quezon City for the reconveyance of 2 parcels of land situated in Tarlac and Nueva Ecija, respectively. May her action prosper? Assuming that the action was for foreclosure on the mortgage of the same parcels of land, what is the proper venue for the action? 2008 Bar. Answer. Yes. The action may prosper because improper venue can be waived, and there appears to be no objection from the defendant. An action for reconveyance of parcels of land partakes of an action to recover title to or possession of such land, hence a real action which should be filed in the place where the parcels of land are situated in Tarlac and Nueva Ecija. If the action was for foreclosure of mortgage, the action may be filed either in Tarlac or Nueva Ecija where any of the parcels of land is situated. Only one action for foreclosure need be filed as only one contract had been instituted. Bank of PI vs. Green, General Register No. 35125, December 12, 1932. Question. A law was passed declaring Mount Carbunco as a protected area since it was a major watershed. The protected area covered a portion located in Municipality A of the province I and a portion located in the city of Z of Province 2. Mangat is the leader of Samahan and G Tagapagangat and G Carbunco, STK, a people's organization. He learned that a portion of the mountain located in the city of Z of Province 2 was extremely damaged when it was bulldozed and leveled to the ground, and several trees and plants were cut down and burned by workers of World Pleasure Resorts Incorporated, WPRI, for the construction of a hotel and golf course. Upon inquiry with the project site engineer if they had a permit for the project, Mangat was shown a copy of the Environmental Compliance Certificate, ECC, issued by the Denry MB, Regional Director, Road Denry MB. Immediately, MainGat and SDK filed a petition for the issuance of a writ of continuing mandamus against Road NREMB and WPRI with the RTC of Province I, a designated environmental court, as the Road NREMB negligently issued the ECC to WPRI. On scrutiny of the petition, the court determined that the area where the alleged actionable neglect or omission subject of the petition took place in the city of Z of Province 2, and therefore cognizable by the RTC of Province 2. Thus, the court dismissed outright the petition for a lack of jurisdiction. A. Was the court correct in motu proprio dismissing the petition? Answer: No. The court was not correct in motu proprio dismissing the petition. While it appears that the alleged actionable neglect or omission took place in the city of Z of Province 2 and, therefore cognizable by the RTC of Province 2, nonetheless, venue is not jurisdictional, and it can be waived in a special civil action for continuing mandamus. Dolot vs. Honorable Page, General Register No. 199199, August 27, 2013. Besides, under Section 1, Rule 9 of the Rules of Court, defenses and objections not pleaded in the answer or in the motion to dismiss are deemed waived. Hence, the court cannot motu proprio dismiss the case on the ground of improper venue. Question: Assuming that the court did not dismiss the petition, the Road NREMB in his comment moved to dismiss the petition on the ground that petitioners failed to appeal the issuance of the ECC and to exhaust administrative remedies provided in the DENR rules and regulations. Should the court dismiss the petition? 2015 Bar. Answer: Yes, the court should dismiss the petition because the proper procedure to question defect in an ECC is to follow the DENR administrative appeal process in accordance with the doctrine of exhaustion of administrative remedies. Dolot vs. Honorable Page, General Register No. 199199, August 27, 2013, Page vs. Casino, General Register No. 207257. February 3, 2015. Effects of stipulations on venue. Question: X, a resident of Angeles City, borrowed 300,000 from A resident of Pasay City. In the loan agreement, the parties stipulate that the parties agree to sue and be sued in the city of Manila. A. In case of non-payment of the loan, can A file his complaint to collect the loan from X in Angeles City? Answer: Yes, because the stipulation in the loan agreement that the parties agree to sue and be sued in the city of Manila does not make Manila the exclusive venue thereof. Section 4, Rule 4. Hence, A can file his complaint in Angel City where he resides. Section 2, Rule 4. B. Suppose the parties did not stipulate in the loan agreement as to the venue, where can A file his complaint against X? Answer: If the parties did not stipulate on the venue, A can file his complaint either in Angeles City where he resides or in Pasay City where X resides. Id. C. Suppose the parties stipulated in their loan agreement that venue for all suits arising from this contract shall be the courts in Quezon City. Can A file his complaint against X in Pasay City? 1997 Bar. Answer: Number if the parties stipulated that the venue shall be in the courts in Quezon City, A cannot file his complaint in Pasay City because the use of the word shall makes Quezon City the exclusive venue thereof. Hoaxed Philippines vs. Torres, General Register No. L 44351 May 18, 1978. Rules on Pleadings. Question: What is counterclaim? Distinguish a counterclaim from a cross-claim. 1999 Bar. Answer: A counterclaim is distinguished from a cross-claim in that a cross-claim is any claim by one party against a co-party arising out of the transaction or occurrence that is the subject matter either of the original action or of a counterclaim therein. A counterclaim is against an opposing party while a cross-claim is against a co-party. Section 8, Rule 6. Question: A. Who is engaged in tile installation business, was sued by E Industries for breach of contract for installing different marble tiles in its offices as provided in their contract. Without filing any motion to dismiss, A filed its answer with counterclaim theorizing that E Industries has no legal capacity to sue because it is not a duly registered corporation. By way of counterclaim, A asked for moral and actual damages as her business depleted as a result of the withdrawal and cancellation by her clients of their contracts due to the filing of the case. The case was dismissed after the trial court found that E Industries is not a registered corporation and therefore has no legal capacity to sue. However, it set a date for the reception of evidence on A's counterclaim. E Industries opposed on the ground that the counterclaim could no longer be prosecuted in view of the dismissal of the main case. Is the stand of E Industries sustainable? Explain. 1999 bar. Answer: no, because if no motion to dismiss has been filed, any of the grounds for dismissal provided in the rules may be pleaded as an affirmative defense in the answer, which may include a counterclaim. This is what A did by filing an answer alleging the lack of legal capacity of E Industries to sue because it is not a duly registered corporation with a counterclaim for damages. The dismissal of the complaint on this ground is without prejudice to the prosecution of the counterclaim in the same action because it is a compulsory counterclaim. Section 6, Rule 16. Question: Faye filed a suit for collection of $387,000 against Ramon in the RTC of Davao City. Aside from alleging payment as a defense, Ramon in his answer set up counterclaims for $100,000 as damages and $30,000 as attorney's fees as a result of the baseless filing of the complaint, as well as for $250,000 as the balance of the purchase price of the 30 units of air conditioners he sold to Faye. A. Does the RTC have jurisdiction over Ramon's counterclaims, and if so, does he have to pay docket fees therefore? Answer: yes. The RTC has jurisdiction over Ramon's counterclaims because they are all money claims in which the totality rule applies in determining jurisdiction. Section 5D, Rule 2. Ramon has to pay docket fees for his counterclaims whether counterclaim is compulsory or permissive in nature. Rule 141 of the Rules of Court has been amended to require payment of docket fees for counterclaims and cross-claims whether compulsory or permissive. B. Suppose Ramon's counterclaim for the unpaid balance is $310,000. What will happen to his counterclaims if the court dismisses the complaint after holding a preliminary hearing on Ramon's affirmative defenses? Answer: the dismissal of the complaint is without prejudice to the right of the defendant, Ramon, to prosecute his counterclaim in the same or in a separate action. Section 6, Rule 16, Last Par, Pina vs. Sayers of Santiago, General Register No. 170,354. June 30, 2006. C. Under the same premise as paragraph B, above, suppose that instead of alleging payment as a defense in his answer, Ramon filed a motion to dismiss on that ground, at the same time setting up his counterclaims, and the court grants his motion. What will happen to his counterclaims? 2008 bar. Answer: since Ramon filed only a motion to dismiss, not an answer, the dismissal of the complaint would also bring about the dismissal of his counterclaims, but he can file a separate action for his permissive counterclaims. The compulsory counterclaims are deemed waived when he filed a motion to dismiss the complaint instead of answering the same. Financial Building Corporation vs. Forbes Park Association Incorporated, General Register No. 133,119, August 17, 2000. Question: Antique dealer Mercedes borrowed $1,000 from antique collector Benjamin. Mercedes issued a post-dated check in the same amount to Benjamin to cover the debt. On the due date of the check, Benjamin deposited it, but it was dishonored. As despite demands, Mercedes failed to make good the check, Benjamin filed in January 2009 a complaint for collection of sum of money before the RTC of Davao. Mercedes filed in February 2009 her answer with counterclaim, alleging that before the filing of the case, she and Benjamin had entered into a dash-in pago agreement in which her vintage 10000 Rolex watch, which was taken by Benjamin for sale on commission, was applied to settle her indebtedness, and that she incurred expenses in defending what she termed a frivolous lawsuit. She accordingly prayed for 50,000 damages. Benjamin soon after moved for the dismissal of the case. The trial court accordingly dismissed the complaint. And it also dismissed the counterclaim. Mercedes moved for a reconsideration of the dismissal of the counterclaim. Pass upon Mercedes' motion. Answer: Mercedes' motion for reconsideration is impressed with merit. The trial court should not have dismissed her counterclaim despite the dismissal of the complaint. Since it was the plaintiff, Benjamin, who moved for the dismissal of his complaint, and at a time when the defendant, Mercedes, had already filed her answer thereto and with counterclaim, the dismissal of the complaint should not carry with it the dismissal of the counterclaim without the conformity of the defendant counterclaimant. The revised Rules of Court provides in Rule 15, Section 2 thereof that if a counterclaim has been pleaded by a defendant prior to the service upon him of the plaintiff's motion for dismissal, the dismissal shall be limited to the complaint. The dismissal shall be without prejudice to the right of the defendant to prosecute his counterclaim. B. Suppose there was no counterclaim and Benjamin's complaint was not dismissed, and judgment was rendered against Mercedes for 100,000. The judgment became final and executory and a writ of execution was correspondingly issued. Since Mercedes did not have cash to settle the judgment debt, she offered her Toyota Camry Model 2008 valued at $1.2 million. The sheriff, however, on request of Benjamin, seized Mercedes' 17th-century ivory image of the La Sagrada Familia estimated to be worth over $100,000. Was the sheriff's action in order? 2010 bar. Answer: No, the sheriff's action was not in order. He should not have listened to Benjamin, the judgment obligee, creditor, in levying on the properties of Mercedes, the judgment obligor, debtor. The option to immediately choose which property or part thereof may be levied upon, sufficient to satisfy the judgment, is vested by law, Rule 39, Section 9b, upon the judgment obligor, Mercedes, not upon the judgment obligee, Benjamin, in this case. Only if the judgment obligor does not exercise the option is the sheriff authorized to levy on personal properties if any, and then on the real properties if the personal properties are insufficient to answer for the judgment. Question: The plaintiff sued the defendant in the RTC for the damage allegedly caused by the latter's encroachment on the plaintiff's lot. In his answer, the defendant denied the plaintiff's claim and alleged that it was the plaintiff who in fact had encroached on his, defendant's, land. Accordingly, the defendant counterclaimed against the plaintiff for damages resulting from the alleged encroachment on his lot. The plaintiff filed an ex parte motion for extension of time to answer the defendant's counterclaim, but the court denied the motion on the ground that it should have been set for hearing. On the defendant's motion, therefore, the court declared the plaintiff in default on the counterclaim. Was the plaintiff validly declared in default? Why? 2002 bar. Answer: No, the plaintiff was not validly declared in default. A motion for extension of time may be filed ex parte and need not be set for hearing. Amonte v. Sungo, General Register No. L 40491, May 28, 1975. Question: PX filed a suit for damages against the. In his answer, the incorporated a counterclaim for damages against PX and AC, counsel for plaintiff in said suit, alleging in said counterclaim, inter alia, that AC, as such counsel, maliciously induced PX to bring the suit against D despite AC's knowledge of its utter lack of factual and legal basis. In due time, AC filed a motion to dismiss the counterclaim as against him on the ground that he is not a proper party to the case, he being merely plaintiff's counsel. Is the counterclaim of D compulsory or not? Should AC's motion to dismiss the counterclaim be granted or not? Reason. 2004 bar. Answer, yes. The counterclaim of D is compulsory because it is one which arises out of or is connected with the subject matter of the opposing party's claim and does not require for its adjudication the presence of third parties of whom the court cannot acquire jurisdiction. Section 7, Rule 6. The motion to dismiss of plaintiff's counsel should not be granted because bringing in plaintiff's counsel as a defendant in the counterclaim is authorized by the rules. Where it is required for the grant of complete relief in the determination of the counterclaim, the court shall order the defendant's counsel to be brought in since jurisdiction over him can be obtained. Section 12, Rule 6, Aurelio v. Court of Appeals, General Register No. 90742, May 6, 1991. Here, the counterclaim was against both the plaintiff and his lawyer who allegedly maliciously induced the plaintiff to file the suit. Question: B and C borrowed 400,000.00 from A. The promissory note was executed by B and C in a joint and several capacity. B, who received the money from A, gave C 200,000 pesos. C, in turn, loaned 100,000 out of the 200,000 he received to D. A. In an action filed by A against B and C with the RTC of Quezon City, can B file a cross-claim against C for the amount of 200,000? Answer: yes. B can file a cross-claim against C for the amount of 200,000 given to C. A cross-claim is a claim filed by one party against a co-party arising out of the transaction or occurrence that is the subject matter of the original action or counterclaim therein and may include a claim that the party against whom it is asserted is or may be liable to the cross-claimant for all or part of a claim asserted against the cross-claimant. Section 8, Rule 6. B. Can C file a third-party complaint against D for the amount of 100,000? 1997 bar. Answer: Number C cannot file a third-party complaint against D because the loan of 100,000 has no connection with the opponent's claim. C could have loaned the money out of other funds in his possession. Question: JK's real property is being attached by the sheriff in a civil action for damages against LM. JK claims that he is not a party to the case, that his property is not involved in said case, and that he is the sole registered owner of said property. Under the rules of court, what must JK do to prevent the sheriff from attaching his property? 2000 bar. Answer: if the real property is being attached, the remedy is to file a third-party claim. The third-party claimant should make an affidavit of his title to the property attached, stating the grounds of his title thereto, and serve such affidavit upon the sheriff while the latter has possession of the attached property, and a copy thereof upon the attaching party. Section 14, Rule 57. The third-party claimant may also intervene or file a separate action to vindicate his claim to the property involved and secure the necessary reliefs, such as preliminary injunction, which will not be considered as interference with a court of coordinate jurisdiction. Ong vs. Tating, General Register No. L61042, April 15, 1987. Question: A obtained a money judgment against B after the finality of the decision, the court issued a writ of execution for the enforcement thereof. Conformably with the said writ, the sheriff levied upon certain properties under B's name. C filed a third-party claim over said properties claiming that B had already transferred the same to him. A moved to deny the third-party claim and to hold B and C jointly and severally liable to him for the money judgment alleging that B had transferred said properties to C to defraud him. A. After due hearing, the court denied the third-party claim and rendered an amended decision declaring B and C jointly and severally liable to A for the money judgment. Is the ruling of the court correct? Explain. 2005 bar. Answer: Number C has not been properly impleaded as a party defendant. He cannot be held liable for the judgment against A without a trial. In fact, since no bond was filed by B, the sheriff is liable to C for damages. C can file a separate action to enforce his third-party claim. It is in that suit that B can raise the ground of fraud against C. However, the execution may proceed where there is a finding that the claim is fraudulent. Tonangan v. Sampson, General Register No. 140889, May 9, 2002. Question: X files a complaint in the RTC for the recovery of a sum of money with damages against Y. Y files his answer denying liability under the contract of sale and praying for the dismissal of the complaint on the ground of lack of cause of action because the contract of sale was superseded by a contract of lease executed and signed by X and Y 2 weeks after the contract of sale was executed. The contract of lease was attached to the answer. X does not file a reply. What is the effect of non-filing of a reply? Explain. 2000 bar. Answer: A reply is generally optional. If it is not filed, the new matters alleged in the answer are deemed controverted. Section 10, Rule 6. However, since the contract of lease attached to the answer is the basis of the defense, by not filing a reply denying under oath the genuineness and due execution of said contract, the plaintiff is deemed to have admitted the genuineness and due execution thereof. Sections 7 and 8, Rule 8, Toribio v. Biden, General Register No. L 57821, January 17, 1985. Verification and certification against forum shopping. Question: What is forum shopping? 2006 bar. Answer: Forum shopping is the act of filing multiple suits involving the same parties for the same cause of action, either simultaneously or successively, for the purpose of obtaining a favorable judgment. Executive Secretary v. Gordon, General Register No. 134171, November 18, 1998. Question: Honey filed with the Regional Trial Court Al Batangas a complaint for specific performance against Bernie. For lack of certification against forum shopping, the judge dismissed the complaint. Honey's lawyer filed a motion for reconsideration, attaching thereto an amended complaint with the certification against forum shopping. If you were the judge, how will you resolve the motion? 2006 bar. Answer: If I were the judge, the motion should be denied after hearing because, as expressly provided in the rules, failure to comply with the requirement of forum shopping is not curable by mere amendment of the complaint or other initiatory pleading, but shall be cause for dismissal of the case, without prejudice, unless otherwise provided. Section 5, Rule 7. However, the trial court in the exercise of its sound discretion, may choose to be liberal and consider the amendment as substantial compliance. Great Southern Maritime Services Corporation v. Acuna, General Register No. 140189, February 28, 2005, Chan v. RTC of Zamboanga del Norte, General Register 149253, April 15, 2004, Uwe v. Land Bank, General Register 136100, July 24, 2000. Question: As counsel for A, B, C and D, Attorney Z prepared a complaint for recovery of possession of a parcel of land against Z. Before filing the complaint, Z discovered that his clients were not available to sign the certification of non-forum shopping. To avoid further delays in the filing of the complaint, Z signed the certification and immediately filed the complaint in court. Is Z justified in signing the certification? Why? 2000 bar. Answer: No, counsel cannot sign the anti-forum shopping certification because it must be executed by the plaintiff or principal party himself. Section 5, Rule 7. Since the rule requires personal knowledge by the party executing the certification, unless counsel gives a good reason why he is not able to secure his client's signatures and shows that his clients will be deprived of substantial justice. Ortiz v. Court of Appeals, General Register No. 127393, December 4, 1998, or unless he is authorized to sign it by his clients through a special power of attorney. Question: Mr. Humpty filed with the Regional Trial Court, RTC, a complaint against Ms. Humpty for damages. The RTC, after due proceedings, rendered a decision granting the complaint and ordering Ms. Humpty to pay damages to Mr. Humpty. Ms. Humpty timely filed an appeal before the Court of Appeals, CA, questioning the RTC decision. Meanwhile, the RTC granted Mr. Humpty's motion for execution pending appeal. Upon receipt of the RTC's order granting execution pending appeal, Ms. Humpty filed with the CA another case, this time a special civil action for certiorari assailing said RTC order. Is there a violation of the rule against forum shopping considering that two actions emanating from the same case with the RTC were filed by Ms. Humpty with the CA? Explain. 2014 Bar. Answer: There is no violation of the rule against forum shopping. The essence of forum shopping is the filing by a party against whom an adverse judgment has been rendered in one forum, seeking another and possibly favorable opinion in another suit other than by appeal or special civil action for certiorari, the act of filing of multiple suits involving the same parties for the same cause of action, either simultaneously or successively for the purpose of obtaining a favorable judgment. Forum shopping exists where the elements of litis pendentia are present or where a final judgment in one case will amount to res judicata in the action under consideration. Roberto S. Benedicto v. Manuel Laxon, General Register No. 141508, May 5, 2010. In Philippines, Nails and Wires Corporation v. Malayan Insurance Company Incorporated, General Register No. 143933, February 14, 2003, the Supreme Court held that one party may validly question a decision in a regular appeal and at the same time assail the execution pending appeal via certiorari without violating the rule against forum shopping. This is because the merits of the case will not be addressed in the petition dealing with the execution and vice versa. Since Ms. Humpty merely filed a special civil action for certiorari, the same will not constitute a violation of the rules on forum shopping because the resolution or favorable judgment thereon will not amount to res judicata in subsequent proceedings between the same parties. Roberto S. Benedicto v. Manuel Laxon, General Register No. 141508, May 5, 2010. Question: Taylor's Toto, Nelson and Yenine filed a special civil action for certiorari under Rule 65 from an adverse decision of the National Labor Relations Commission, NLRC, on the complaint for legal dismissal against Empire Textile Corporation. They were terminated on the ground that they failed to meet the prescribed production quota at least four times. The NLRC decision was assailed in a special civil action under Rule 65 before the Court of Appeals, CA. In the verification and certification against forum shopping, only Toto signed the verification and certification, while Attorney Arman signed for Nelson. Empire filed a motion to dismiss on the ground of defective verification and certification. Decide with reasons. 2016 Bar. Answer: the motion to dismiss should be granted. The verification and certification against non-forum shopping were not signed by all petitioners. There was no showing that Toto nor Attorney Arman were duly authorized by the other petitioners through a special power of attorney to sign on their behalf, hence, the motion to dismiss should be granted. Alternative answer: the motion to dismiss should be denied, because there is substantial compliance of the requirements of the rules. Verification is not a jurisdictional but merely a formal requirement which the court may motu proprio direct a party to comply with or correct, as the case may be. On the other hand, regarding the certificate of non-forum shopping, the general rule is that all the petitioners or plaintiffs in a case should sign it. However, the Supreme Court has time and again stressed that the rules on forum shopping, which were designed to promote the orderly administration of justice, do not interdict substantial compliance with its provisions under justifiable circumstances. As ruled by the court, the signature of any of the principal petitioners or principal parties would constitute a substantial compliance with the rule on verification and certification of non-forum shopping. And should there exist a commonality of interest among the parties, or where the parties filed the case as a collective, raising only one common cause of action or presenting a common defense, then the signature of one of the petitioners or complainants, acting as representative, is sufficient compliance. Irene Marco Cerdita v. Court of Appeals, General Register No. 154096, August 22, 2008. Evidently, since there is a commonality of interest among Taylor's Toto, Nelson, and Yanayan, there is substantial compliance with the rules on verification and certification against forum shopping, when Toto signed the verification and certification, and Attorney Arman signed the same for Nelson. Allegations in a pleading. Question. In his complaint for foreclosure of mortgage to which was duly attached a copy of the mortgage deed, plaintiff PP alleged inter alia as follows: 1. That defendant DD duly executed the mortgage deed, copy of which is Annex A of the complaint and made an integral part thereof, and 2. That to prosecute his complaint, plaintiff contracted a lawyer, CC, for a fee of $50,000. In his answer, the defendant alleged, inter alia, that he had no knowledge of the mortgage deed, and he also denied any liability for plaintiff's contracting with a lawyer for a fee. Does defendant's answer as to plaintiff's allegation number 1 as well as number 2 sufficiently raise an issue of fact? Reason briefly. 2004 bar. Answer. As to plaintiff's allegation number 1, defendant does not sufficiently raise an issue of fact, because he cannot allege lack of knowledge of the mortgage deed since he should have personal knowledge as to whether he signed it or not, and because he did not deny under oath the genuineness and due execution of the mortgage deed, which is an actionable document. As to plaintiff's allegation number 2, defendant did not properly deny liability as to plaintiff's contracting with a lawyer for a fee. He did not even deny for lack of knowledge, Section 10, Rule 8. Default. Question. When may a party be declared in default? What is the effect of an order of default? 1999 bar. Answer. A party may be declared in default when he fails to answer within the time allowed therefor and upon motion of the claiming party with notice to the defending party, and proof of such failure, Section 3, Rule 9. The effect of an order of default is that the court may proceed to render judgment granting the claimant such relief as his pleading may warrant unless the court in its discretion requires the claimant to submit evidence. The party in default cannot take part in the trial but shall be entitled to notice of subsequent proceedings, Section 3A, Rule 9. Question. Cersei filed with the RTC a complaint for the foreclosure of real estate mortgage against siblings Scylla and Charybdis, co-owners of the property and co-signatories to the mortgage deed. The siblings permanently reside in Athens, Greece. Cersei tipped off Sheriff Pluto that Scylla is on a Balikbayan trip and is billeted at the Century Plaza Hotel in Pasay City. Sheriff Pluto went to the hotel and personally served Scylla the summons, but the latter refused to receive summons for Charybdis as she was not authorized to do so. Sheriff Pluto requested Scylla for the email address and fax number of Charybdis, which the latter readily gave. Sheriff Pluto, in his return of the summons, stated that summons for Scylla was served personally as shown by her signature on the receiving copy of the summons. Summons on Charybdis was served pursuant to the amendment of Rule 14 by facsimile transmittal of the summons and complaint on defendant's fax number as evidenced by transmission verification report automatically generated by the fax machine indicating that it was received by the fax number to which it was sent on the date and time indicated therein. Cersei, 60 days after her receipt of Sheriff Pluto's return, filed a motion to declare Charybdis in default as Charybdis did not file any responsive pleading. A. Should the court declare Charybdis in default? Answer: no, the court should not declare Charybdis in default because there was no proper service of summons. Section 12, Rule 14 of the Rules of Court applies only to a foreign private juridical entity that is not registered in the Philippines and has no resident agent in the country, and not to individuals. AM number 1136 SC, March 15, 2011. The service of summons by facsimile under said rule is, therefore, defective. A foreclosure of real estate mortgage is a quasi-in rem action, thus, the court can render judgments as long as it has jurisdiction over the reason any of the modes of extraterritorial service of summons under Section 15 of Rule 14 is complied with prior leave of court. There is, unfortunately, no showing in the problem that a prior leave of court was obtained before resorting to extraterritorial service of summons, hence, the service of summons is defective. B. Scylla seasonably filed her answer setting forth therein as a defense that Charybdis had paid the mortgage debt. On the premise that Charybdis was properly declared in default, what is the effect of Scylla's answer to the complaint? 2015 bar. Answer: assuming that Charybdis was properly declared in default, the court shall try the case against all the defendants upon the answer filed by Scylla, and render judgment upon the evidence presented. Section 3C, Rule 9. Relief from an order of default. Question: Mario was declared in default but before judgment was rendered, he decided to file a motion to set aside the order of default. A. What should Mario state in his motion in order to justify the setting aside of the order of default? Answer: in order to justify the setting aside of the order of default, Mario should state in his motion that his failure to answer was due to fraud, accident, mistake or excusable negligence and that he has a meritorious defense. Section 3B Rule 9. B. In what form should such motion be? 2001 bar. Answer: the motion should be under oath, id. Question: for failure to seasonably file his answer despite due notice, A was declared in default in a case instituted against him by B. The following day, A's mistress, who is working as a clerk in the sala of the judge before whom his case pending, informed him of the declaration of default. On the same day, A presented a motion under oath to set aside the order of default on the ground that his failure to answer was due to fraud and he has a meritorious defense. Thereafter, he went abroad. After his return a week later, with the case still undecided, he received the order declaring him in default. The motion to set aside default was opposed by B on the ground that it was filed before A received notice of his having been declared in default, citing the rule that the motion to set aside may be made at any time after notice but before judgment. Resolve the motion. 1999 bar. Answer: assuming that the motion to set aside complies with the other requirements of the rule, it should be granted. Although such a motion may be made after notice but before judgment, Section 3B, Rule 9, with more reason may it be filed after discovery even before receipt of the order of default. Question: what are the available remedies of a party declared in default? A. Before the rendition of judgment. Answer: before the rendition of judgment, A. He may file a motion under oath to set aside the order of default on the grounds of fraud, accident, mistake or excusable negligence and that he has a meritorious defense. Section 3B, Rule 9, and if it is denied, he may move to reconsider, and if reconsideration is denied, he may file the special civil action of certiorari for grave abuse of discretion tantamount to lack or excess of the lower court's jurisdiction. Section 1, Rule 65, or, b. He may file a petition for certiorari if he has been illegally declared in default, for example during the pendency of his motion to dismiss or before the expiration of the time to answer. Matute v. Court of Appeals, General Register No. 26751, January 31, 1969, Acosta Ofelia v. Sundiem, General Register No. L 42648, September 30, 1978. b. After judgment but before its finality, and answer, after judgment but before its finality, he may file a motion for new trial on the grounds of fraud, accident, mistake, excusable negligence, or a motion for reconsideration on the ground of excessive damages, insufficient evidence or the decision or final order being contrary to law, c. 2, Rule 37, and thereafter. If the motion is denied, appeal is available under Rules 40 or 41, whichever is applicable. c. After the finality of judgment. 1998, 2006 Bar. Answer. After finality of the judgment, there are three ways to assail the judgment, which are, a petition for relief under Rule 38 on the grounds of fraud, accident, mistake or excusable negligence. B. Annulment of judgment under Rule 47 for extrinsic fraud or lack of jurisdiction, or, c. certiorari if the judgment is void on its face or by the judicial record. Balikat v. Justices of the Court of Appeals, General Register No. 83888, February 12, 1992. Question. For failure of KJ to file an answer within the reglementary period, the Court, upon motion of LM, declared KJ in default. In due time, KJ filed an unverified motion to lift the order of default without an affidavit of merit attached to it. KJ however attached the motion in his answer under oath, stating in said answer his reasons for his failure to file an answer on time, as well as his defenses. Will the motion to lift the order of default prosper? Explain. 2000 Bar. Answer. Yes, there is substantial compliance with the rule. Although the motion is unverified, the answer attached to the motion is verified. The answer contains the motion to lift the order of default and the affidavit of merit should contain, which are the reasons of the movant's failure to answer as well as his defenses. Section 3b, Rule 9, cf. Citibank, N.A. v. Court of Appeals, General Register No. 61508, March 17, 1999. Amendment. Question. Arturo lent $1 million to his friend Robert on the condition that Robert will execute a promissory note for the loan and a real estate mortgage over his property located in Tagtay City. Robert complied. In his promissory note dated September 20, 2006, Robert undertook to pay the loan within a year from its date at 12% per annum interest. In June 2007, Arturo requested Robert to pay ahead of time but the latter refused and insisted on the agreement. Arturo issued a demand letter and when Robert did not comply, Arturo filed an action to foreclose the mortgage. Robert moved to dismiss the complaint for lack of cause of action as the debt was not yet due. The resolution of the motion to dismiss was delayed because of the retirement of the judge. A. On October 1, 2007, pending resolution of the motion to dismiss, Arturo filed an amended complaint alleging that Robert's debt had in the meantime become due but that Robert still refused to pay. Should the amended complaint be allowed considering that no answer has been filed? Answer. Even though an amendment of complaint before answer is a matter of right, lack of a cause of action at the commencement of the suit is not cured by the accrual of a cause of action subsequent thereto, such that an amendment setting up the after-accrued cause of action is not allowed. Swagman Hotel and Travel Incorporated v. Court of Appeals, General Register Number 161135, April 8, 2005. B. Would your answer be different had Arturo filed instead a supplemental complaint stating that the debt became due after the filing of the original complaint? 2008 Bar. Answer: no, because a complaint whose cause of action has not accrued yet when filed, does not gain any standing in court such that no amendment, whether by amended or supplemental pleading, can cure the deficiency. The subsequent cause of action that arose may only be subject of a different suit but cannot be pleaded as a supplement to the complaint where no cause action exists. Simply put, no amended or supplemental complaint is allowed. Id. Question: on May 12, 2005, the plaintiff filed a complaint in the RTC of Quezon City for the collection of $250,000. The defendant filed a motion to dismiss the complaint on the ground that the court had no jurisdiction over the action since the claimed amount of $250,000 is within the exclusive jurisdiction of the Metropolitan Trial Court of Quezon City. Before the court could resolve the motion, the plaintiff, without leave of court, amended his complaint to allege a new cause of action consisting in the inclusion of an additional amount of 200,000.00 pesos, thereby increasing his total claim to 450,000.00 pesos. The plaintiff thereafter filed his opposition to the motion to dismiss, claiming that the RTC had jurisdiction over his action. Rule on the motion of the defendant with reasons. 2005 Bar. Answer: the motion to dismiss should be denied. Basic is the rule that a motion to dismiss is not a responsive pleading. Under the rules, a pleader may amend his pleading as a matter of right before the other party has served his responsive pleading. Section 2, Rule 10. The court, in allowing the amendment, would not be acting without jurisdiction because allowing an amendment as a matter of right does not require the exercise of discretion. Soledad v. Mamangan, General Register Number L 17983, May 30, 1963, Gomube v. Berlin, General Register Number L 30683, May 31, 1977, Prudence Realty v. C.A., General Register Number 110274, March 21, 1994. Question: after an answer has been filed, can the plaintiff amend his complaint, with leave of court, by changing entirely the nature of the action? 2003 Bar. Answer: yes. The present rules allow amendments substantially altering the nature of the cause of action. Section 3, Rule 10, Heirs of Marcelino Pagobo v. Court of Appeals, General Register Number 121687, October 16, 1997. This should only be true, however, when the substantial change or alteration in the cause of action or defense shall serve the higher interests of substantial justice and prevent delay and equally promote the laudable objective of the rules, which is to secure a just, speedy and inexpensive disposition of every action and proceeding. Valenzuela v. Court of Appeals, General Register Number 131175, August 28, 2001. Amendments to conform to or authorize presentation of evidence. Question: in a complaint for a sum of money filed before the MRTC, plaintiff did not mention or even just hint at any demand for payment made on defendant before commencing suit. During the trial, plaintiff duly offered Exhibit A in evidence for the stated purpose of proving the making of extrajudicial demand on defendant to pay 500,000, the subject of the suit. Exhibit A was a letter of demand for defendant to pay said sum of money within 10 days from receipt, addressed to and served on defendant some 2 months before suit was begun. Without objection from defendant, the court admitted Exhibit A in evidence. Was the court's admission of Exhibit A in evidence erroneous or not? Reason. 2004 Bar. Answer: the court's admission of Exhibit A in evidence is not erroneous. It was admitted in evidence without objection on the part of the defendant. It should be treated as if it had been raised in the pleadings. The complaint may be amended to conform to the evidence, but if it is not so amended, it does not affect the result of the trial on this issue. Section 5, Rule 10. Effect of amended pleading. Question: X, an illegitimate child of Y, celebrated her 18th birthday on May 2, 1996. A month before her birthday, Y died. The legitimate family of Y refused to recognize X as an illegitimate child of Y after countless efforts to convince them. X filed on April 25, 2000 an action for recognition against Z, wife of Y, after Z filed an answer on August 14, 2000. X filed a motion for leave to file an amended complaint and a motion to admit the said amended complaint and pleading the three legitimate children of Y. The trial court admitted the amended complaint on August 22, 2000. What is the effect of the admission of the amended complaint? Has the action of X prescribed? Explain. 2000 bar. Answer: Number: the action filed on April 25, 2000 is still within the 4-year prescriptive period which started to run on May 2, 1996. The amended complaint and pleading the three illegitimate children, though admitted on August 22, 2000 beyond the 4-year prescriptive period, retroacts to the date of the filing of the original complaint. Amendments and pleading new defendants retroact to the date of the filing of the complaint because they do not constitute a new cause of action. Verzusa vs. Court of Appeals, General Register Nos. 119,511-13, November 24, 1998. Summons. Question: What is the effect of absence of summons on the judgment rendered in the case? 1999 bar. Answer: The effect of the absence of summons on a judgment would make the judgment null and void because the court would not have jurisdiction over the person of the defendant, but if the defendant voluntarily appeared before the court, his appearance is equivalent to the service of summons. Section 20, Rule 14. Question: When additional defendant is impleaded in the action, is it necessary that summons be served upon him? Explain. 1999 bar. Answer: Yes. Summons must be served on an additional defendant impleaded in the action so that the court can acquire jurisdiction over him, unless he makes a voluntary appearance. Question: Is summons required to be served upon a defendant who is substituted for the deceased? Explain. 1999 bar. Answer: Number: a defendant who is substituted for the deceased need not be served with summons because it is the court which renders him as the legal representative of the deceased to appear and substitute the deceased. Section 16, Rule 3. Substituted service. Question: A suit 20 corporation, XXC, a corporation organized under Philippine laws, for specific performance when the latter failed to deliver T-shirts to the former as stipulated in their contract of sale. Summons was served on the corporation's cashier and director. Would you consider service of summons on either officer sufficient? Explain. 1999 bar. Answer: Summons on a domestic corporation through its cashier and director are not valid under the present rules. Section 11, Rule 14. Question: Summons was issued by the MRTC and actually received on time by defendant from his wife at their residence. The sheriff earlier that day had delivered the summons to her at said residence because defendant was not home at the time. The sheriff's return or proof of service filed with the court in some states that the summons, with attached copy of the complaint, was served on defendant at his residence through his wife, a person of suitable age and discretion then residing therein. Defendant moved to dismiss on the ground that the court had no jurisdiction over his person as there was no valid service of summons on him because the sheriff's return or proof of service does not show that the sheriff first made a genuine attempt to serve the summons on defendant personally before serving it through his wife. Is the motion to dismiss meritorious? What is the purpose of summons and by whom may it be served? Explain. 2004 bar. Answer: The motion to dismiss is not meritorious because the defendant actually received the summons on time from his wife. Service on the wife was sufficient. Boticano v. Chu, General Register No. L 58036, March 16, 1987. It is the duty of the court to look into the sufficiency of the service. The sheriff's negligence in not stating in his return that he first made a genuine effort to serve the summons on the defendant, should not prejudice the plaintiff. Mappa v. Court of Appeals, General Register Nos. 79,374 and 82,986, October 2, 1992. The purpose of the summons is to inform the defendant of the complaint filed against him and to enable the court to acquire jurisdiction over his person. It may be served by the sheriff or his deputy or any person authorized by the court. Question: Alfie Bravo filed with the Regional Trial Court of Caloocan a complaint for a sum of money against Charlie Delta. The claim is for Ph 1.5 million. The complaint alleges that Charlie borrowed the amount from Alfie and duly executed a promissory note as evidence of the loan. Charlie's office secretary, Esther, received the summons at Charlie's office. Charlie failed to file an answer within the required period, and Alfie moved to declare Charlie in default and to be allowed to present evidence ex parte. 10 days later, Charlie filed his verified answer, raising the defense of full payment with interest. 2006, 2013 bar. A. Was there proper and valid service of summons on Charlie? Answer: There is no showing that earnest efforts were exerted to personally serve the summons on the defendant before substituted service was resorted to. The service of summons was improper. In an action strictly in person and like a complaint for sum of money, personal service on the defendant is the preferred mode of service, that is, by handing a copy of the summons to the defendant in person. If defendant, for excusable reasons, cannot be served with summons within a reasonable period, then substituted service can be resorted to. Montauk v. Court of Appeals, General Register No. 130,974, August 16, 2006. Otherwise stated, it is only when the defendant cannot be served personally within a reasonable time that a substituted service may be made. Impossibility of prompt service should be shown by stating the efforts made to find the defendant personally and the fact that such efforts failed. This statement should be made in the proof of service. Gallery Public Act v. Math Agro Corporation, General Register No. 167,230, August 14, 2009. Since there was no prior attempt to serve the summons in person, the substituted service to Charlie's secretary is invalid. B. If declared in default, what can Charlie do to obtain relief? Answer: If Charlie is declared in default, he has the following remedies, to wit. A. He may, at any time after discovery of the default but before judgment, file a motion, under oath, to set aside the order of default on the ground that his failure to answer was due to fraud, accident, mistake or excusable neglect, and that he has a meritorious defense. B. If judgment has already been rendered when he discovered the default, but before the same has become final and executory, he may file a motion for new trial under Section 1A of Rule 37. C. If he discovered the default after the judgment has become final and executory, he may file a petition for relief under Section 2 of Rule 38, and D. He may also appeal from the judgment rendered against him as contrary to the evidence or to the law, even if no petition to set aside the order of default has been presented by him. B. DeLongspan Builders Incorporated v. R.S. Apeliquio Realty Development, General Register No. 169,919, September 11, 2009. Note: there are additional remedies to address judgments by default: motion for reconsideration, Rule 37, annulment of judgment, Rule 47, and petition for certiorari, Rule 65. Question: Juan sued Roberto for specific performance. Roberto knew that Juan was going to file the case, so he went out of town and temporarily stayed in another city to avoid service of summons. Juan engaged the service of Sheriff Matanik to serve the summons, but when the latter went to the residence of Roberto, he was told by the caretaker thereof that his employer no longer resides at the house. The caretaker is a high school graduate and is the godson of Roberto. Believing the caretaker's story to be true, Sheriff Matanik left a copy of the summons and complaint with the caretaker. Was there a valid substituted service of summons? Discuss the requirements for a valid service of summons. 2016 Bar. Answer: no, there was no valid substituted service of summons. In an action strictly in personam, personal service on the defendant is the preferred mode of service, that is, by handing a copy of the summons to the defendant in person. If defendant, for excusable reasons, cannot be served with the summons within a reasonable period, then substituted service can be resorted to. While substituted service of summons is permitted, it is extraordinary in character and in derogation of the usual method of service, hence, it must faithfully and strictly comply with the prescribed requirements and circumstances authorized by the rules. Compliance with the rules regarding the service of summons is as important as the issue of due process for the court to acquire jurisdiction. For the presumption of regularity and the performance of official duty to apply, the sheriff's return must show that serious efforts or attempts were exerted to personally serve the summons and that said efforts failed. These facts must be specifically narrated in the return. It must clearly show that the substituted service must be made in person of suitable age and discretion living in the dwelling or residence of defendant, otherwise, the return is flawed and the presumption cannot be availed of. The Supreme Court laid down the requirements as follows. 1. Impossibility of prompt personal service, that is, the party relying on substituted service or the sheriff must show that defendant cannot be served promptly or there is impossibility of prompt service within a reasonable time. Reasonable time being so much time as is necessary under the circumstances for a reasonably prudent and diligent man to do, conveniently, what the contract or duty requires that should be done, having a regard for the rights and possibility of loss, if any, to the other party. Moreover, it must be indicated therein that the sheriff has made several attempts at personal service for at least three times on at least two different dates. 2. Specific details in the return, that is, the sheriff must describe in the return of summons the facts and circumstances surrounding the attempted personal service. 3. Substituted service effected on a person of suitable age and discretion residing at defendant's house or residence, or on a competent person in charge of defendant's office or regular place of business. Ma. Imelda M. Minitak vs. Court of Appeals, General Register No. 130974, August 16, 2006. Question: Tristan filed a suit with the RTC of Pasay against Arthur King and or estate of Arthur King for reconveyance of a lot declared in the name of Arthur King under TCT No. 1234. The complaint alleged that on account Arthur King's residence abroad up to the present and the uncertainty of whether he is still alive or dead, he or his estate may be served with summons by publication. Summons was published and nobody filed any responsive pleading within 60 days therefrom. Upon motion, defendants were declared in default and judgment was rendered declaring Tristan as legal owner and ordering defendants to reconvey said lot to Tristan. Jojo, the court-designated administrator of Arthur King's estate, filed a petition for annulment of judgment before the CA praying that the decision in favor of Tristan be declared null and void for lack of jurisdiction. He claims that the action filed by Tristan is an action in personam and that the court did not acquire jurisdiction over defendants Arthur King and or his estate. On the other hand, Tristan claims that the suit is an action in rem or at least an action quasi in rem. Is the RTC judge correct in ordering service of summons by publication? Explain. 2016 Bar. Answer: yes. The RTC judge is correct in ordering the service of summons by publication. An action for declaration of nullity of title and recovery of ownership of real property, or reconveyance, is not a real action, but it is an action in personam, for it binds a particular individual only although it concerns the right to a tangible thing. Any judgment therein is binding only upon the parties properly impleaded. Heirs of Eugenio Lopez, Sr. vs. Enriquez cited in Emerita Munoz vs. Attorney Victoriano Ariabot Jr. and Samuel Gochan, General Register No. 142676, June 6, 2011. In an action in personam, jurisdiction over the person of the defendant is necessary for the court to validly try and decide the case. Jurisdiction over the person of a resident defendant who does not voluntarily appear in court can be acquired by personal service of summons as provided under Section 7, Rule 14 of the Rules of Court. If he cannot be personally served with summons within a reasonable time, substituted service may be made in accordance with Section 8 of said rule. Spouses Domingo M. Bellin, et al., versus Honorable Pablo R. Chavez, et al., General Register No. 175334, March 26, 2008. Under Section 14, Rule 14, Rules of Court, in any action where the defendant is designated as an unknown owner, or the like, or whenever his whereabouts are unknown and cannot be ascertained by diligent inquiry, service may, by leave of court, be effected upon him by publication in a newspaper of general circulation and in such places and for such time as the court may order. This rule applies to any action, whether in personam, in rem or quasi in rem. Pedro T. Santos, Jr., vs. PNOC Exploration Corporation, General Register No. 170943. September 23, 2008. Clearly, since the action for reconveyance is an action in personam, the RTC judge is correct in ordering service of summons by publication. Alternative answer: number the RTC judge is not correct in ordering service of summons by publication. It is well settled that an action in personam wherein the defendant is a non-resident who does not voluntarily submit himself to the authority of the court, personal service of summons within the state is essential to the acquisition of jurisdiction over her person. This method of service is possible if such defendant is physically present in the country. If he is not found therein, the court cannot acquire jurisdiction over his person and therefore cannot validly try and decide the case against him. Spouses Domingo M. Bellin, et al., versus Honorable Pablo R. Chavez, et al., General Register No. 175334, March 26, 2008. Accordingly, the RTC judge is not correct in ordering service of summons by publication. Motions. Omnibus Motion Rule. Question: Charis, alleging that she was a resident of Lapu-Lapu City, filed a complaint for damages against Atlanta Bank before the RTC of Lapu-Lapu City, following the dishonor of a check she drew in favor of Shirley against her current account which she maintained in the bank's local branch. The bank filed a motion to dismiss the complaint on the ground that it failed to state a cause of action, but it was denied. It thus filed an answer. A. In the course of the trial, Charis admitted that she was a U.S. citizen residing in Los Angeles, California, and that she was temporarily billeted at the Pescado Hotel in Lapu-Lapu City, drawing the bank to file another motion to dismiss, this time on the ground of improper venue, since Charis is not a resident of Lapu-Lapu City. Charis opposed the motion citing the Omnibus Motion Rule. Rule on the motion. Answer: the bank's second motion to dismiss, which is grounded on improper venue, should be denied. The improper venue of an action is deemed waived by the bank's filing an earlier motion to dismiss without raising improper venue as an issue, and more so when the bank filed an answer without raising improper venue as an issue after its first motion to dismiss was denied. Under the Omnibus Motion Rule, Rule 15, Section 8, which governs the bank's motion to dismiss, such motion should include all objections then available, otherwise, all objections not so included shall be deemed waived. B. Suppose chairist did not raise the Omnibus Motion Rule, can the judge proceed to resolve the motion to dismiss? Explain. Answer: yes, the judge can proceed to resolve the motion to dismiss, because the ground raised therefore became known to the movant only during the trial, such that it was only then that the objection became available to him. C. Suppose the judge correctly denied the second motion to dismiss and rendered judgment in favor of chairess, ordering the bank to pay her $100,000 in damages plus legal interest. The judgment became final and executory in 2008. To date, chairess has not moved to execute the judgment. The bank is concerned that its liability will increase with the delay because of the interest on the judgment award. As counsel of the bank, what move should you take? 2010 Bar. Answer: as counsel of the bank, I shall recommend to the bank as judgment obligor, to make a tender of payment to the judgment obliged and thereafter make a consignation of the amount due by filing an application therefore placing the same at the disposal of the court which rendered the judgment, Articles 1256 and 1258, and cc. Motions for Bill of Particulars. Question: when can a Bill of Particulars be availed of? What is the effect of non-compliance with the order of a Bill of Particulars? 2003 Bar. Answer: before responding to a pleading, a party may move for a Bill of Particulars of any matter which is not averred with sufficient definiteness or particularity to enable him properly to prepare his responsive pleading. If the pleading is a reply, the motion must be filed within 10 days from service thereof, Section 1, Rule 12. If the order is not complied with, the court may order the striking out of the pleading or the portions thereof to which the order was directed or make such other order as it deems just, Section 4, Rule 12. Question: within the period for filing a responsive pleading, the defendant filed a motion for Bill of Particulars that he set for hearing on a certain date. However, the defendant was surprised to find on the date set for hearing that the trial court had already denied the motion on the day of its filing, stating that the allegations of the complaint were sufficiently made. A. Did the judge gravely abuse his discretion in acting on the motion without waiting for the hearing set for the motion? Answer: no. The judge did not gravely abuse his discretion when he denied the motion for Bill of Particulars without waiting for the hearing set for the motion. Section 2, Rule 12 of the Rules of Court authorizes the court to either deny or grant said motion outright upon the clerk of court bringing such motion to the attention of the court. The motion may lack merit. B. If the judge grants the motion and orders the plaintiff to file and serve the Bill of Particulars, can the trial judge dismiss the case if the plaintiff does not comply with the order? 2008 Bar. Answer: yes, the trial judge can dismiss the case if the plaintiff failed to comply with the court's order to file and serve the needed Bill of Particulars. Section 4, Rule 12 of the Rules of Court authorizes the court to order the striking out of the pleading affected, hence the dismissal of the complaint. To the same end is the provision of Section 3, Rule 17 of the Rules when plaintiff fails to comply for no justifiable cause with any order of the court or with the rules. Res judicata. Question: what is res judicata in prison gray? What are the essential requisites of res judicata? 2010 Bar. Answer: res judicata in prison gray is the criminal concept of double jeopardy, as res judicata is the doctrine of civil law. Trinidad vs. Office of the Ombudsman, General Register No. 166038, December 4, 2007. Described as res judicata in prison gray, the right against double jeopardy prohibits the prosecution of a person for a crime of which he has been previously acquitted or convicted. The purpose is to set the effects of the first prosecution forever at rest, assuring the accused that he shall not thereafter be subjected to the danger and anxiety of a second charge against him for the same offense. Julbis vs. Intermediate Appellate Court, General Register Nos. 74,989-90, November 6, 1989. The essential requisites of res judicata are: 1. The judgment or order rendered must be final. 2. The court rendering the same must have jurisdiction of the subject matter and of the parties. 3. It must be a judgment or order on the merits, and 4. There must be between the two cases identity of parties, identity of subject matter, and identity of causes of action. San Diego vs. Cardona, General Register No. 46655, June 27, 1940. Question: distinguish bar by prior judgment from conclusiveness of judgment. 1997 Bar. Answer: bar by prior judgment is the doctrine of res judicata, which bars a second action when there is identity of parties, subject matter and cause of action. Section 47b, Rule 39. Conclusiveness of judgment precludes the relitigation of a particular issue in another action between the same parties on a different cause of action. Section 47c, Rule 39. Grounds. Question: Amarcelo, a Filipino citizen permanently residing in New York City, filed with the RTC of Lipa City a complaint for rescission of contract of sale of land against Brigido, a resident of Barangay San Miguel, So. Thomas, Batangas. The subject property, located in Barangay Talisay, Lipa City, has an assessed value of 19,700.00 pesos. Appended to the complaint is Amarcelo's verification and certification of non-forum shopping executed in New York City, duly notarized by Mr. Joseph Brown, Esquire, a notary public in the state of New York. Brigido filed a motion to dismiss the complaint on the following grounds. A. The court cannot acquire jurisdiction over the person of Amarcelo because he is not a resident of the Philippines. Answer: the first ground raised lacks merit because jurisdiction over the person of a plaintiff is acquired by the court upon the filing of plaintiff's complaint therewith. Residency or citizenship is not a requirement for filing a complaint, because plaintiff thereby submits to the jurisdiction of the court. B. The RTC does not have jurisdiction over the subject matter of the action involving real property with an assessed value of 19,700.00. Exclusive and original jurisdiction is with the municipal trial court where the defendant resides. Answer: the second ground raised is also without merit because the subject of the litigation, rescission of contract, is incapable of pecuniary estimation. The exclusive original jurisdiction to which is vested by law in the regional trial courts. The nature of the action renders the assessed value of the land involved irrelevant. C. The verification and certification of non-forum shopping are fatally defective because there is no accompanying certification issued by the Philippine consulate in New York, authenticating that Mr. Brown is duly authorized to notarize the document. 2009 Bar. Answer: the third ground raised questioning the validity of the verification and certification of non-forum shopping for lack of certification from the Philippine consulate in New York, authenticating that Mr. Brown is duly authorized to notarize the document, is likewise without merit. The required certification alluded to pertains to official acts, or records of official bodies, tribunals, and public officers, whether of the Philippines or of a foreign country. The requirement in Section 24, Rule 132 refers only to paragraph A of Section 29, which does not cover notarial documents. It is enough that the notary public who notarize the verification and certification of non-forum shopping is clothed with authority to administer oath in the state or foreign country. Question: Mariano, through his attorney in fact, Marcos, filed with the RTC of Baguio City a complaint for annulment of sale against Henry Marcos and Henry both reside in Asin Road, Baguio City, while Mariano resides in Davao City. Henry filed a motion to dismiss the complaint on the ground of prematurity for failure to comply with the mandatory barangay conciliation. Resolve the motion with reasons. 2009 Bar. Answer: the motion to dismiss should be denied because the parties in interest, Mariano and Henry, do not reside in the same city, municipality, or is the property subject of the controversy situated therein. The required conciliation, mediation before the proper barangay as mandated by the local government code governs only when the parties to the dispute reside in the same city or municipality, and if involving real property, as in this case, the property must be situated also in the same city or municipality. Question: AB, as mother and in her capacity as legal guardian of her illegitimate minor son, CD, brought action for support against F, as father of CD and AB's lawfully wedded husband. F filed his answer denying his paternity with counterclaim for damages. Subsequently, AB filed a manifestation in court that in view of the denial made by F, it would be futile to pursue the case against F. AB agreed to move for the dismissal of the complaint, subject to the condition that F will withdraw his counterclaim for damages. AB and F filed a joint motion to dismiss. The court dismissed the case with prejudice. Later on, minor son CD, represented by AB, filed another complaint for support against F. F filed a motion to dismiss on the ground of res judicata. Is res judicata a valid ground for dismissal of the second complaint? Explain your answer. 2000 Bar. Answer: no, res judicata is not a defense in an action for support even if the first case was dismissed with prejudice on a joint motion to dismiss. The plaintiff's mother agreed to the dismissal of the complaint for support in view of the defendant's answer denying his paternity with counterclaim for damages. This was in the nature of a compromise of the right to support which is prohibited by law, Art. 2035, and cc. De Asis vs. Court of Appeals, General Register No. 127578, February 15, 1999. Question: A resident of Lingayen, Pangasinan sued X, a resident of San Fernando La Union in the RTC of Quezon City for the collection of a debt of 1 million. X did not file a motion to dismiss for improper venue but filed his answer raising therein improper venue as an affirmative defense. He also filed a counterclaim for 80,000 against A for attorney's fees and expenses for litigation. X moved for a preliminary hearing on said affirmative defense. For his part, A filed a motion to dismiss the counterclaim for lack of jurisdiction. A. Rule on the affirmative defense of improper venue. Answer: there is improper venue. The case for a sum of money, which was filed in Quezon City, is a personal action. It must be filed in the residence of either the plaintiff, which is in Pangasinan, or the defendant, which is in San Fernando, La Union. Sec. 2, Rule 4. The fact that it was not raised in a motion to dismiss does not matter because the rule that if improper venue is not raised in a motion to dismiss it is deemed waived was removed from the 1997 Rules of Civil Procedure. The new rules provide that if no motion to dismiss has been filed, any of the grounds for dismissal may be pleaded as an affirmative defense in the answer. Sec. 6, Rule 16. B. Rule on the motion to dismiss the counterclaim on the ground of lack of jurisdiction over the subject matter. 1998 Bar. Answer: the motion to dismiss on the ground of lack of jurisdiction over the subject matter should be denied. The counterclaim for attorney's fees and expenses of litigation is compulsory counterclaim because it necessarily arises out of and is connected with the complaint. In an original action before the RTC, the counterclaim may be considered compulsory regardless of the amount. Section 7, Rule 6. Question: Kobatong, a taipan, filed a civil action for damages with the Regional Trial Court, RTC, of Parañaque City against Jose Penduko, a news reporter of the Philippines Times, a newspaper of general circulation printed and published in Parañaque City. The complaint alleged, among others, that Jose Penduko wrote malicious and defamatory imputations against Cobatong, that Cobatong's business address is in Makati City, and that the libelous article was first printed and published in Parañaque City. The complaint prayed that Jose Penduko be held liable to pay 200,000 as moral damages, 150,000.00 pesos as exemplary damages, and 50,000.00 pesos as attorney's fees. Jose Penduko filed a motion to dismiss on the following grounds. The RTC is without jurisdiction because under the totality rule, the claim for damages in the amount of 350,000 fall within the exclusive original jurisdiction of the Metropolitan Trial Court, METC, of Parañaque City. The venue is improperly laid because what the complaint alleged is Cobatong's business address and not his residence address. Are the grounds invoked in the motion to dismiss proper? A. The RTC is without jurisdiction because under the totality rule, the claim for damages in the amount of 350,000 fall within the exclusive original jurisdiction of the Metropolitan Trial Court, METC, of Parañaque City. Answer: Number the ground invoked in the motion to dismiss is not proper. Under Article 360 of the RPC, the civil action for damages in cases of written defamation may be filed separately in the regional trial court where the libelous article was printed and first published, regardless of the amount of damages being claimed. B. The venue is improperly laid because what the complaint alleged is Cobatong's business address and not his residence address. 2014 Bar. Answer: The venue is properly laid. Under the law, the venue for the civil action involving written defamation shall be the place where the defamatory article was printed and first published. Art. 360, RPC. Since the defamatory article was printed and first published in Parañaque City, the venue of the action is properly laid. Hence, the dismissal of the complaint will only be proper if the complaint failed to allege the residence of the complainant or the place where the libelous article was printed and first published. Nakam vs. Stan, General Register No. 145022, September 23, 2005. Question: X was driving the dump truck of Y along Catlia Street in Sda. Maria, Bulacan. Due to his negligence, X hit and injured V, who was crossing the street. Lawyer L, who witnessed the incident, offered his legal services to versus V, who suffered physical injuries including a fractured wrist bone, underwent surgery to screw a metal plate to his wrist bone. On complaint of V, a criminal case for reckless imprudence resulting in serious physical injuries was filed against X before the Municipal Trial Court, MTC, of Sda. Maria. Attorney L, the private prosecutor, did not reserve the filing of a separate civil action. V subsequently filed a complaint for damages against X and Y before the Regional Trial Court of Pangasinan in Urdaneta where he resides. In his certification against Forum Shopping, V made no mention of the pendency of the criminal case in Sda. Maria. 2010. A. Is V guilty of forum shopping? Answer: No, V is not guilty of forum shopping because the case is Sda. Maria, Bulacan, is a criminal action filed in the name of the people of the Philippines, where civil liability arising from the crime is deemed also instituted therewith, whereas the case filed in Urdaneta, Pangasinan, is a civil action for quasi-delict in the name of V and against both X and Y for all damages caused by X and Y to V, which may be beyond the jurisdiction of MTC. Hence, the tests of forum shopping, which is res judicata or litis pendentia, do not obtain here. Moreover, substantive law, Art. 33, and CC, and Section 3, Rule 111, expressly authorize the filing such action for damages entirely separate and distinct from the criminal action. B. Instead of filing an answer, X and Y move to dismiss the complaint for damages on the ground of litis pendentia. Is the motion meritorious? Explain. Answer: no. The motion to dismiss based on alleged litis pendentia is without merit because there is no identity of parties and subject matter in the two cases. Besides, Art. 33 of the Civil Code and Rule 111, Section 3 of the Rules of Criminal Procedure authorize the separate civil action for damages arising from physical injuries to proceed independently. C. Suppose only X was named as defendant in the complaint for damages, may he move for the dismissal of the complaint for failure of V to implead Y as an indispensable party? Answer: no. X may not move for dismissal of the civil action for damages on the contention that Y is an indispensable party who should be impleaded. Y is not an indispensable party but only a necessary party. Besides, non-joinder and misjoinder of parties is not a ground for dismissal of actions. Section 11, Rule 3. D. X moved for the suspension of the proceedings in the criminal case to await the decision in the civil case. For his part, Y moved for the suspension of the civil case to await the decision in the criminal case. Which of them is correct? Explain. Answer: neither of them is correct. Both substantive law, Art. 33, and CC, and procedural law, Section 3, Rule 111, provide for the two actions to proceed independently of each other. Therefore, no suspension of action is authorized. E. Attorney L offered in the criminal cases affidavit respecting what he witnessed during the incident. X's lawyer wanted to cross-examine Attorney L who, however, objected on the ground of lawyer-client privilege. Rule on the objection. 2010 Bar. Answer: the objection should be overruled. Lawyer-client privilege is not involved here. The subject on which the counsel would be examined has been made public in the affidavit he offered and thus, no longer privileged, aside from the fact that it is in respect of what the counsel witnessed during the incident and not to the communication made by the client to him or the advice he gave thereon in his professional capacity. Remedies. Question: Mr. Avenger filed with a regional trial court, RTC, a complaint against Miss Bright for annulment of deed of sale and other documents. Miss Bright filed a motion to dismiss the complaint on the ground of lack of cause of action. Mr. Avenger filed in opposition to the motion to dismiss. State and discuss the appropriate remedies under each of the following situations. A. If the RTC grants Miss Bright's motion to dismiss and dismisses the complaint on the ground of lack of cause of action, what will be the remedies of Mr. Avenger? Answer: Mr. Avenger can choose any of the following remedies. 1. Mr. Avenger may file a motion for reconsideration. If denied, he could file an appeal to the Court of Appeals under Rule 41 since a dismissal based on lack of cause of action, under Rule 33, is appealable. 2. Mr. Avenger may file a motion for reconsideration. If the same is denied, he could file a petition for certiorari under Rule 65 because a dismissal based on failure to state a cause of action is considered without prejudice and therefore an interlocutory order which cannot be a subject of an appeal under Rule 41. 3. Mr. Avenger may file a motion for reconsideration. If the same is denied, he can simply refile the complaint because an order granting a motion to dismiss based on failure to state a cause of action is without prejudice to the filing of another complaint. Section 5, Rule 16. 4. Mr. Avenger may amend his complaint, as a matter of right, since a motion to dismiss is not a responsive pleading. Irene R. Marcos Ernita vs. Court of Appeals, General Register No. 154096, August 22, 2008. B. If the RTC denies Miss Bright's motion to dismiss, What will be her remedies? Answer. 1. Miss Bright may file a motion for reconsideration. If the same is denied, she could file a special civil action for certiorari under Rule 65. An order denying a motion to dismiss is interlocutory because it does not finally dispose of the case, and, in effect, directs the case to proceed until final adjudication by the court. Hence, a special civil action on certiorari is the appropriate remedy. Section 1, Rule 41, Marmo vs. Inake, General Register No. 182585, November 27, 2009. 2. Miss Bright may file an answer within the balance of the period from the filing of his motion to dismiss but not less than 5 days, and raise affirmative defenses therein. Section 4 and 6, Rule 16. C. If the RTC denies Miss Bright's motion to dismiss and, further proceedings, including trial on the merits, are conducted until the RTC renders a decision in favor of Mr. Avenger, what will be the remedies of Miss Bright? 2014 Bar. Answer. Miss Bright may avail of the following remedies before the finality of the decision. 1. A motion for reconsideration, Sec. 1, Rule 37. 2. A motion for new trial, Section 1, Rule 37, and 3. Appeal, Rules 40, 41, 42, 43 and 45. After the finality of the decision, Miss Bright can avail of the following. 1. Petition for relief, Rule 38. 2. Annulment of judgment, Rule 47, and 3. Petition for certiorari, Rule 65. Dismissal of actions. Question. Ben sold a parcel of land to Dell with right to repurchase within 1 year. Ben remained in possession of the property. When Ben failed to repurchase the same, title was consolidated in favor of Dell. Despite demand, Ben refused to vacate the land, constraining Dell to file a complaint for unlawful detainer. In his defense, Ben averred that the case should be dismissed because Dell had never been in possession of the property. Is Ben correct? 2008 Bar. Answer. Number Ben is not correct. In an action for unlawful detainer, it is not required that the plaintiff be in prior physical possession of a land subject of the action. In this action by the vendee retro against a vendor retro who refused to vacate the property even after title has been consolidated in the vendee, the latter, in contemplation of law, steps into the shoes of the vendor and succeeds to his rights and interest. Pharma Industries Incorporated vs. Honorable Pajariga, General Register No. L53788, October 17, 1980. Mananan vs. Court of Appeals, General Register No. 121719, September 16, 1999. Pretrial. Question. Upon termination of the pretrial, the judge dictated the pretrial order in the presence of the parties and their counsel, reciting what had transpired and defining three issues to be tried. A. If, immediately upon receipt of his copy of the pretrial order, plaintiff's counsel should move for its amendment to include a fourth, tribal issue which he allegedly inadvertently failed to mention when the judge dictated the order. Should the motion to amend be granted? Reasons. Answer. Depending on the merit of the issue sought to be brought in by the amendment, the motion to amend may be granted upon due hearing. It is a policy of the rules of court that parties should be afforded reasonable opportunity to bring about a complete determination of the controversy between them, consistent with substantial justice. With this end in view, the amendment before trial may be granted to prevent manifest injustice. The matter is addressed to the sound and judicious discretion of the trial court. B. Suppose trial had already commenced and after the plaintiff's second witness had testified, the defendant's counsel moves for the amendment of the pretrial order to include a fifth, Fifth, tribal issue vital to his client's defense. Should the motion be granted over the objection of plaintiff's counsel? Reasons. 2009 bar. Answer: the motion may be denied since trial had already commenced and two witnesses for the plaintiff had already testified. Courts are required to issue pretrial order after the pretrial conference has been terminated and before trial begins, precisely because the reason for such order is to define the course of the action during the trial. Where trial had already commenced, more so the adverse party had already presented witnesses, to allow an amendment would be unfair to the party who had already presented his witnesses. The amendment would simply render nugatory the reason for or purpose for the pretrial order. Section 7, Rule 18 non-pretrial and civil action is explicit in allowing a modification of the pretrial order before trial begins to prevent manifest injustice. Distinction between pretrial and civil case and pretrial and criminal case. Question: give three distinctions between a pretrial and a criminal case and a pretrial and a civil case. 1997 bar. Answer: three distinctions between a pretrial and a criminal case and a pretrial and a civil case are as follows. 1. The pretrial in a criminal case is conducted only where the accused and counsel agree, Rule 118, Section 1, while the pretrial in a civil case is mandatory, Section 1 of former Rule 20, Section 1 of new Rule 18. 2. The pretrial in a criminal case does not consider the possibility of a compromise, which is one important aspect of the pretrial in a civil case, Section 1 of former Rule 20, Section 2 of new Rule 18. 3. In a criminal case, a pretrial agreement is required to be reduced to writing and signed by the accused and his counsel, see Rule 118, Section 4, while in a civil case, the agreement may be contained in the pretrial order, Section 4 of former Rule 20, C7 of new Rule 78. Intervention. Question: what are the requisites for an intervention by a non-party in an action pending in court? 2000 bar. Answer: the requisites for intervention are: a. legal interest in the matter in controversy, or b. legal interest in the success of either of the parties, or c. legal interest against both, or d. so situated as to be adversely affected by a distribution or other disposition of property in the custody of the court or of an officer thereof. E. Intervention will not unduly delay or prejudice the adjudication of the rights of original parties. F. Intervenors' rights may not be fully protected in a separate proceeding, as seen as 2 versus Court of Appeals, General Register No. 107762, August 29, 1995, Section 1, Rule 19, Modes of Discovery. Question: describe briefly at least 5 modes of discovery under the Rules of Court. 2000 bar. Answer: 5 modes of discovery under the Rules of Court are: 1. Deposition. By leave of court after jurisdiction has been obtained over any defendant or over property which is the subject of the action, or without such leave after an answer has been served, the testimony of any person, whether a party or not, may be taken, at the instance of any party, by deposition upon oral examination or written interrogatories, Section 1, Rule 23. 2. Interrogatories to parties. Under the same conditions specified in Section 1 of Rule 23, any party shall file and serve upon any adverse party written interrogatories regarding material and relevant facts to be answered by the party served, Section 1. Rule 25. 3. Admission by adverse party. At any time after issues have been joined, a party may file and serve upon any other party a written request for the admission by the latter of the genuineness of any material and relevant document or of the truth of any material and relevant matter of fact, Section 1, Rule 26. 4. Production or inspection of documents or things. Upon motion of any party showing good cause therefore, a court may order any party to produce and permit the inspection and copying or photographing of any designated documents, etc., or order any party to permit entry upon designated land or property for inspecting, measuring, surveying, or photographing the property or any designated relevant object or operation thereon. Section 1, Rule 27. 5. Physical and mental examination of persons. In an action in which the mental or physical condition of a party is in controversy, the court in which the action is pending may in its discretion order him to submit to a physical or mental examination by a physician. Section 1, Rule 28. Written interrogatories to adverse party. Question. An heir, oppositor in a probate proceeding filed a motion to remove the administrator on the grounds of neglect of duties as administrator and absence from the country. On his part the heir, oppositor served written interrogatories to the administrator preparatory to presenting the latter as a witness. The administrator objected, insisting that the modes of discovery apply only to ordinary civil actions, not special proceedings. Rule on the matter. 2008 Bar. Answer. The administrator's contention that the modes of discovery apply only to ordinary civil action and not to special proceedings is not correct. Section 2, Rule 72 of the Rules of Court provides that, in the absence of special provisions, the rules provided for in ordinary civil action shall be, as far as practicable, applicable in special proceedings. There is no provision to the contrary that would preclude the application of the modes of discovery, specifically interrogatories to parties under Rule 25 of the Rules, to probate proceedings. Question. A tugboat owned by Speedy Port Service Incorporated, SPS, sank in Manila Bay while helping tow another vessel, drowning five of the crew in the resulting shipwreck. At the Maritime Board inquiry, the four survivors testified. SPS engaged attorney Ely to defend it against potential claims and to sue the company owning the other vessel for damages to the tug. Ely obtained signed statements from the survivors. He also interviewed other persons, in some instance making memoranda. The heirs of the five victims filed an action for damages against SPS. Plaintiff's counsel sent written interrogatories to Ely, asking whether statements of witnesses were obtained, if written, copies were to be furnished, if oral, the exact provisions were to be set forth in detail. Ely refused to comply, arguing that the documents and information asked are privileged communication. Is the contention tenable? Explain. 2008 Bar. Answer. Yes. The contention of counsel for SPS is tenable considering that he was acting in his professional capacity in bringing about the statement he obtained from witnesses and the memoranda he made. The notes, memoranda, and writings made by counsel in pursuance of his professional duty, form part of his private and confidential files in the cases handled by him, hence privileged. Air Philippines Corporation v. Pennzoil Incorporated. General Register No. 172835, December 13, 2007. Question. In an Admiralty case filed by A against Y Shipping Lines, whose principal offices are in Manila, in the RTC, Davao City, the court issued a subpoena duces tecum directing Y, the president of the shipping company, to appear and testify at the trial and to bring with him several documents. A. On what valid ground can Y refuse to comply with the subpoena duces tecum? Answer. Y can refuse to comply with the subpoena duces tecum on the ground that he resides more than 50, now 100, kilometers from the place where he is to testify, Section 9 of former Rule 23, Section 10 of new Rule 21. The witness can also refuse to comply with the subpoena duces tecum on the ground that the documents are not relevant and there was no tender of fees for 1 day's attendance and the kilometrage allowed by the rules. B. How can A take the testimony of Y and present the documents as exhibits other than through the subpoena from the RTC? 1997 bar. Answer: A can take the testimony of Y and present the documents as exhibits by taking his deposition through oral examination or written interrogatories. Rule 24, new Rule 23. He may also file a motion for the production or inspection of documents. Rule 27. Question. A. Briefly explain the procedure in interrogatories to parties under Rule 25 and state the effect of failure to serve in written interrogatories. B. Briefly explain the procedure on admission by adverse party under Rule 26 and the effect of failure to file and serve the request. 2016 bar. Answer. A. Procedure. 1. Any party desiring to elicit material and relevant facts from any adverse party shall file and serve upon the latter written interrogatories to be answered by the party served or, if the party served is a public or private corporation or a partnership or association, by any officer thereof competent to testify in its behalf. Section 1, Rule 25, Rules of Court. 2. The interrogatories shall be answered fully in writing and shall be signed and sworn to by the person making them. The party upon whom the interrogatories have been served shall file and serve a copy of the answers on the party submitting the interrogatories within 15 days after service thereof, unless the court on motion and for good cause shown, extends or shortens the time. Section 2, Rule 25, Rules of Court. 3. Objections to any interrogatories may be presented to the court within 10 days after service thereof, with notice as in case of a motion, and answers shall be deferred until the objections are resolved, which shall be at as early a time as is practicable. Section 3, Rule 25, Rules of Court. 4. Should a party fail to file and serve written interrogatories on an adverse party, he cannot compel the latter to give testimony in open court or to give deposition pending appeal, unless allowed by the court for good cause shown and to prevent failure of justice. Section 6, Rule 25, Rules of Court. Spouses Vicentea Fiugentia and Letitia Fiugentia, General Register No. 185145, February 5, 2014. B. Procedure. 1. At any time after issues have been joined, a party may file and serve upon any party a written request for the admission by the latter of the genuineness of any material and relevant document described in and exhibited with the request or of the truth of any material and relevant matter of fact set forth in the request. Copies of the documents shall be delivered with the request unless copies have already been furnished. Section 1, Rule 26, Rules of Court. 2. Each of the matters of which an admission is requested shall be deemed admitted unless, within a period designated in the request, which shall not be less than 15 days after service thereof, or within such further time as the court may allow on motion, the party to whom the request directed files and serves upon the party requesting the admission a sworn statement either denying specifically the matters of which an admission is requested or setting forth in detail the reasons why he cannot truthfully either admit or deny those matters. 3. Objections to any request for admission shall be submitted to the court by the party requested within the period for and prior to the filing of his sworn statement as contemplated in the preceding paragraph, and his compliance therewith shall be deferred until such obligations are resolved, which resolution shall be made as early as practicable. Section 2, Rule 26, Rules of Court. 4. Any admission made by a party pursuant to such request is for the purpose of the pending action only and shall not constitute an admission by him for any other purpose, nor may the same be used against him in any other proceeding. Section 3, Rule 26, Rules of Court. 5. Unless otherwise allowed by the court for good cause shown and to prevent a failure of justice, a party who fails to file and serve a request for admission on the adverse party of material and relevant facts at issue which are or ought to be, within the personal knowledge of the latter, shall not be permitted to present evidence on such facts. Section 5, Rule 26, Rules of Court. Production or inspection of documents or things. Question: Continental Chemical Corporation, CCC, filed a complaint for a sum of money against Barso Trading Corporation, BTC, for the latter's failure to pay for its purchases of industrial chemicals. In its answer, BTC contended that it refused to pay because CCC misrepresented that the products it sold belonged to a new line, when in fact they were identical with CCC's existing products. To substantiate its defense, BTC filed a motion to compel CCC to give a detailed list of the product's ingredients and chemical components, relying on the right to avail of the modes of discovery allowed under Rule 27. CCC objected, invoking confidentiality of the information sought by BTC. Resolve BTC's motion with reasons. 2009 Bar. Answer: I will deny the motion. The ingredients and chemical components of CCC's products are trade secrets within the contemplation of the law. Trade secrets may not be the subject of compulsory disclosure by reason of their confidential and privileged character. Otherwise, CCC would eventually be exposed to unwarranted business competition with others who may imitate and market the same kinds of products in violation of CCC's proprietary rights. Being privileged, the detailed list of ingredients and chemical components may not be the subject of mode of discovery under Rule 27, Section 1, which expressly makes privileged information an exception from its coverage. Air Philippines Corporation v. Pennzoil Incorporated, General Register No. 172835, December 13, 2007. Question: The plaintiff sued the defendant in the RTC to collect on a promissory note, the terms of which were stated in the complaint and a photocopy attached to the complaint as an annex. Before answering, the defendant filed a motion for an order directing the plaintiff to produce the original of the note so that the defendant could inspect it and verify his signature and the handwritten entries of the dates and amounts. A. Should the judge grant the defendant's motion for production and inspection of the original of the promissory note? Why? Answer: Yes, because upon motion of any party showing good cause, the court in which the action is pending may order any party to produce and permit the inspection of designated documents. Rule 27. The defendant has the right to inspect and verify the original of the promissory note so that he could intelligently prepare his answer. B. Assuming that an order for production and inspection was issued but the plaintiff failed to comply with it, how should the defendant plead to the alleged execution of the note? 2002 Bar. Answer: The defendant may file a motion to dismiss the complaint because of the refusal of the plaintiff to obey the order of the court for the production and inspection of the promissory note, Section 3C, Rule 29. Physical and mental examination of persons. Question: Ernie filed a petition for guardianship over the person and properties of his father, Ernesto. Upon receipt of the notice of hearing, Ernesto filed in opposition to the petition. Ernie, before the hearing of the petition, filed a motion to order Ernesto to submit himself for mental and physical examination, which the court granted. After Ernie's lawyer completed the presentation of evidence in support of the petition and the court's ruling on the formal offer of evidence, Ernesto's lawyer filed a demurrer to evidence. Ernie's lawyer objected on the ground that a demurrer to evidence is not proper in a special proceeding. If Ernesto defies the court's order directing him to submit to physical and mental examinations, can the court order his arrest? 2015 Bar. Answer: If the order for the conduct of physical and mental examination is issued as a mode of discovery and Ernesto defies the said order, the court cannot validly order his arrest. Section 3D, Rule 29. Demurrer to evidence. Question: X, a Makati-bound paying passenger of PBU, a public utility bus, died instantly on board the bus on account of the fatal head wounds he sustained as a result of the strong impact of the collision between the bus and a dump truck that happened while the bus was traveling on Edsa towards Makati. The foregoing facts, among others, were duly established on evidence in chief by the plaintiff Thai, sole heir of Ax, in Thai's action against the subject common carrier for breach of contract of carriage. After Thai had rested his case, the common carrier filed a demurrer to evidence, contending that plaintiff's evidence is insufficient because it did not show, 1. that defendant was negligent and, 2. that such negligence was the proximate cause of the collision. Should the court grant or deny defendant's demurrer to evidence? Reason briefly. 2004 bar. Answer. The court should not grant defendant's demurrer to evidence because the case is for breach of contract of carriage. Proof that the defendant was negligent and that such negligence was the proximate cause of the collision is not required. Articles 1170 and 2201, NCC, Mendoza v. Phil Airlines Inc., General Register No. L 3678. February 29, 1952, Bait Angus Transportation Company v. Kagimbal, General Register No. L 22985, January 24, 1968, Abeto v. Powell, General Register No. L 28692, July 30, 1982. Waiver of right to present evidence. Question. Carlos filed a complaint against Pedro in the RTC of Azamis City for the recovery of the ownership of a car. Pedro filed his answer within the reglementary period. After the pre-trial and actual trial, and after Carlos has completed the presentation of his evidence, Pedro moved for the dismissal of the complaint on the ground that under the facts proven and under the law applicable to the case, Carlos is not entitled to the ownership of a car. The RTC granted the motion for dismissal. Carlos appealed the order of dismissal and the appellate court reversed the order of the trial court. Thereafter, Pedro filed a motion with the RTC asking the latter to allow him to present his evidence. Carlos objected to the presentation of evidence by Pedro. Should the RTC grant Pedro's motion to present evidence his evidence? Why? 2001 bar. Answer. Pedro's motion should be denied. He can no longer present evidence. The rules provide that if a motion for dismissal is granted by the trial court but on appeal the order of dismissal is reversed, he shall be deemed to have waived the right to present evidence. Section 1, Rule 33. Demurrer to evidence in a civil case versus demurrer to evidence in a criminal case. Question. Compare the effects of denial of demurrer to evidence in a civil case with those of a denial of demurrer to evidence in a criminal case. 2003 bar. Answer. In a civil case, the defendant has the right to file a demurrer to evidence without leave of court. If his demurrer is denied, he has the right to present evidence. If his demurrer is granted and on appeal by the plaintiff, the appellate court reverses the order and renders judgment for the plaintiff, the defendant loses his right to present evidence. Rule 33. In a criminal case, the accused has to obtain leave of court to file a demurrer to evidence. If he obtains leave of court and his demurrer to evidence is denied, he has the right to present evidence in his defense. If his demurrer to evidence is granted, he is acquitted and the prosecution cannot appeal. If the accused does not obtain leave of court and his demurrer to evidence is denied, he waives his right to present evidence and the case is decided on the basis of the evidence for the prosecution. The court may also dismiss the action on the ground of insufficiency of the evidence on its own initiative after giving the prosecution the opportunity to be heard. Section 23, Rule 119. Question. Ernie filed a petition for guardianship over the person and properties of his father, Ernesto. Upon receipt of the notice of hearing, Ernesto filed in opposition to the petition. Ernie, before the hearing of the petition, filed a motion to order Ernesto to submit himself for mental and physical examination which the court granted. After Ernie's lawyer completed the presentation of evidence in support of the petition and the court's ruling on the formal offer of evidence, Ernesto's lawyer filed a demurrer to evidence. Ernie's lawyer objected on the ground that a demurrer to evidence is not proper in a special proceeding. Was Ernie's counsel's objection proper? 2015 bar. Answer: Number the rule on demurrer to evidence is applicable in special proceedings. Matute v. Court of Appeals, General Register No. 26751, January 31, 1969. Moreover, under Section 2, Rule 72 of the Rules of Court, in the absence of special rules, the rules provided for in ordinary action shall be applicable, as far as practicable, to special proceedings. Judgment and final orders. Question: What is the difference between a judgment and an opinion of the court? 2006 bar. Answer: The judgment or fallo is the final disposition of the court which is reflected in the dispositive portion of the decision, while the opinion of the court is contained in the body of the decision that serves as a guide or enlightenment to determine the ratio decidendi of the decision. Judgment on the pleadings. Question: What are the grounds for judgment on the pleadings? 1999 bar. Answer: The grounds for judgment on the pleadings are, a. Where an answer fails to tender an issue, or, b. Otherwise admits the material allegations of the adverse party's pleading, Section 1, Rule 34. Question: A's answer admits the material allegations of B's complaint. May the court motu proprio render judgment on the pleadings? Explain. 1999 bar. Answer: No, a motion must be filed by the adverse party, Section 1, Rule 34. The court cannot motu proprio render judgment on the pleadings. Question: A brought an action against her husband B for annulment of their marriage on the ground of psychological incapacity. B filed his answer to the complaint admitting all the allegations therein contained. May A move for judgment on the pleadings? Explain. 1999 bar. Answer: No, because even if B's answer to A's complaint annulment of their marriage admits all the allegations therein contained, the material facts alleged in the complaint must always be proved. Section 1, Rule 34. The court shall order the prosecutor to investigate whether or not a collusion between the parties exists, and if there is no collusion, to intervene for the state in order to see to it that the evidence submitted is not fabricated. Section 3E, Rule 9. Evidence must have to be presented in accordance with the requirements set down by the Supreme Court in Republic v. Court of Appeals and Valina, General Register No. 108763, February 13, 1997. Question: In a complaint for recovery of real property, the plaintiff averred, among others, that he is the owner of the said property by virtue of a deed of sale executed by the defendant in his favor. Copy of the deed of sale was appended to the complaint as annex thereof. In his unverified answer, the defendant denied the allegation concerning the sale of the property in question, as well as the appended deed of sale, for lack of knowledge or information sufficient to form a belied as to the truth thereof. Is it proper for the court to render judgment without trial? Explain. 2005 bar. Answer: Defendant cannot deny the sale of the property for lack of knowledge or information sufficient to form a belied as to the truth thereof. The answer amounts to an admission. The defendant must aver or state positively how it is that he is ignorant of the facts alleged. Philippines Advertising Counselors Incorporated v. Revilla, General Register No. L31869, August 8, 1973, Section 10, Rule 8. Moreover, the genuineness and due execution of the deed of sale can only be denied by the defendant under oath, and failure to do so is also an admission of the deed. Section 8, Rule 8. Hence, a judgment in the pleadings can be rendered by the court without need of a trial. Question: Plaintiff files a request for admission and serves the same on defendant who fails. within the time prescribed by the rules, to answer the request. Suppose the request for admission asked for the admission of the entire material allegations stated in the complaint. What should plaintiff do? 2012 Bar. Answer: the plaintiff should file a motion for judgment on the pleadings because the failure of the defendant to answer a request for admission results to an implied admission of all the matters which an admission is requested. Hence, a motion for judgment on the pleadings is the appropriate remedy where the defendant is deemed to have admitted matters contained in the request for admission by the plaintiff. Rule 34 in connection with Section 2, Rule 26. Question: plaintiff sued defendant for collection of $1 million based on the latter's promissory note. The complaint alleges, among others: 1. Defendant borrowed $1 million from plaintiff as evidenced by a duly executed promissory note. 2. The promissory note reads: Makati, Philippines. December 30, 2014. For value received from plaintiff, defendant promises to pay plaintiff $1 million, 12 months from the above indicated date without necessity of demand. Signed, Defendant. A copy of the promissory note is attached as Annex A. Defendant, in his verified answer, alleged among others: 1. Defendant specifically denies the allegation in paragraphs 1 and 2 of the complaint, the truth being defendant did not execute any promissory note in favor of plaintiff, or 2. Defendant has paid the $1 million claimed in the promissory note, Annex A of the complaint, as evidenced by an acknowledgment receipt duly executed by plaintiff on January 30, 2015 in Manila with his spouse signing as witness. A copy of the acknowledgment receipt is attached as Annex 1 hereof. Plaintiff filed a motion for judgment on the pleadings on the ground that defendant's answer failed to tender an issue as the allegations therein on his defenses are sham for being inconsistent, hence, no defense at all. Defendant filed an opposition claiming his answer tendered an issue. A. Is judgment on the pleadings proper? 2015 Bar. Answer: no, the judgment on the pleadings is not proper. Judgment on the pleading is proper only when the answer fails to tender an issue, or otherwise admits the material allegations of the adverse party's pleading, Section 1, Rule 34. When it appears, however, that not all the material allegations of the complaint were admitted in the answer, because some of them were either denied or disputed, and the defendant has set up certain special defenses which, if proven, would have the effect of nullifying plaintiff's main cause of action, judgment on the pleadings cannot be rendered. Philippine National Bank vs. Isner, General Register No. 17105, May 30, 2011. Clearly, since the defendant's verified answer specifically denied the execution of the promissory note, or raised the affirmative of payment, judgment on the pleading is not proper. Question: defendant filed a motion for summary judgment on the ground that there are no longer any triable genuine issues of facts. Should the court grant defendant's motion for summary judgment? 2015 Bar. Answer: no. The court should not grant the motion for summary judgment because the defense of payment is a genuine issue as to material fact that must be resolved by the court upon presentation of evidence. For a summary judgment to be proper, the movant must establish two requisites: a. There must be no genuine issue as to any material fact, except for the amount of damages, and b. The party presenting the motion for summary judgment must be entitled to a judgment as a matter of law. A genuine issue is an issue of fact which requires the presentation of evidence as distinguished from an issue which is sham, fictitious, contrived or a false claim. Relative thereto, when the facts pleaded by the parties are disputed or contested, proceedings for a summary judgment cannot take place of a trial. The evidence on record must be viewed in light most favorable to the party opposing the motion, who must be given the benefit of all favorable inferences as can reasonably be drawn from the evidence, Smart Communications vs. Aldecoa, General Register Number 166330, September 11, 2013. Summary Judgment vs. Judgment on the Pleadings. Question: Royal Bank, Royal, filed a complaint for a sum of money against Irvine and Jude before the RTC of Manila. The initiatory pleading averred that on February 14, 2010, Irvine obtained a loan from Royal in the amount of $1 million, as evidenced by promissory note number 007, PN, signed by Irvine. Jude signed a surety agreement binding herself as surety for the loan. Royal made a final demand on February 14, 2015 for Irvine and Jude, defendants, to pay, but the latter failed to pay. Royal prayed that defendants Irvine and Jude be ordered to pay the amount of $1 million plus interests. In their answer, Irvine admitted that he obtained the loan from Royal and signed the PN. Jude also admitted that she signed the surety agreement. Defendants pointed out that the PN did not provide the due date for payment, and that the loan has not yet matured as the maturity date was left blank to be agreed upon by the parties at a later date. Defendants filed a motion for a judgment on the pleadings on the ground that there is no genuine issue presented by the parties' submissions. Royal opposed the motion on the ground that the PN's maturity is an issue that must be threshed out during trial. A. Resolve the motion with reasons. B. Distinguish summary judgment and judgment on the pleadings. Answer. A. The motion for judgment on the pleadings should be denied. First, judgment on the pleadings is available to the plaintiff and not to the defendant. Second, judgment on the pleadings is proper only when the answer fails to tender any issue, that is, if it does not deny the material allegations in the complaint or admits said material allegations of the adverse party's pleadings by admitting the truthfulness thereof and or omitting to deal with them at all. Here, while the defendant's answer to the complaint practically admitted all the material allegations therein, it nevertheless asserts the affirmative defenses that the lay-on is not yet due. As issues obviously arise from these affirmative defenses, a judgment on the pleadings is clearly improper in this case. Besides, it should be emphasized that judgment on the pleadings is based exclusively upon the allegations appearing in the pleadings of the parties and the annexes, if any, without consideration of any evidence und. Henceforth, when it appears that not all the material allegations of the complaint were admitted in the answer, for some of them were either denied or disputed, and the defendant has set up certain special defenses which, if proven, would have the effect of nullifying the plaintiff's main cause of action, judgment on the pleadings cannot be rendered. Philippine National Bank vs. Mirlo B. Isner, General Register Number 171805. May 30, 2011. B. What distinguishes a judgment on the pleadings from a summary judgment is the presence of issues in the answer to the complaint. When the answer fails to tender any issue, that is, if it does not deny the material allegations in the complaint or admits said material allegations of the adverse party's pleading by admitting the truthfulness thereof and or omitting to deal with them at all, a judgment on the pleadings is appropriate. On the other hand, when the answer specifically denies the material averments of the complaint or asserts affirmative defenses, or in other words raises an issue, a summary judgment is proper provided that the issue raised is not genuine. A genuine issue means an issue of fact which calls for the presentation of evidence, as distinguished from an issue which is fictitious or contrived or which does not constitute a genuine issue for trial. Eugenio Basbas vs. Beatriz Asen and Roberto Sason Jr., General Register Number 172660, August 24, 2011. Post-judgment remedies. Motion for new trial or reconsideration. Question: The RTC rendered judgment against Street, a copy of which was received by his counsel on February 28, 2000. On March 10, 2000, Street, through counsel, filed a motion for reconsideration of the decision with notice to the clerk of court submitting the motion for the consideration of the court. On March 15, 2000, realizing that the motion lacked a notice of hearing, ST's counsel filed a supplemental pleading. Was the motion for reconsideration filed within the reglementary period? Explain. 2000 bar. Answer: yes, because the last day of filing a motion for reconsideration was March 15 if February had 28 days, or March 16 if February had 29 days. Although the original motion for reconsideration was defective because it lacked a notice of hearing, the defect was cured on time by its filing on March 15 of a supplemental hearing, provided that motion was set for hearing and served on the adverse party at least 3 days before the date of hearing. Section 4, Rule 15. Matters not appealable. Question: what is an interlocutory order? 2006 bar. Answer: an interlocutory order is an order which decides some point or matter between the commencement and end of the suit, but it is not the final decision on the whole controversy. It leaves something to be done by the court before the case is finally decided on the merits. Metropolitan Bank and Trust Company v. Court of Appeals, General Register No. 110147, April 17, 2001. Gallardo v. People, General Register No. 142030, April 21, 2005. Question: after defendant has served and filed his answer to plaintiff's complaint for damages before the proper RTC, plaintiff served and filed a motion, with supporting affidavits, for a summary judgment in his favor upon all of his claims. Defendant served and filed his opposition, with supporting affidavits, to the motion. After due hearing, the court issued an order: 1. Stating that the court has found no genuine issue as to any material fact and thus concluded that plaintiff is entitled to judgment in his favor as a matter of law except as to the amount of damages recoverable, and 2. Accordingly ordering that plaintiff shall have judgment summarily against defendant for such amount as may be found due plaintiff for damages, to be ascertained by trial on October 7, 2004, at 8:30 o'clock in the morning. May defendant properly take an appeal from said order? Or, may defendant properly challenge said order through a special civil action for certiorari? Reason: 2004 bar. Answer: no, plaintiff may not properly take an appeal from said order because partial summary judgments are interlocutory orders. There is still something to be done, which is the trial for the adjudication of damages. Province of Pangasinan v. Court of Appeals, General Register No. 104266, March 31, 1993, GVR Republic Act v. Court of Appeals, General Register No. L49017 and L49024, August 30, 1983. But the defendant may properly challenge said order through a special civil action for certiorari. Section 1, C, and last par. Rule 41. Modes of appeal. Question: what are the modes of appeal to the Supreme Court? 2002 bar. Answer: the modes of appeal to the Supreme Court are: a. Appeal by certiorari on pure questions of law under Rule 45 through a petition for review on certiorari, and b. Ordinary appeal in criminal cases through a notice of appeal from convictions imposing reclusion perpetua or life imprisonment, or where a lesser penalty is involved but for offenses committed on the same occasion or which arose out of the same occurrence that gave rise to the more serious offense. Section 3, Rule 122. Convictions imposing the death penalty are elevated through automatic review. Question: distinguish the two modes of appeal from the judgment of the Regional Trial Court to the Court of Appeals. 2009 bar. Answer: in cases decided by the regional trial courts in the exercise of their original jurisdiction, appeals to the Court of Appeals shall be ordinary appeal by filing written notice of appeal indicating the parties to the appeal, specifying the judgment, final order or part thereof appealed from, specifying the court to which the appeal is being taken, and stating the material dates showing the timeliness of the appeal. The notice of appeal shall be filed with the RTC which rendered the judgment appealed from, and copy thereof shall be served upon the adverse party within 15 days from notice of judgment or final order appealed from. But if the case admits of multiple appeals or is a special proceeding, a record on appeal is required aside from the written notice of appeal to perfect the appeal, in which case the period for appeal and notice upon the adverse party is not only 15 days but 30 days from notice of judgment or final order appealed from. The full amount of the appellate court docket fee and other lawful fees required must also be paid within the period for taking an appeal, to the clerk of the court which rendered the judgment or final order appealed from. Sections 4 and 5, Rule 41. The periods of 15 or 30 days above stated are non-extendable. In cases decided by the regional trial court in the exercise of its appellate jurisdiction, appeal to the Court of Appeals shall be by filing a verified petition for review with the Court of Appeals and furnishing the RTC and the adverse party with copy thereof, within 15 days from notice of judgment or final order appealed from. Within the same period for appeal, the docket fee and other lawful fees required with the deposit for cost should be paid. The 15-day period may be extended for 15 days and another 15 days for compelling reasons. Period of appeal. Question: Defendant X received an adverse decision of the RTC in an ordinary civil case on January 2, 2003. He filed a notice of appeal on January 10, 2003. On the other hand, Plaintiff A received the same decision on January 6, 2003 and, on January 19, 2003, filed a motion for reconsideration of the decision. On January 13, 2003, Defendant X filed a motion withdrawing his notice of appeal in order to file a motion for new trial which he attached. On January 2003, the court denied A's motion to withdraw notice of appeal. Plaintiff A received the order denying his motion for reconsideration on February 3, 2003 and filed his notice of appeal on February 5, 2003. The court denied due course to A's notice of appeal on the ground that the period to appeal already lapsed. A. Is the court's denial of X's motion to withdraw notice of appeal proper? Answer: No. The court's denial of X's motion to withdraw notice of appeal is not proper, because the period of appeal of X has not yet expired. From January 2, 2003 when X received a copy of the adverse decision up to January 13, 2003 when he filed his withdrawal of appeal and motion for new trial, only 10 days had elapsed and he had 15 days to do so. B. Is the court's denial of due course to A's appeal correct? 2003 bar. Answer: No. The court's denial of due course to A's appeal is not correct because the appeal was taken on time. From January 6, 2003 when he received a copy of the decision up to January 19, 2003 when he filed a motion for reconsideration, only 12 days had lapsed. Consequently, he had 3 days from receipt on February 2003 of the order denying his motion for reconsideration within which to appeal. He filed his notice of appeal February 5, 2003, or only 2 days later. Note: to standardize the appeal periods provided in the rules and to afford litigants fair opportunity to appeal their cases, the court deems it practical to allow a fresh period of 15 days within which to file the notice of appeal in the RTC, counted from receipt of the order dismissing a motion for a new trial or motion for reconsideration, Nyapset.al. versus Court of Appeals, General Register Number 121524, September 14, 2005. Question: 30 received a copy of the RTC decision on June 9, 1999, ye received it on the next day, June 10, 1999. 30 filed a notice of appeal on June 15, 1999. The parties entered into a compromise on June 16, 1999. On June 13, 1999, Yi, who did not appeal, filed with the RTC a motion for approval of the compromise agreement. 30 changed his mind and opposed the motion on the ground that the RTC has no more jurisdiction. Rule on the motion assuming that the records have not yet been forwarded to the CA. 1999 bar. Answer: the contention of 30 that the RTC has no more jurisdiction over the case is not correct because at the time that the motion to approve the compromise had been filed, the period of appeal of Yi had not yet expired, the records of the case had not yet been forwarded to the Court of Appeals. The rules provide that in appeals by notice of appeal, the court loses jurisdiction over the case upon the perfection of the appeals filed in due time and the expiration of the time to appeal of the other parties. Section 9, 3rd Par, Rule 41. The rules also provide that prior to the transmittal of the record, the court may, among others, approve compromises. Section 9, 5th Par, Rule 41. Perfection of appeal. Question: when is an appeal from the RTC to the Court of Appeals deemed perfected? 1999 bar. Answer: an appeal from the regional trial court to the Court of Appeals is deemed perfected as to the appellant upon the filing of a notice of appeal in the regional trial court in due time or within the reglementary period of appeal. An appeal by record on appeal is deemed perfected as to the appellant with respect to the subject matter thereof upon the approval of the record on appeal filed in due time. Section 9, Rule 4. Appeal from judgments or final orders of the MTC, appeal from judgments or final orders of the RTC, appeal from judgments or final orders of the CTA. Question: where and how will you appeal the following? A. An order of execution issued by the RTC. Answer: a petition for certiorari under Rule 65 before the Court of Appeals. B. Judgment of RTC denying a petition for writ of amparo. Answer: any party may appeal from the final judgment or order to the Supreme Court by way of a petition for review on certiorari under Rule 45 of the Rules of Court. The period of appeal shall be 5 working days from the date of notice of the adverse judgment, and the appeal may raise questions of fact or law or both. Section 19, Rule on the Writ of Amparo, AM number 07912 SC, September 25, 2007. C. Judgment of MTC on a land registration case based on its delegated jurisdiction. Answer: the appeal should be filed with the Court of Appeals by filing a notice of appeal within 15 days from notice of judgment or final order appealed from. Section 34, but as Pambansabalang 129, or the Judiciary Reorganization Act of 1980, as amended by Republic Act No. 7691, March 25, 1994. D. A decision of the Court of Tax Appeals 1st Division. 2012 bar. Answer: the decision of the Court of Tax Appeals Division may be appealed to the CTA and Bank. The decisions of the Court of Tax Appeals are no longer appealable to the Court of Appeals. Under the modified appeal procedure, the decision of a division of the CTA may be appealed to the CTA and Bank. The decision of the CTA and Bank may in turn be directly appealed to the Supreme Court by way of a petition for review on certiorari under Rule 45 on questions of law, Section 11, Republic Act 9282, March 30, 2004. Question: after receiving the adverse decision rendered against his client, the defendant, Attorney Sakat duly filed a notice of appeal. For his part, the plaintiff timely filed a motion for partial new trial to seek an increase in the monetary damages awarded. The RTC instead rendered an amended decision further reducing the monetary awards. Is it necessary for Attorney Sakat to file a second notice of appeal after receiving the amended decision? 2008 bar. Answer: yes, It is necessary for Attorney Sakat to file a second notice of appeal to the amended decision because a substantial change was made to the original decision when the monetary awards were reduced in the amended decision, and in effect the amended decision superseded the original decision. A new notice of appeal is required to comply with the required contents thereof in respect of the amended decision. Pacific Life Assurance Corporation v. Sisson, General Register No. 122839, November 20, 1998. Magdalena Estates Incorporated v. Calawag, General Register No. L16250, June 30, 1964. Question: On July 15, 2009, Attorney Manananggal was served copies of numerous unfavorable judgments and orders. On July 29, 2009, he filed motions for reconsideration which were denied. He received the notices of denial of the motions for reconsideration on October 2, 2009, a Friday. He immediately informed his clients who, in turn, uniformly instructed him to appeal. How, when and where should he pursue the appropriate remedy for each of the following? A. Judgment of a municipal trial court, MTC, pursuant to its delegated jurisdiction dismissing his client's application for land registration? Answer: by notice of appeal, within 15 days from notice of judgment or final order appealed from, to the Court of Appeals. B. Judgment of the Regional Trial Court, RTC, denying his client's petition for a writ of habeas data? Answer: by verified petition for review on certiorari under Rule 45, with the modification that appellant may raise questions of fact or law or both, within 5 work days from date of notice of the judgment or final order to the Supreme Court, Section 19, AM No. 08116 SC. C. Order of a family court denying his client's petition for habeas corpus in relation to custody of a minor child? Answer: by notice of appeal, within 48 hours from notice of judgment or final order to the Court of Appeals, Section 14, Republic Act No. 8369 in relation to Sec. 3, Rule 41. D. Order of the RTC denying his client's petition for certiorari questioning the Metropolitan Trial Courts, METC's, denial of a motion to suspend criminal proceedings. Answer: by notice of appeal, within 15 days from notice of the final order, to the Court of Appeals, Magistrato v. People, General Register No. 148072, July 7, 2007. E. Judgment of the First Division of the Court of Tax Appeals, CDA, affirming the RTC decision convicting his client for violation of the National Internal Revenue Code, 2009 bar. Answer: by petition for review filed with the Court of Tax Appeals, CDA, N-Bank, within 30 days from receipt of the decision or ruling in question, Section 9b, Rule 9, Revised Rules of Court of Tax Appeals. Relief from judgments, orders and other proceedings. Preliminary injunction pending proceedings. Question: Mike was renting an apartment unit in the building owned by Jonathan. When Mike failed to pay 6 months' rent, Jonathan filed an ejectment suit. The Municipal Trial Court, MTC, rendered judgment in favor of Jonathan, who then filed a motion for the issuance of a writ of execution. The MTC issued the writ. A. How can Mike stay the execution of the MTC judgment? Explain. Answer: writ of execution shall be issued if immediately upon motion, unless Mike, A, perfects his appeal to the RTC, B, files a sufficient supersedeas bond to pay the rents, damages and costs accruing up to the time of the judgment appealed from, and, C, deposits monthly with the RTC during the pendency of the appeal the amount of rent due from time to time, Section 19, Rule 70. B. Mike appealed to the Regional Trial Court, RTC, which affirmed the MTC decision. Mike then filed a petition for review with the Court of Appeals, CA. The CA dismissed the petition on the ground that the sheriff had already executed the MTC decision and had ejected Mike from the premises, thus rendering the appeal moot and academic. Is the CA correct? Reasons. 2009 bar. Answer: no, the Court of Appeals is not correct. The dismissal of the appeal is wrong, because the execution of the RTC judgment is only in respect of the eviction of the defendant from the leased premises. Such execution pending appeal has no effect on the merits of the ejectment suit, which still has to be resolved in the pending appeal. Section 21, Rule 70 of the Rules provides that the RTC judgment against the defendant shall be immediately executory, without prejudice to a further appeal that may be taken therefrom. UI v. Santiago, General Register No. 131237, July 31, 2000. Question: having obtained favorable judgment in his suit for a sum of money against Patricio, Orencio sought the issuance of a writ of execution. When the writ was issued, the sheriff levied upon a parcel of land that Patricio owns, and a date was set for the execution sale. A. How may Patricio prevent the sale of the property on execution? Answer: Patricio may file a petition for relief with preliminary injunction, Rule 38, posting a bond equivalent to the value of the property levied upon, or assail the levy as invalid if ground exists. Patricio may also simply pay the amount required by the writ and the costs incurred therewith. B. If Orencio is the purchaser of the property at the execution sale, how much does he have to pay? Explain. Answer: Orencio, the judgment creditor, should pay only the excess amount of the bid over the amount of the judgment, if the bid exceeds the amount of the judgment. C. If the property is sold to a third party at the execution sale, what can Patricio do to recover the property? Explain. 2009 bar. Answer: Patricio can exercise his right of legal redemption within 1 year from date of registration of the certificate of sale by paying the amount of the purchase price with interest of 1% monthly, plus assessment and taxes paid by the purchaser, with interest thereon, at the same rate. Question: a default judgment was rendered by the RTC ordering D to pay P a sum of money. The judgment became final, but D filed a petition for relief and obtained a writ of preliminary injunction staying the enforcement of the judgment. After hearing, the RTC dismissed D's petition, whereupon P immediately moved for the execution of the judgment in his favor. Should P's motion be granted? Why? 2002 bar. Answer: P's immediate motion for execution of the judgment in his favor should be granted because the dismissal of D's petition for relief also dissolves the writ of preliminary injunction staying the enforcement of the judgment, even if the dismissal is not yet final. Goles v. Leonidas, General Register No. L 56587, August 31, 1981. Question: after his properties were attached, defendant Porfirio filed a sufficient counter bond. The trial court discharged the attachment. Nonetheless, Porfirio suffered substantial prejudice due to the unwarranted attachment. In the end, the trial court rendered a judgment in Porfirio's favor by ordering the plaintiff to pay damages because the plaintiff was not entitled to the attachment. Porfirio moved to charge the plaintiff's attachment bond. The plaintiff and his sureties opposed the motion, claiming that the filing of the counter bond had relieved the plaintiff's attachment bond from all liability for the damages. Rule on Porfirio's motion. 2008 bar. Answer: Porfirio's motion to charge plaintiff's attachment bond is proper and can be granted. It is not correct to contend that Porfirio's filing of a counterbond constitutes a waiver of his right to proceed against the attachment bond for the damages he suffered from the unwarranted attachment. It is a condition inter alia of the applicant's attachment bond that he will pay all the costs which may be adjudged to the adverse party and all damages which the latter may sustain by reason of the attachment, if the court shall finally adjudge that the applicant was not entitled thereto. Section 4, Rule 57, DM Wenceslao and Associates Incorporated vs. Reedy Trading and Construction Corporation, General Register Number 154106, June 29, 2004. Time to file the petition. Question: May an order denying the probate of a will still be overturned after the period to appeal therefrom has lapsed? Why? 2002 bar. Answer: Yes, an order denying the probate of a will may be overturned after the period to appeal therefrom has lapsed. A petition for relief may be filed on the grounds of fraud, accident, mistake or excusable negligence within a period of 60 days after the petitioner learns of the judgment or final order and not more than 6 months after such judgment or final order was entered. Sections 1 and 3, Rule 38, Soriano v. Assit General Register Number L9633, January 29, 1957. An action for annulment may also be filed on the ground of extrinsic fraud within 4 years from its discovery, and if based on lack of jurisdiction, before it is barred by laches or estoppel. Sections 2 and 3, Rule 47. Annulment of judgments or final orders and resolutions. Grounds of annulment. Question: What are the grounds for the annulment of a judgment of the RTC? 1998 bar. Answer: The grounds for annulment of judgment of the Regional Trial Court are extrinsic fraud and lack of jurisdiction. Section 2, Rule 47. Question: Tom Wallace filed with the Regional Trial Court, RTC, a petition for declaration of nullity of his marriage with Debbie Wallace on the ground of psychological incapacity of the latter. Before filing the petition, Tom Wallace had told Debbie Wallace that he wanted the annulment of their marriage because he was already fed up with her irrational and eccentric behavior. However, in the petition for a declaration of nullity of marriage, the correct residential address of Debbie Wallace was deliberately not alleged and instead, the resident address of their married son was stated. Summons was served by substituted service at the address stated in the petition. For failure to file an answer, Debbie Wallace was declared in default and Tom Wallace presented evidence ex parte. The RTC rendered judgment declaring the marriage null and void on the ground of psychological incapacity of Debbie Wallace. 3 years after the RTC judgment was rendered, Debbie Wallace got hold of a copy thereof and wanted to have the RTC judgment reversed and set aside. If you are the lawyer of Debbie Wallace, what judicial remedy or remedies will you take? Discuss and specify the ground or grounds for said remedy or remedies. 2014 bar. Answer: Debbie Wallace may file a petition for annulment of judgment under Rule 47 of the Rules of Court, on the grounds of lack of jurisdiction, extrinsic fraud and denial of the right to due process. Letitia Diona v. Romeo Balange, General Register Number 173589, January 7, 2013. An action for annulment of judgment is a remedy in law independent of the case where the judgment sought to be annulled was rendered. The purpose of such action is to have the final and executory judgment set aside so that there will be a renewal of litigation. It is resorted to in cases where the ordinary remedies of new trial, appeal, petition for relief from judgment, or other appropriate remedies are no longer available through no fault of the appellant and is based on the grounds of extrinsic fraud, and lack of jurisdiction. Aliban v. Court of Appeals, General Register Number 156021, September 23, 2005. Relative thereto, the act of Tom Wallace in deliberately keeping Debbie Wallace away from the court, by intentionally alleging a wrong address in the complaint constitutes extrinsic fraud. Moreover, the failure of the court to acquire jurisdiction over the person of the respondent, being an indispensable party, necessitates the annulment of judgment of the Regional Trial Court. Likewise, there is denial of the right to due process when Debbie Wallace was not given an opportunity to be heard in the case. Hence, The judgment rendered by the RTC may be annulled by the Court of Appeals under Rule 47 of the Rules of Court. Moreover, it is evident that the ordinary remedies of new trial, petition for relief or other appropriate remedies are no longer available through no fault of Debbie Wallace because she was able to obtain a copy of the decision only three years after the same was rendered by the trial court. At any rate, the court heard in declaring the defendant in default because there is no default in a petition for declaration of nullity of marriage, Section 3, Rule 9. Thus, a petition for certiorari under Rule 65 of the Rules of Court could have been an appropriate remedy within the reglementary period allowed by the rules. Execution, satisfaction and effect of judgments. Question. A. The writ of execution was returned unsatisfied. The judgment obligee subsequently received information that a bank holds a substantial deposit belonging to the judgment obligor. If you are the counsel of the judgment obligee, what steps would you take to reach the deposit to satisfy the judgment? Answer. Since a writ of execution is valid for 5 years from its issuance, the sheriff should be informed and requested to garnish or levy on execution the bank deposits belonging to the judgment obligor, Section 9c, Rule 39. Then the judgment creditor move for a court order directing the application of such bank deposit to the satisfaction of the judgment, Section 40, Rule 39. B. If the bank denies holding the deposit in the name of the judgment obligor but your client's informant is certain that the deposit belongs to the judgment obligor under an assumed name, what is your remedy to reach the deposit? 2008 Bar. Answer. To reach the bank deposit belonging to the judgment obligor but under an assumed name, a motion may be filed for a court order requiring the proper bank officer to appear in court for examination under oath as to such bank deposit, and subsequently move for a court order authorizing the filing of an action against such bank for the recovery of the judgment obligor's deposit, interest therein, then to forbid a transfer or other disposition of such deposit, interest within 120 days from notice of the order, Sections 37 and 43, Rule 39. Question. A. A resident of Dagupan City secured a favorable judgment in an ejectment case against X, a resident of Quezon City, from the MTC of Manila. The judgment, entered on June 15, 1991, had not as yet been executed. A. In July 1996, A decided to enforce the judgment of the MTC of Manila. What is the procedure to be followed by A in enforcing the judgment? Answer. A can enforce the judgment by another action reviving the judgment because it can no longer be enforced by motion as the 5-year period within which a judgment may be enforced by motion has already expired. Section 6, Rule 39. B. With what court should A institute the proceedings? 1997 Bar. Answer. A may institute the proceedings in the regional trial court in accordance with the rules of venue because the enforcement of the judgment is a personal action incapable of pecuniary estimation. Question. The trial court rendered judgment ordering the defendant to pay the plaintiff moral and exemplary damages. The judgment was served on the plaintiff on October 1, 2001 and on the defendant on October 5, 2001. On October 8, 2001, the defendant filed a notice of appeal from the judgment, but the following day, October 9, 2001, the plaintiff moved for the execution of the judgment pending appeal. The trial court granted the motion upon the posting by the plaintiff of a bond to indemnify the defendant for damages it may suffer as a result of the execution. The court gave as a special reason for its order the imminent insolvency of the defendant. Is the order of execution pending appeal correct? Why? 2002 Bar. Answer. No, because awards for moral and exemplary damages cannot be the subject of execution pending appeal. The execution of any award for moral and exemplary damages is dependent on the outcome of the main case. Liabilities for moral and exemplary damages, as well as the exact amounts remain uncertain and indefinite pending resolution by the Court of Appeals or Supreme Court, RCPI v. Land, General Register Number L 59311, January 31, 1985, International School Incorporated v. Court of Appeals, General Register Number 131109, June 29, 1999. Question: Aldrin entered into a contract to sell with Neil over a parcel of land. The contract stipulated a $500,000 down payment upon signing and the balance payable in 12 monthly installments of PLOO,000.00 pesos. Aldrin paid the down payment and had paid three monthly installments when he found out that Neil had sold the same property to Yuri for PL.5 million paid in cash. Aldrin sued Neil for specific performance with damages with the RTC. Yuri, with leave of court, filed an answer in intervention as he had already obtained a TCT in his name. After trial, the court rendered judgment ordering Aldrin to pay all the installments due, the cancellation of Yuri's title, and Neil to execute a deed of sale in favor of Aldrin. When the judgment became final and executory, Aldrin paid Neil all the installments, but the latter refused to execute the deed of sale in favor of the former. Aldrin filed a petition for the issuance of a writ of execution with proper notice of hearing. The petition alleged, among others, that the decision had become final and executory and he is entitled to the issuance of the writ of execution as a matter of right. Neil filed a motion to dismiss the petition on the ground that it lacked the required certification against forum shopping. A. Should the court grant Neil's motion to dismiss? 2015 bar. Answer. The motion to dismiss should be denied because the certification against forum shopping is only required in a complaint or other initiatory pleading, Section 5, Rule 7, Arquiza v. Court of Appeals, General Register Number 160479, June 8, 2005. Since a petition for the issuance of the writ of execution is not an initiatory pleading, it does not require a certification against forum shopping. Question: Despite the issuance of the writ of execution directing Neil to execute the deed of sale in favor of Aldrin, the former obstinately refused to execute the deed. What is Aldrin's remedy? 2015 bar. Answer: Aldrin may move for the issuance of a court order directing the execution of the deed of sale by some other person appointed by it. Under Section 10, Rule 39 of the Rules of Court, if a judgment directs a party to execute a conveyance of land or personal property, or to deliver deeds, other documents, or to perform any other specific act in connection therewith, and the party fails to comply within the time specified, the court may direct the act to be done at the cost of the disobedient party by some other person appointed by the court, and the act when so done shall have like effect as if done by the party. If real or personal property is situated within the Philippines, the court in lieu of directing a conveyance thereof may by an order divest the title of any party invested in others, which shall have the force and effect of a conveyance executed in due form of law. The phrase "some other person appointed by the court" may refer to the branch clerk of court, sheriff, or even the register of deeds, and their acts when done under such authority shall have the effect of having been done by Neil himself. Examination of judgment obligor when judgment is unsatisfied. Question: The plaintiff, a Manila resident, sued the defendant, a resident of Manila's Bulacan, in the RTC, Manila for a sum of money. When the sheriff tried to serve the summons with a copy of the complaint on the defendant at his Bulacan residence, the sheriff was told that the defendant had gone to Manila for business and would not be back until the evening of that day. So, the sheriff served the summons, together with a copy of the complaint, on the defendant's 18-year-old daughter, who was a college student. For the defendant's failure to answer the complaint within the reglementary period, the trial court, on motion of the plaintiff, declared the defendant in default. A month later, the trial court rendered judgment holding the defendant liable for the entire amount paid for in the complaint. A. After the judgment had become final, a writ of execution was issued by the court. As the writ was returned unsatisfied, the plaintiff filed a motion for an order requiring the defendant to appear before it and to be examined regarding his property and income. How should the court resolve the motion? Answer: the RTC Manila should deny the motion because it is in violation of the rule that no judgment obligor shall be required to appear before a court, for the purpose of examination concerning his property and income, outside the province or city in which such obligor resides. In this case the judgment obligor resides in Bulacan, Section 36, Rule 39. B. 7 years after the entry of judgment, the plaintiff filed an action for its revival. Can the defendant successfully oppose the revival of the judgment by contending that it is null and void because the RTC Manila did not acquire jurisdiction over his person? Why? 2002 Bar. Answer: yes, because the sheriff did not exert sufficient effort to serve summons personally on the defendant within a reasonable time and hence the RTC Manila did not acquire jurisdiction over his person. Sections 6 and 7, Rule 14, De Guzman v. Court of Appeals, General Register No. 120941, April 18, 1997. Enforcement and effect of foreign judgments or final orders. Question: under Article 1144 of the new Civil Code, an action upon a judgment must be brought within 10 years from the time the right of action accrues. Is this provision applicable to an action filed in the Philippines to enforce a foreign judgment? Explain. 2005 Bar. Answer: Number Article 1144 of the Civil Code, which requires that an action upon a judgment, though without distinction, must be brought within 10 years from the time the right of action accrues, does not apply to an action filed in the Philippines to enforce a foreign judgment. While we can say that where the law does not distinguish, we should not distinguish, still the law does not evidently contemplate the inclusion of foreign judgments. A local judgment may be enforced by motion within 5 years and by action within the next 5 years, Rule 39. That is not the case with respect to foreign judgments which cannot be enforced by mere motion. Provisional remedies. Preliminary attachment. Question: the plaintiff obtained a writ of preliminary attachment upon a bond of 1 million. The writ was levied on the defendant's property, but it was discharged upon the posting by the defendant of a counterbond in the same amount of 1 million. After trial, the court rendered judgment finding that the plaintiff had no cause of action against the defendant and that he had sued out the writ of attachment maliciously. Accordingly, the court dismissed the complaint and ordered the plaintiff and its surety to pay jointly to the defendant 1.5 million as actual damages, P0.5 million as moral damages and P0.5 million as exemplary damages. Evaluate the soundness of the judgment from the point of view of procedure. 2002 Bar. Answer: the judgment against the surety is not sound if due notice was not given to him of the applicant for damages, Sec. 20, Rule 57. Moreover, the judgment against the surety cannot exceed the amount of its counterbond of 1 million. Question: in a case, the property of an incompetent under guardianship was in custodia legis. Can it be attached? Explain. 1999 Bar. Answer: although the property of an incompetent under guardianship is in custodia legis, it may be attached as in fact it is provided that in such case, a copy of the writ of attachment shall be filed with the proper court and notice of the attachment served upon the custodian of such property. Section 7, Last Par, Rule 57. Question: may damages be claimed by a party prejudiced by a wrongful attachment even if the judgment is adverse to him? Explain. 1999 Bar. Answer: yes. Damages may be claimed by a party prejudiced by a wrongful attachment even if the judgment is adverse to him. This is authorized by the rules. A claim for damages may be made on account of improper, irregular or excessive attachment, which shall be heard with notice to the adverse party and his surety or sureties. Section 20, Rule 57, Javelin vs. D.O. Plaza Enterprises Incorporated, General Register Number L 28297, March 30, 1970. Question: May a writ of preliminary attachment be issued ex parte? Briefly state the reasons for your answer. 2001 Bar. Answer: Yes, an order of attachment may be issued ex parte or upon motion with notice and hearing. Section 2, Rule 57. The reason why the order may be issued ex parte is that requiring notice to the adverse party and a hearing would defeat the purpose of the provisional remedy and enable the adverse party to abscond or dispose of his property before a writ of attachment issues. Mindanao Savings and Loan Association Incorporated vs. Court of Appeals, General Register Number 84481, April 18, 1989. Question: May a preliminary injunction be issued ex parte? Why? 2001 Bar. Answer: No, a writ of preliminary injunction may not be issued ex parte. As provided in the rules, no preliminary injunction shall be granted without hearing and prior notice to the party or person sought to be enjoined. Section 5, Rule 58. The reason is that a preliminary injunction may cause grave and irreparable injury to the party enjoined. Question: Katie filed an action against Tyrone for collection of the sum of $1 million in the RTC, with an ex parte application for a writ of preliminary attachment. Upon posting of an attachment bond, the court granted the application and issued a writ of preliminary attachment. Apprehensive that Tyrone might withdraw his savings deposit with the bank, the sheriff immediately served a notice of garnishment on the bank to implement the writ of preliminary attachment. The following day, the sheriff proceeded to Tyrone's house and served him the summons, with copies of the complaint containing the application for a writ of attachment, Katie's affidavit, order of attachment, writ of preliminary attachment and attachment bond. Within 15 days from service of the summons, Tyrone filed a motion to dismiss and to dissolve the writ of preliminary attachment on the following grounds: I. The court did not acquire jurisdiction over his person because the writ was served ahead of the summons. 2. The writ was improperly implemented, and 3. Said writ was improvidently issued because the obligation in question was already fully paid. Resolve the motion with reasons. 2005 Bar. Answer: The motion to dismiss and to dissolve the writ of preliminary attachment should be denied. 1. The fact that the writ of attachment was served ahead of the summons did not affect the jurisdiction of the court over his person. It makes the writ unenforceable. Section 5, Rule 57. However, all that is needed to be done is to reserve the writ. Oneid vs. Abergar, General Register Number 197393, February 23, 1985. 2. The writ was improperly implemented. Serving a notice of garnishment, particularly before the summons is served, is not proper. It should be a copy of the writ of attachment that should be served on the defendant, and a notice that the bank deposits are attached pursuant to the writ. Section 7D, Rule 57. 3. The writ was improvidently issued if indeed it can be shown that the obligation was already fully paid. The writ is only ancillary to the main action. Section 13, Rule 57. The alleged payment of the account cannot serve as a grounds for resolving the improvident issuance of the writ, because this matter delves into the merits of the case, and requires full-blown trial. Payment, however, serves as a ground for a motion to dismiss. Question: Distinguish attachment from garnishment. 1999 Bar. Answer: Attachment and garnishment are distinguished from each other as follows. Attachment is a provisional remedy that affects a levy on property of a party as security for the satisfaction of any judgment that may be recovered, while garnishment is a levy on debts due the judgment obligor or defendant and other credits, including bank deposits, royalties and other personal property not capable of manual delivery under a writ of execution or a writ of attachment. Question. Briefly discuss. Differentiate the following kinds of attachment: preliminary attachment, garnishment, levy on execution, warrant of seizure and warrant of distraint and levy. 2012 Bar. Answer. Preliminary attachment is a provisional remedy under Rule 57 of the Rules of Court. It may be sought at the commencement of an action or at any time before entry of judgment where property of an adverse party may be attached as security for satisfaction of any judgment, where this adverse party is about to depart from the Philippines, where he has intent to defraud or has committed fraud, or is not found in the Philippines. An affidavit and a bond is required before the preliminary attachment issues. It is discharged upon payment of a counter bond. Garnishment is a manner of satisfying or executing judgment where the sheriff may levy debts, credits, royalties, commissions, bank deposits and other personal property not capable of manual delivery that are in the control or possession of third persons and are due the judgment obligor. Notice shall be served on third parties. The third-party garnishee must make a written report on whether or not the judgment obligor has sufficient funds or credits to satisfy the amount of the judgment. If not, the report shall state how much funds or credits the garnishee holds for the judgment obligor. Section 9C, Rule 39. Levy on execution is a manner of satisfying or executing judgment where the sheriff may sell property of the judgment obligor if he is unable to pay all or part of the obligation in cash, certified bank check or any other manner acceptable to the obligee. If the obligor does not choose which among his property may be sold, the sheriff shall sell personal property first and then real property second. He must sell only so much of the personal or real property as is sufficient to satisfy judgment and other lawful fees. Section 9b, Rule 39. Warrant of seizure is normally applied for with the search warrant, in criminal cases. The warrant of seizure must particularly describe the things to be seized. While it is true that the property to be seized under a warrant must be particularly described therein and no other property can be taken thereunder, yet the description is required to be specific only insofar as the circumstances will ordinarily allow. An application for search and seizure warrant shall be filed with the following: a. Any court within whose territorial jurisdiction a crime was committed. b. For compelling reasons stated in the application, any court within the judicial region where the crime was committed if the place of the commission of the crime is known, or any court within the judicial region where the warrant shall be enforced. However, if the criminal action has already been filed, the application shall only be made in the court where the criminal action is pending. Warrant of distraint and levy is remedy available to local governments and the burn tax cases to satisfy deficiencies or delinquencies in inheritance and estate taxes, and real estate taxes. Distraint is the seizure of personal property to be sold in an authorized auction sale. Levy is the issuance of a certification by the proper officer showing the name of the taxpayer and the tax, fee, charge or penalty due him. Levy is made by writing upon said certificate the description of the property upon which levy is made. Question. A sues B for collection of a sum of money, alleging fraud in the contracting of the loan, applies for preliminary attachment with the court. The court issues the preliminary attachment after A files a bond. While summons on B was yet unserved, the sheriff attached B's properties. Afterwards, summons was duly served on B. B moves to lift the attachment. Rule on this. 2012 Bar. Answer. I will grant the motion since no levy on attachment pursuant to the writ shall be enforced unless it is preceded or contemporaneously accompanied by service of summons. There must be prior or contemporaneous service of summons with the writ of attachment. Section 5, Rule 57. Question. Bayani, an overseas worker based in Dubai, issued in favor of Agenti a special power of attorney to sell his house and lot. Agenti was able to sell the property but failed to remit the proceeds to Bayani, as agreed upon. On his return to the Philippines, Bayani, by way of a demand letter duly received by Agenti, sought to recover the amount due him. Agenti failed to return the amount as he had used it for the construction of his own house. Thus, Bayani filed an action against Agenti for sum of money with damages. Bayani subsequently filed an ex parte motion for the issuance of a writ of preliminary attachment duly supported by an affidavit. The court granted the ex parte motion and issued a writ of preliminary attachment upon Bayani's posting of the required bond. Bayani prayed that the court's sheriff be deputized to serve and implement the writ of attachment. On November 19, 2013, the sheriff served upon Agenti the writ of attachment and Agenti levied on the latter's house and lot. On November 20, 2013, the sheriff served upon Agenti summons and a copy of the complaint. On November 22, 2013, Agenti filed an answer with motion to discharge the writ of attachment, alleging that at the time the writ of preliminary attachment was issued, he has not been served with summons and, therefore, it was improperly issued. 2014. A. Is Agenti correct? Answer. Number Agenti is not correct. Section 2, Rule 57 provides that a writ of attachment may be issued ex parte or upon motion with notice and hearing by the court in which the action is pending. Under the rules, the applicant of the writ is only required to I. Submit an affidavit and 2. Post a bond before the court can validly issue the writ of attachment. The rules do not require prior service of summons for the proper issuance of a writ of attachment. Sophia Torres v. Nekuner Sat Satan, General Register No. 166759, November 25, 2009. Accordingly, the issuance of the writ of attachment is valid notwithstanding the absence of a prior service of summons to Agnet. B. Was the writ of preliminary attachment properly executed? 2014 bar. Answer. Number The writ of preliminary attachment was not properly executed. Although a writ of attachment may issue even before summons is served upon the defendant, the same, however, may not bind and affect the defendant until jurisdiction over his person is obtained. DeVoe Light and Power Company Incorporated vs. Court of Appeals, General Register No. 93262, December 29, 1991. Thus, the writ of preliminary attachment must only be served simultaneous or at least after the service of summons to the defendant. Sophia Torres v. Nekuner Sat Satan, General Register No. 166759, November 25, 2009. Preliminary injunction. Question. Define a temporary restraining order, TRO. Differentiate a TRO from a status quo order. 2006 bar. Answer. A temporary restraining order is issued upon application of a party and upon the posting of the required bond. On the other hand, a status quo order may be issued motu proprio on equitable considerations, and does not require the posting of a bond. Unlike a temporary restraining order or a preliminary injunction, a status quo order is more in the nature of a cease and desist order, since it neither directs the doing or undoing of acts as in the case of prohibitory or mandatory injunctive relief. Garcia v. Mojica, General Register No. 139043. September 10, 1999. Question. What are the requisites for the issuance of a writ of preliminary injunction, and b. a final writ of injunction? 2006 bar. Answer. The requisites for the issuance of a writ of preliminary injunction are 1. A right in esse or a clear and unmistakable right to be protected. 2. a violation of that right. 3. That there is an urgent and permanent act and urgent necessity for the writ to prevent serious damage. Tyag v. Laxon, General Register No. 134971, March 25, 2004. A final writ of injunction may be granted if after trial of the action, it appears that the applicant is entitled to have the act or acts complained of permanently enjoined. Section 9, Rule 58. Question. Distinguish between injunction as an ancillary remedy and injunction as a main action. 2006 Bar. Answer. Injunction as an ancillary remedy presupposes the existence of a principal or main action. Valink v. Court of Appeals, General Register No. 55336, May 4, 1989. Its main function is to preserve the status quo until the merits can be heard and resolved. Urbanes v. Court of Appeals, General Register No. 117964, March 28, 2001. On the other hand, an injunction as the main action is brought specifically to obtain a judgment perpetually restraining or commanding the performance of an act after trial. Delmar v. Pagker, General Register No. 138298, November 29, 2000. Question. While window shopping at the mall on August 4, 2008, Dante lost his organizer including his credit card and billing statement. 2 days later, upon reporting the matter to the credit card company, he learned that a one-way airplane ticket was purchased online using his credit card for a flight to Milan in mid-August 2008. Upon extensive inquiry with the airline company, Dante discovered that the plane ticket was under the name of one Dinamro. Dante approaches you for legal advice. A. What is the proper procedure to prevent Dina from leaving the Philippines? Answer. The filing of an appropriate criminal action cognizable by the RTC against Dina and the filing in said criminal action a motion for the issuance of a hold departure order. 2. Thereafter, a written request with the Commissioner of the Bureau of Immigration for a watch list order pending the issuance of the hold departure order should be filed. 3. Then, the airline company should be requested to cancel the ticket issued to Dina. B. Suppose an information is filed against Dina on August 12, 2008 and she is immediately arrested. What pieces of electronic evidence will Dante have to secure in order to prove the fraudulent online transaction? 2010 Bar. Answer. He will have to present, A. His report to the bank that he lost his credit card, B. That the ticket was purchased after the report of the lost ad, and, C. The purchase of one-way ticket. Dante should bring an original, or an equivalent copy, print out of, 1. The online ticket purchase using his credit card, 2. The phone call log to show that he already alerted the credit card company of his loss, and 3. His credit card billing statement bearing the online ticket transaction. Question. Can a suit for injunction be aptly filed with the Supreme Court to stop the President of the Philippines from entering into a peace agreement with the National Democratic Front? 2003 Bar. Answer. A suit for injunction cannot aptly be filed with the Supreme Court to stop the President of the Philippines from entering into a peace agreement with the National Democratic Front, which is a purely political question. Matarang v. Santa Maria, General Register No. L 13316, December 11, 1917. The President of the Philippines is immune from suit. Question. May the RTC issue injunction without bond? 2006 Bar. Answer. Yes, if the injunction issued is a final injunction. Generally, however, a preliminary injunction may not be issued without the posting of a bond, unless exempted by the trial court, Section 4, B, Rule 58, or otherwise provided for by law. Question. An application for a writ of preliminary injunction with a prayer for a temporary restraining order is included in a complaint and filed in a multi-sala RTC consisting of branches 1, 2, 3 and 4. Being urgent in nature, The executive judge, who was sitting in Branch 1, upon the filing of the aforesaid application immediately raffled the case in the presence of the judges of Branches 2, 3 and 4. The case was raffled to Branch 4 and judge thereof immediately issued a temporary restraining order. Is the temporary restraining order valid? Why? 2001, 2006 Bar. Answer. Number it is only the executive judge who can issue immediately a temporary restraining order effective only for 72 hours from issuance. No other judge has the right or power to issue a temporary restraining order ex parte. The judge to whom the case is assigned will then conduct a summary hearing to determine whether the temporary restraining order shall be extended, but in no case beyond 20 days. Including the original 72-hour period, Section 5, Rule 58. Question: May a justice of a division of the Court of Appeals issue a TRO? 2006 Bar. Answer: Yes, a justice of a division of the Court of Appeals may issue a TRO, as authorized under Rule 58 and by Section 5. Rule V of the Internal Rules of Court of Appeals, which additionally requires that the action shall be submitted on the next working day to the absent members of the division for their ratification, modification or recall. Heirs of the late Justice Jose B. L. Reyes v. Court of Appeals, General Register Nos. 135,180-81, 135,425-26. August 16, 2000. Receivership. Question: Joaquin filed a complaint against Jose for the foreclosure of a mortgage of a furniture factory with a large number of machinery and equipment. During the pendency of the foreclosure suit, Joaquin learned from reliable sources that Jose was quietly and gradually disposing of some of his machinery and equipment to a businessman friend who was also engaged in furniture manufacturing, such that from confirmed reports Joaquin gathered, the machinery and equipment left with Jose were no longer sufficient to answer for the latter's mortgage indebtedness. In the meantime, judgment was rendered by the court in favor of Joaquin, but the same is not yet final. Knowing what Jose has been doing, if you were Joaquin's lawyer, what action would you take to preserve whatever remaining machinery and equipment are left with Jose? Why? 2001 Bar. Answer: To preserve whatever remaining machinery and equipment are left with Jose, Joaquin's lawyer should file a verified application for the appointment by the court of one or more receivers. The rules provide that receivership is proper in an action by the mortgagee for the foreclosure of a mortgage when it appears that the property is in danger of being wasted or dissipated or materially injured and that its value is probably insufficient to discharge the mortgage debt. Section 1, b, Rule 59. Writ Levin. Question: What is writ levin? 1999 Bar. Answer: Writ levin or delivery of personal property consists in the delivery, by order of the court, of personal property by the defendant to the plaintiff, upon the filing of a bond. Kahlo v. Roldan, General Register No. L252, March 30, 1946. Support pendenti lite. Question: Before the RTC, A was charged with rape of his 16-year-old daughter. During the pendency of the case, the daughter gave birth to a child allegedly as a consequence of the rape. Thereafter, she asked the accused to support the child, and when he refused, the former filed a petition for support pendenti lite. The accused, however, insists that he cannot be made to give such support, arguing that there is as yet no finding as to his guilt. Would you agree with the trial court if it denied the application for support pendenti lite? Explain. 1999, 2001. Answer: The provisional remedy of support pendenti lite may be granted by the RTC in the criminal action for rape. In criminal actions where the civil liability includes support for the offspring as a consequence of the crime and the civil aspect thereof has not been waived, reserved or instituted prior to its filing, the accused may be ordered to provide support pendenti lite to the child born to the offended party allegedly because of the crime. Section 6, Rule 61, Rules of Court. Special Civil Actions. Certiorari, Prohibition and Mandamus. Question: distinguish error of jurisdiction from error of judgment. 2012 Bar. Answer: an error of judgment is one which the court may commit in the exercise of its jurisdiction. Such an error does not deprive the court of jurisdiction and is correctable only by appeal, whereas an error of jurisdiction is one which the court acts without or in excess of its jurisdiction. Such an error renders an order or judgment void or voidable and is correctable by the special civil action of certiorari. Dela Cruz v. Moore, General Register No. L 12256, February 6, 1917. Kochinian v. Claribel, General Register No. 27070-71, April 22, 1977, Fordish v. Corona, General Register No. 131457, April 24, 1998, Artística Ceramica Incorporated v. Ciudad del Carmen Homeowners Association Incorporated, General Register Nos. 167,583-84, June 16, 2010. Question: compare the certiorari jurisdiction of the Supreme Court under the Constitution with it under Rule 65 of the Rules of Civil Procedure. 2008 Bar. Answer: under the Constitution, the certiorari jurisdiction of the Supreme Court provides for its expanded jurisdiction power of judicial power over, governs, all branches or instrumentalities of the government where there is a grave abuse of discretion amounting to lack or excessive jurisdiction, as, agencies and instrumentalities, provided in Section 1, Second Part, Article 8 of the 1987 Constitution. The petition is filed under Rule 45 of the Rules of Court, and the writ is directed not only to tribunal, board or officer exercising judicial or quasi-judicial functions, and the period fixed for availing of the remedy is within 30 days from receipt of the copy of the decision, order ruling in question, Section 7, Art. 9, 1987 Constitution. But under Rule 65 of the Rules of Court, the certiorari jurisdiction of the Supreme Court is limited to acts done without or in excess of jurisdiction or grave abuse of discretion amounting to lack or excessive jurisdiction, by a tribunal, board or officer exercising judicial or quasi-judicial functions only. And the period fixed for availing of the remedy is not later than 60 days from notice of judgment, order or resolution in question, Sections 1 and 4. Rule 65. Question: AB mortgaged his property to CD. AB failed to pay his obligation and CD filed an action for foreclosure of mortgage. After trial, the court issued an order granting CD's prayer for foreclosure of mortgage and ordering AB to pay CD the full amount of the mortgage debt including interest and other charges not later than 120 days from date of receipt of the order. AB received the order on August 10, 1999. No other proceeding took place thereafter. On December 20, 1999, AB tendered the full amount adjudged by the court to CD, but the latter refused to accept it on the ground that the money was tendered beyond the 120-day period granted by the court. AB filed a motion in the same court praying that CD be directed to receive the amount tendered by him on the ground that the order does not comply with the provisions of Section 2, Rule 68 of the Rules of Court, which give AB 120 days from entry of judgment, and not from date of receipt of the order. The court denied his motion on the ground that order had already become final and can no longer be amended to conform with Section 2, Rule 68. Aggrieved, AB files a petition for certiorari against the court and CD. Will the petition for certiorari prosper? Explain. 2000 Bar. Answer: yes. The court erred in issuing an order granting CD's prayer for foreclosure of mortgage and ordering AB to pay CD the full amount of the mortgage and ordering AB to pay CD the full amount of the mortgage debt including interest and other charges not later than 120 days from receipt of the order. The court should have rendered a judgment which is appealable. Since no appeal was taken, the judgment became final on August 25, 1999, which is the date of entry of judgment, Section 2, Rule 36. Hence, AB had up to December 24, 1999 within which to pay the amount due, Section 2, Rule 68. The court gravely abused its discretion amounting to lack or excessive jurisdiction in denying AB's motion praying that CD be directed to receive the amount tendered. Question: The defendant was declared in default in the RTC for his failure to file an answer to a complaint for a sum of money. On the basis of the plaintiff's ex parte presentation of evidence, judgment by default was rendered against the defendant. The default judgment was served on the defendant on October 1, 2001. On October 10, 2001, he files a verified motion to lift the order of default and to set aside the judgment. In his motion, the defendant alleged that, immediately upon receipt of the summons, he saw the plaintiff and confronted him with his receipt evidencing his payment and the plaintiff assured him that he would instruct his lawyer to withdraw the complaint. The trial court denied the defendant's motion because it was not accompanied by an affidavit of merit. The defendant filed a special civil action for certiorari under Rule 65 challenging the denial order. A. Is certiorari under Rule 65 the proper remedy? Why? Answer: yes. The petition for certiorari under Rule 65 filed by the defendant is the proper remedy because appeal is not a plain, speedy and adequate remedy in the ordinary course of law. In appeal, the defendant in default can only question the decision in the light of the evidence of the plaintiff. The defendant cannot invoke the receipt to prove payment of his obligation to the plaintiff. B. Did the trial court abuse its discretion or act without or in excess of its jurisdiction in denying the defendant's motion to lift the order of default judgment? Why? 2002 Bar. Answer: yes. The trial court gravely abused its discretion or acted without or in excess of jurisdiction in denying the defendant's motion because it was not accompanied by a separate affidavit of merit. In his verified motion to lift the order of default and to set aside the judgment, the defendant alleged that immediately upon the receipt of the summons, he saw the plaintiff and confronted him with his receipt showing payment and that the plaintiff assured him that he would instruct his lawyer to withdraw the complaint. Since the good defense of the defendant was already incorporated in the verified motion, there was no need for a separate affidavit of merit. Caputes v. Court of Appeals, General Register No. 112795, June 27, 1994, Mago v. Court of Appeals, General Register No. 115624, February 25, 1999. Question: explain each mode of certiorari. A. As a mode of appeal from the regional trial court or the Court of Appeals to the Supreme Court. Answer: a petition for review on certiorari under Rule 45 is a mode of appeal on pure questions law from a judgment or final order or resolution of the regional court or the Court of Appeals to the Supreme Court. B. As special civil action from the regional trial court or the Court of Appeals to the Supreme Court. Answer: a special civil action for certiorari under Rule 65, is an original action from the regional trial court or the Court of Appeals to the Supreme Court against any tribunal, board or officer exercising judicial or quasi-judicial functions raising the issue of lack or excessive jurisdiction or grave abuse of discretion amounting to lack or excessive jurisdiction, there being no appeal or any plain, speedy and adequate remedy in the ordinary course of law. C. As a mode of review of the decisions of the National Labor Relations Commission and the Constitutional Commissions. 2006 Bar. Answer: the mode of review of the decision of the NLRC is via a special civil action for certiorari under Rule 65, but pursuant to the hierarchy of the courts enunciated in the case of St. Martin's Funeral Homes v. NLRC, General Register No. 130866, September 16, 1998, the same should be filed in the Court of Appeals. The mode of review of the decisions of two constitutional commissions, the Commission on Elections and the Commission on Audit, as provided under Rule 64, is the special civil action for certiorari under Rule 65. Decisions of the Civil Service Commission, however, are reviewable by petition for review to be filed with the Court of Appeals under Rule 43. Question: differentiate certiorari as an original action from certiorari as a mode of appeal. 1998, 1999 bar. Answer: certiorari as an original action and certiorari as a mode of appeal may be distinguished as follows. A. The first is a special civil action under Rule 65, while the second is an appeal to the Supreme Court from the Court of Appeals, Sandiganbayan, and the Regional Trial Court under Rule 45. B. The first can be filed only on the grounds of lack or excessive jurisdiction or grave abuse of discretion tantamount to lack or excessive jurisdiction, while the second is based on the errors of law of the lower court. C. The first should be filed within 60 days from notice of the judgment, order or resolution sought to be assailed, Section 4, Rule 65. While the second should be filed within 15 days from notice of the judgment or final order or resolution appealed from, or of the denial of the petitioner's motion for new trial or reconsideration filed in due time after notice of the judgment, Section 2, Rule 45. D. The first cannot generally be availed of as a substitute for a lost appeal under Rules 40, 41, 42, 43 and 45. E. Under the first, the lower court is impleaded as a party respondent, Section 5, Rule 65, while under the second, the lower court is not impleaded, Section 4, Rule of 45. Question: may the aggrieved party file a petition for certiorari in the Supreme Court under Rule 65 of the 1997 Rules of Civil Procedure, instead of filing a petition for review on certiorari under Rule 45 thereof for the nullification of a decision of the Court of Appeals in the exercise either of its original or appellate jurisdiction? Explain. 1999, 2005 bar. Answer: to nullify a decision of the Court of Appeals, the aggrieved party should file a petition for review on certiorari in the Supreme Court under Rule 45 of the Rules of Court instead of filing a petition for certiorari under Rule 65 except under very exceptional circumstances. A long line of Supreme Court decisions, too numerous to mention, holds that certiorari is not a substitute for a lost appeal. It should be noted, however, when the Court of Appeals imposes the death penalty, or a lesser penalty for offenses committed on such occasion, appeal by petition for review or ordinary appeal. In cases when the Court of Appeals imposes reclusion perpetua, life imprisonment or a lesser penalty, appeal is by notice of appeal filed with the Court of Appeals. Question: after an information for rape was filed in the RTC, the DOJ Secretary, acting on the accused's petition for review, reversed the investigating prosecutor's finding of probable cause. Upon order of the DOJ Secretary, the trial prosecutor filed a motion to withdraw information which the judge granted. The order of the judge stated only the following. Based on the review by the DOJ Secretary of the findings of the investigating prosecutor during the preliminary investigation, the court agrees that there is no sufficient evidence against the accused to sustain the allegation in the information. The motion to withdraw information is, therefore, granted. If you were the private prosecutor, what should you do? Explain. 2003, 2012 bar. Answer: if I were the private prosecutor, I would file a petition for certiorari under Rule 65 with the Court of Appeals, Cerezo v. People, GR number 185230, June 1, 2011. It is well settled that when the trial court is confronted with a motion to withdraw an information, On the ground of lack of probable cause to hold the accused for trial based on a resolution of the DOJ Secretary, the trial court has the duty to make an independent assessment of the merits of the motion. It may either agree or disagree with the recommendation of the Secretary. Reliance alone on the resolution of the Secretary would be an abdication of the trial court's duty and jurisdiction to determine a prima facie case. The court must itself be convinced that there is indeed no sufficient evidence against the accused. Otherwise, the judge acted with grave abuse of discretion if he grants the motion to withdraw information by the trial prosecutor. Harold Tamargo v. Romulo Inganet. Al. General Register No. 177727, January 19, 2010. Question: After plaintiff in an ordinary civil action before the RTC, ZZ has completed presentation of his evidence. Defendant without prior leave of court moved for dismissal of plaintiff's complaint for insufficiency of plaintiff's evidence. After due hearing of the motion and the opposition thereto, the court issued an order, reading as follows: The court hereby grants defendant's motion to dismiss and accordingly orders the dismissal of plaintiff's complaint, with the costs taxed against him. It is so ordered. Is the order of dismissal valid? May plaintiff properly take an appeal? Reason: 2004 bar. Answer: The order or decision is void because it does not state findings of fact and of law, as required by Section 14, Article 8 of the Constitution and Section 1, Rule 36. Being void, appeal is not available. The proper remedy is certiorari under Rule 65. Question: Jaime was convicted for murder by the Regional Trial Court of Davao City in a decision promulgated on September 30, 2015. On October 5, 2015, Jaime filed a motion for new trial on the ground that errors of law and irregularities prejudicial to his rights were committed during his trial. On October 7, 2015, the private prosecutor, with the conformity of the public prosecutor, filed an opposition to Jaime's motion. On October 9, 2015, the court granted Jaime's motion. On October 12, 2015, the public prosecutor filed a motion for reconsideration. The court issued an order dated October 16, 2015 denying the public prosecutor's motion for reconsideration. The public prosecutor received his copy of the order of denial on October 20, 2015 while the private prosecutor received his copy on October 26, 2015. A. What is the remedy available to the prosecution from the court's order granting Jaime's motion for new trial? Answer: The remedy of the prosecution is to file a petition for certiorari under Rule 65 of the Rules of Court, because the denial of a motion for reconsideration is merely an interlocutory order and there is no plain, speedy and adequate remedy under the course of law. Be that as it may be argued that appeal is the appropriate remedy from an order denying a motion for reconsideration of an order granting a motion for new trial because an order denying a motion for reconsideration was already removed in the enumeration of matters that cannot be a subject of an appeal under Section 1, Rule 41 of the Rules of Court. B. In what court and within what period should a remedy be availed of? Answer: Following the principle of judicial hierarchy, the petition for certiorari should be filed before the Court of Appeals within 60 days from receipt of the copy of the order of denial of the public prosecutor's motion for reconsideration, or on October 20, 2015. C. Who should pursue the remedy? 2015 bar. Answer: The Office of the Solicitor General, OSG, should pursue the remedy. In criminal proceedings on appeal in the Court of Appeals or in the Supreme Court, the authority to represent the people is vested solely in the Solicitor General. Under Presidential Decree No. 4478, among the specific powers and functions of the OSG is to represent the government in the Supreme Court and the Court of Appeals in all criminal proceedings. This provision has been carried over to the Revised Administrative Code, particularly in Book 4, Title 3, Chapter 12 thereof. Without doubt, the OSG is the appellate counsel of the people of the Philippines in all criminal cases. Carino vs. De Castro, General Register No. 176084, April 30, 2008. Question: The Ombudsman found probable cause to charge with plunder the provincial governor, vice governor, treasurer, budget officer, and accountant. An information for plunder was filed with the Sandiganbayan against the provincial officials except for the treasurer, who was granted immunity when he agreed to cooperate with the Ombudsman in the prosecution of the case. Immediately, the governor filed with the Sandiganbayan a petition for certiorari against the Ombudsman, claiming there was grave abuse of discretion in excluding the treasurer from the information. A. Was the remedy taken by the governor correct? Answer: No, the remedy taken by the governor is not correct. The petition for certiorari is a remedy that is only available when there is no plain, speedy and adequate remedy under the ordinary course of law. Hence, the governor should have filed a motion for reconsideration. Besides, there is no showing that the Ombudsman committed grave abuse of discretion in granting immunity to the treasurer who agreed to cooperate in the prosecution of the case. B. Will the writ of mandamus lie to compel the Ombudsman to include the treasurer in the information? 2015 Bar. Answer: No, mandamus will not lie to compel the Ombudsman to include the treasurer in the information. In matters involving exercise of judgment and discretion, mandamus may only be resorted to in order to compel respondent tribunal, corporation, board, officer or person to take action, but it cannot be used to direct the manner or particular way discretion is to be exercised, or to compel the retraction or reversal of an action already taken in the exercise of judgment or discretion. Ampichuan Jr. vs. Secretary de Lima, General Register No. 197291, April 3, 2013. Evidently, the Ombudsman's act of granting the treasurer immunity from prosecution under such terms and conditions as it may determine, Section 17, Republic Act 6770, is a discretionary duty that may not be compelled by the extraordinary writ of mandamus. Mandamus. Question: Petitioner Fabian was appointed election registrar of the municipality of Sevilla supposedly to replace the respondent election registrar Pablo, who was transferred to another municipality without his consent and who refused to accept his aforesaid transfer, much less to vacate his position in Bogotá as election registrar, as in fact he continued to occupy his aforesaid position and exercise his functions thereto. Petitioner Fabian then filed a petition for mandamus against Pablo, but the trial court dismissed Fabian's petition, contending that quo warranto is the proper remedy. Is the court correct in its ruling? Why? 2001 Bar. Answer: Yes, the court is correct in its ruling. Mandamus will not lie. This remedy applies only where petitioner's right is founded clearly in law, not when it is doubtful. Pablo was transferred without his consent, which is tantamount to removal without cause, contrary to the fundamental guarantee on non-removal except for cause. Considering that Pedro continued to occupy the disputed position and exercised his functions therein, the proper remedy is quo warranto, not mandamus. Garces vs. Court of Appeals, General Register No. 114795. July 17, 1996. Question: In 1996, Congress passed Republic Act No. 8189, otherwise known as the Voters Registration Act of 1996, providing for computerization of elections. Pursuant thereto, the COMELEC approved the Voters Registration and Identification System (VRIS) project. It issued invitations to pre-qualify and bid for the project. After the public bidding, Photokina was declared the winning bidder with a bid of $6 billion and was issued a notice of award. But QUAMTO Chairman Jenner Go objected to the award on the ground that under the Appropriations Act, the budget for the QUAMTO's modernization is only $1 billion. He announced to the public that the VERUS project has been set aside. 2 commissioners sided with Chairman Go, but the majority voted to uphold the contract. Meanwhile, Photokina filed with the RTC a petition for mandamus to compel the QUAMTO to implement the contract. The Office of the Solicitor General, OSG, representing Chairman Go, opposed the petition on the ground that mandamus does not lie to enforce contractual obligations. During the proceedings, the majority commissioners filed a manifestation that Chairman Go was not authorized by the QUAMTO Bank to oppose the petition. Is a petition for mandamus an appropriate remedy to enforce contractual obligations? 1999, 2006 Bar. Answer: no, the petition for mandamus is not an appropriate remedy because it is not available to enforce a contractual obligation. Mandamus is directed only to ministerial acts, directing or commanding a person to do a legal duty. QUAMTO vs. Quiano Padilla, General Register No. 152992, September 18, 2002, Section 3, Rule 65. Question: A files a complaint against B for recovery of title and possession of land situated in Makati with the RTC of Pasig. B files a motion to dismiss for improper venue. The RTC Pasig judge denies B's motion to dismiss, which obviously was incorrect, alleging that the RTC judge unlawfully neglected the performance of an act which the law specifically enjoins as a duty resulting from an office. A files a petition for mandamus against the judge. Will mandamus lie? Reasons. 2012 Bar. Answer: no, mandamus will not lie. The proper remedy is a petition for prohibition, Serena vs. Sandigan in General Register No. 162059, January 22, 2008. The dismissal of the case based on improper venue is not a ministerial duty. Mandamus does not lie to compel the performance of a discretionary duty. Nilo Paloma vs. Danilo Mara, General Register No. 157783, September 23, 2005. Quo warranto. Question: A group of businessmen formed an association in Cebu City calling itself Cars C to distribute/sell cars in said city. It did not incorporate itself under the law nor did it have any government permit or license to conduct its business as such. The Solicitor General filed before a RTC in Manila a verified petition for quo warranto questioning and seeking to stop the operations of Cars Company. The latter filed a motion to dismiss the petition on the ground of improper venue, claiming that its main office and operation are in Cebu City and not in Manila. Is the contention of Cars Company correct? Why? 2001 Bar. Answer: number as expressly provided in the rules. When the Solicitor General commences the action for quo warranto, it may be brought in the RTC in the city of Manila, as in this case, in the Court of Appeals or in the Supreme Court, Section 7, Rule 66. Expropriation. Question: May Congress enact a law providing that a 5,000 square meter lot, a part of the UST compound in Sampaloc, Manila, be expropriated for the construction of a park in honor of former City Mayor Arsenio Lacson? As compensation to UST, the City of Manila shall deliver its 5-hectare lot in Sda. Rosa, Laguna, originally intended as a residential subdivision for the Manila City Hall employees. Explain. 2006 Bar. Answer: yes. Congress may enact a law expropriating property provided that it is for public use and with just compensation. In this case, the construction of a park is for public use. See, Sena vs. Manila Railroad Co., General Register No. 15915, September 7, 1921, Reyes vs. NHA, General Register Number 147511, March 24, 2003. The planned compensation, however, is not legally tenable as the determination of just compensation is a judicial function. No statute, decree or executive order can mandate that the determination of just compensation by the executive or legislative departments can prevail over the court's findings. Export Processing Zone Authority vs. ULE, General Register Number L59603, April 29, 1987, Sections 5 to 8 Rule 67. In addition, compensation must be paid in money. Esteban vs. Honorio, AM number 004166 RTC, June 29, 2001. Foreclosure of real estate mortgage. Question. A. Is the buyer in the auction sale arising from an extrajudicial foreclosure entitled to a writ of possession even before the expiration of the redemption period? If so, what is the action to be taken? B. After the period of redemption has lapsed and the title to the lot is consolidated in the name of the auction buyer, is he entitled to the writ of possession as a matter of right? If so, what is the action to be taken? C. Suppose that after the title to the lot has been consolidated in the name of the auction buyer, said buyer sold the lot to a third party without first getting a writ of possession. Can the transferee exercise the right of the auction buyer and claim that it is a ministerial duty of the court to issue a writ of possession in his favor? Briefly explain. 2016 Bar. Answer. A. Yes, the buyer in the auction sale is entitled to a writ of possession even before the expiration of the redemption period upon the filing of the ex parte petition for issuance of a writ of possession and posting of the appropriate bond. Under Section 7 of Act No. 3135, as amended, the writ of possession may be issued to the purchaser in a foreclosure sale either within the one-year redemption period upon the filing of a bond, or after the lapse of the redemption period, without need of a bond. LZK Holdings and Development Corporation vs. Planters Development Bank, General Register Number 167998. April 27, 2007, stated otherwise, Section 7 of Act No. 3135, as amended, also refers to a situation wherein the purchaser seeks possession of the foreclosed property during the 12-month period for redemption. Hence, upon the purchaser's filing of the ex parte petition and posting of the appropriate bond, the RTC shall, as a matter of course, order the issuance of the writ of possession in favor of the purchaser. Spouses Nicasio C. Marquez and Anita J. Marquez vs. Spouses Carlito Alindog and Carmen Alindog, General Register Number 184045, January 22, 2014, Spouses Jose Gattislao and Ermila Gattislao vs. Leo Ray Jansen, General Register Number 191540, January 21, 2015. B. Yes, the auction buyer is entitled to a writ of possession as a matter of right. It is settled that the buyer in a foreclosure sale becomes the absolute owner of the property purchased if it is not redeemed within a period of 1 year after the registration of the certificate of sale. He is, therefore, entitled to the possession of the property and can demand it at any time following the consolidation of ownership in his name and the issuing to him of a new transfer certificate of title. In such a case, the bond required in Section 7 of Act No. 3135 is no longer necessary. Possession of the land then becomes an absolute right of the purchases as confirmed owner. Upon proper application and proof of title, the issuance of the writ of possession becomes a ministerial duty of the court. LZK Holdings and Development Corporation vs. Planters Development Bank, General Register Number 167998, April 27, 2007, SPS, Marquez vs. SPS. Alindog, General Register Number 184045, January 22, 2014, SPS. Gajislaw vs. Leo Ray Jansen, General Register Number 191540, January 21, 2015. C. Yes, the transferee can exercise the right of the auction buyer. A transferee or successor in interest of the auction buyer by virtue of the contract of sale between them, is considered to have stepped into the shoes of the auction buyer. As such, the transferee is necessarily entitled to avail of the provisions of Section 7 of Act 3135, as amended, as if he is the auction buyer. SPS. Gajislaw vs. Jansen, Ibid. When the lot purchased at a foreclosure sale is in turn sold or transferred, the right to the possession thereof, along with all other rights of ownership, transfers to its new owner. SPS. Gallen vs. Velasquez, General Register Number 203949, April 6, 2016. Ergo, it is a ministerial duty of the court to issue a writ of possession in favor of the transferee of the auction buyer. Forcible entry and unlawful detainer. Question. A borrowed from the Development Bank of the Philippines, DBP, the amount of 1 million secured by the titled land of his friend B who, however, did not assume personal liability for the loan. A defaulted in DBP filed an action for judicial foreclosure of the real estate mortgage pleading A and B as defendants. In due course, the court rendered judgment directing A to pay the outstanding account of 1.5 million, principal plus interest, to the bank. No appeal was taken by A on the decision within the reglementary period. A failed to pay the judgment debt within the period specified in the decision. Consequently, the court ordered the foreclosure sale of the mortgaged land. In that foreclosure sale, the land was sold to the DPB for 1.2 million. The sale was subsequently confirmed by the court, and the confirmation of the sale was registered with the Registry of Deeds on January 5, 2002. On January 10, 2003, the bank filed an ex parte motion with the court for the issuance of a writ of possession to oust B from the land. It also filed a deficiency claim for 800,000 against A and B. The deficiency claim was opposed by A and B. A. Resolve the motion for the issuance of a writ of possession. Answer. In judicial foreclosure of banks such as DBP, the mortgagor of debtor whose real property has been sold on foreclosure has the right to redeem the property sold within 1 year after the date, or registration of the sale. However, the purchaser at the auction sale has the right to obtain a writ of possession after the finality of the order confirming the sale. Section 3, Rule 68, Section 47, Republic Act 8791. The General Banking Law of 2000. The motion for writ of possession, however, cannot be filed ex parte. There must be a notice of hearing. B. Resolve the deficiency claim of the bank. 2003 Bar. Answer. The deficiency claim of the bank may be enforced against the mortgage debtor A, but it cannot be enforced against B, the owner of the mortgaged property, who did not assume personal liability for the loan. Ejectment. Question. On January 10, 1990, X leased the warehouse of A under a lease contract with a period of 5 years. On June 8, 1996, A filed an unlawful detainer case against X without a prior demand for X to vacate the premises. A. Can X contest his ejectment on the ground that there was no prior demand for him to vacate the premises? Answer. Yes. X can contest his ejectment on the ground that there was no prior demand to vacate the premise. Section 2, Rule 70, Castellan vs. Omasi, General Register Number L16574, February 28, 1964, Lezaca vs. Cuevas, General Register Number L48419, October 27, 1983. B. In case the municipal trial court renders judgment in favor of A, is the judgment immediately executory? 1997 Bar. Answer. Yes, because the judgment of the municipal trial court against the defendant X is immediately executory upon motion unless an appeal has been perfected, a supersedeas bond has been filed and the periodic deposits of current rentals, if any, as determined by the judgment will be made with the appellate court. Sec. 19, Rule 70. Unlawful detainer. Question. In an action for unlawful detainer in the municipal trial court, MTC, defendant X raised in his answer the defense that plaintiff A is not the real owner of the house subject of the suit. X filed a counterclaim against A for the collection of a debt of $80,000 plus accrued interest of $15,000 and attorney's fees of $20,000. A. Is X's defense tenable? Answer. Number X's defense is not tenable if the action is filed by a lessor against a lessee. However, if the right of possession of the plaintiff depends on his ownership, then the defense is tenable. B. Does the MTC have jurisdiction over the counterclaim? 1998 bar. Answer. The counterclaim is within the jurisdiction of the municipal trial court, which does not exceed $100,000. Because the principal demand is $80,000, exclusive of interest and attorney's fees, Sec. 33, but is Pambansa BLG 129, as amended. However, inasmuch as all actions of forcible entry and unlawful detainer are subject to summary procedure and since the counterclaim is only permissive, it cannot be entertained by the municipal trial court. Section 1, Revised Rule on Summary Procedure. Question. The spouses one reside in Quezon City. With their lottery winnings, they purchased a parcel of land in Tagaytay City for 100,000 pesos. In a recent trip to their Tagaytay property, they were surprised to see hastily assembled shelters of light materials occupied by several families of informal settlers who were not there when they last visited the property three months ago. To rid the spouses' Tagaytay property of these informal settlers, briefly discuss the legal remedy you, as their counsel, would use, the steps you would take, the court where you would file your remedy if the need arises, and the reason for your actions. 2013 bar. Answer. As counsel of spouses 1, I will file a special civil action for forcible entry. The rules of court provides that a person deprived of the possession of any land or building by force, intimidation, threat, strategy or stealth may at any time within 1 year after such withholding of possession bring an action in the proper municipal trial court where the property is located. This action, which is summary in nature, seeks to recover the possession of the property from the defendant which was illegally withheld by the latter. Section 1. Rule 70. An ejectment case is designed to restore, through summary proceedings, the physical possession of any land or building to one who has been illegally deprived of such possession, without prejudice to the settlement of the parties opposing claims of juridical possession in appropriate proceedings. Heirs of Agapatio T. Alart and Angela A. Alart et al. Versus Office of the President of the Philippines et al. General Register Number 177995, June 15, 2011. Inabad vs. Fair Rolls, General Register Number 178635, April 11, 2011. The Supreme Court held that 2 allegations are indispensable in actions for forcible entry to enable first-level courts to acquire jurisdiction over them. First, that the plaintiff had prior physical possession of the property, and, second, that the defendant deprived him of such possession by means of force, intimidation, threats, strategy, or stealth. However, before instituting the said action, I will first endeavor to amicably settle the controversy with the informal settlers before the appropriate Lupon or Barangay chairman. If there is no agreement reached after mediation and conciliation under the Katarungang Pambarangay Law, I will secure a certificate to file action and file the complaint for ejectment before the MTC of Tagtay City where the property is located, since ejectment suit is a real action regardless of the value of the property to be recovered or claim for unpaid rentals. BP 129 and Section 1, Rule 4. In the aforementioned complaint, I will allege that spouses 1 had prior physical possession and that the dispossession was due to force, intimidation and stealth. The complaint will likewise show that the action was commenced within a period of 1 year from unlawful deprivation of possession, and that spouses 1 is entitled to restitution of possession together with damages and costs. Question: BB files a complaint for ejectment in the MTC on the ground of non-payment of rentals against JJ. After 2 days, JJ files in the RTC a complaint against BB for specific performance to enforce the option to purchase as the land subject to the ejectment case. What is the effect of JJ's action on BB's complaint? Explain. 2000 bar. Answer: there is no effect. The ejectment case involves possession de facto only. The action to enforce the option to purchase will not suspend the action of ejectment for non-payment or rentals. Wilman Auto Supply Corporation vs. Court of Appeals, General Register Number 97637, April 10, 1992. Question: landlord, a resident of Quezon City, entered into a lease contract with tenant, a resident of Marikina City, over a residential house in Las Piñas City. The lease contract provided, among others, for a monthly rental of 25,000 pesos plus 10% interest rate in case of non-payment on its due date. Subsequently, landlord migrated to the United States of America, USA, but granted in favor of his sister Maria a special power of attorney to manage the property and file and defend suits over the property rented out to tenant. Tenant failed to pay the rentals due for 5 months. Maria asks your legal advice on how she can expeditiously collect from tenant the unpaid rentals plus interests due. A. What judicial remedy would you recommend to Maria? Answer: I will advise Maria to immediately send a letter to the tenant demanding the immediate payment of the unpaid rentals plus interests due. If the tenant refuses, Maria can avail any of the following remedies. 1. A complaint under AM number 0887SC or the Rules of Procedure for Small Claims Cases. Maria should nonetheless waive the amount in excess of 100,000 in order for her to avail of the remedy under the said rules. 2. A complaint for collection of sum of money under the rules on summary procedure, since Maria is only claiming the unpaid rentals and interest due from tenant. 3. If the tenant refuses or is unable to pay the rentals within 1 year from the last demand to vacate and pay, I would advise Maria to file an action for unlawful detainer. B. Where is the proper venue of the judicial remedy which you recommended? Answer: 1. If Maria decides to file a complaint for collection of sum of money under the rules of summary procedure or small claims, the venue is the residence of the plaintiff or defendant, at the election if the plaintiff, Section 2, Rule 4. Hence it may be in Quezon City or Marikina City, at the option of Maria. 2. If Maria files an action for unlawful detainer, the same shall be commenced and tried in the municipal trial court of the municipality or city wherein the real property involved, or a portion thereof is situated, Section 1, Rule 4. Therefore, the venue is Las Piñas City. C. If Maria insists on filing an ejectment suit against tenant, when do you reckon the 1 year period within which to file the action? 2014 bar. Answer: the reckoning point for determining the 1 year period within which to file the action is the receipt of the last demand to vacate and pay, Section 2, Rule 70. Question: Mr. Sheriff attempts to enforce a writ of execution against X, a tenant in a condominium unit, who lost in an ejectment case. X does not want to budge and refuses to leave. Y, the winning party, moves that X be declared in contempt, and after hearing, the court held X guilty of indirect contempt. If you were X's lawyer, what would you do? Y. 2012 bar. Answer: if I were X's lawyer, I would file a petition for certiorari under Rule 65. The judge should not have acted on Y's motion to declare X in contempt. The charge of indirect contempt is initiated through a verified petition, Section 4, Rule 71. The writ was not directed to X but to the sheriff, which was directed to deliver the property to Y. As the writ did not command the judgment debtor to do anything, he cannot be guilty of the facts described in Rule 71, which is disobedience of or resistance to a lawful writ, process, order, judgment, or command of any court. The proper procedure is for the sheriff to oust X availing of the assistance of peace officers pursuant to Section 10C of Rule 39, Lipa v. Tootin, L. 16643, September 29, 1983, Medina v. Garces, L. 25923, July 15, 1980, Pascu v. Sayers of Segundo Simeon, General Register No. L. 47717, May 2, 1988, Patagonet. Al. v. Panis, General Register No. 55630, April 8, 1988. Contempt. Question: A filed a complaint for the recovery of ownership of land against B, who was represented by her counsel X. In the course of the trial, B died. However, X failed to notify the court of B's death. The court proceeded to hear the case and rendered judgment against B. After the judgment became final, a writ of execution was issued against C, who, being B's sole heir, acquired the property. Did the failure of counsel X to inform the court of B's death constitute direct contempt? 1998 bar. Answer: No. It is not direct contempt under Section 1 of Rule 71, but it is an indirect contempt within the purview of Section 3 of Rule 71. The lawyer can also be subject of disciplinary action, Section 16, Rule 3. Special proceedings. Writ of habeas corpus. Question: Roxanne, a widow, filed a petition for habeas corpus with the Court of Appeals against Major Amor, who is allegedly detaining her 18-year-old son Bong without authority of law. After Amor had filed a return alleging the cause of detention of Bong, the Court of Appeals promulgated a resolution remanding the case to the RTC for a full-blown trial due to the conflicting facts presented by the parties in their pleadings. In directing the remand, the Court of Appeals relied on Section 9(1) in relation to Section 21 of BP 129, conferring upon said court the authority to try and decide habeas corpus cases concurrently with the RTCs. Did the Court of Appeals act correctly in remanding the petition to the RTC? Why? 1993 bar. Answer: No. Because while the CA has original jurisdiction over habeas corpus concurrent with the RTCs, it has no authority for remanding to the latter original actions filed with the former. On the contrary, the CA is specifically given the power to receive evidence and perform any and all acts necessary to resolve factual issues raised in cases falling within its original jurisdiction. When not proper/applicable. Question: A was arrested on the strength of a warrant of arrest issued by the RTC in connection with an information for homicide. W, the live-in partner of A, filed a petition for habeas corpus against A's jailer and police investigators with the Court of Appeals. A. Does W have the personality to file the petition for habeas corpus? Answer: Yes. W, the live-in partner of A, has the personality to file the petition for habeas corpus because it may be filed by some person in his behalf, Sec. 3, Rule 102. B. Is the petition tenable? 1998 bar. Answer: No, the petition is not tenable because the warrant of arrest was issued by a court which had jurisdiction to issue it, Section 4 Rule 102. Question: Widow and her 2 children, both girls, aged 8 and 12 years old, reside in Angeles City, Pampanga. A leaves her 2 daughters in their house at night because she works in a brothel as a prostitute. Realizing the danger to the morals of these 2 girls, B, the father of the deceased husband of A, files a petition for habeas corpus against A for the custody of the girls in the family court in Angeles City. In said petition, B alleges that he is entitled to the custody of the 2 girls in the family court in Angeles City. In said petition, B alleges that he is entitled to the custody of the 2 girls because their mother is living a disgraceful life. The court issues the writ of habeas corpus. When A learns of the petition and the writ, she brings her 2 children to Cebu City. At the expense of B, the sheriff of the said family court goes to Cebu City and serves the writ on A. A files her comment on the petition raising the following defenses. A. The enforcement of the writ of habeas corpus in Cebu City is illegal, and answer. The writ of habeas corpus issued by the family court in Angeles City may not be legally enforced in Cebu City, because the writ is enforceable only within the judicial region to which the family court belongs, unlike the writ granted by the Supreme Court or Court of Appeals, which is enforceable anywhere in the Philippines. Section 20 of Rule of Custody of Minors and Writ of Habeas Corpus in relation to custody of minors, AM number 030404 SC. See also, Sec 4 Rule 102, Rules of Court. B. B has no personality to institute the petition. Resolve the petition in the light of the above defenses of A. 2003 bar. Answer. B. The father of the deceased husband of A, has the personality to institute the petition for habeas corpus of the 2 minor girls, because the grandparent has the right of custody as against the mother A, who is a prostitute. Section 2 and 13. Id. Question. Hercules was walking near a police station when a police officer signaled for him to approach. As soon as Hercules came near, the police officer frisked him, but the latter found no contraband. The police officer told Hercules to get inside the police station. Inside the police station, Hercules asked the police officer, "Sir, may problema po ba?" Instead of replying, the police officer locked up Hercules inside the police station jail. What is the remedy available to Hercules to secure his immediate release from detention? 2015 bar. Answer. The remedy available to Hercules is to file a petition for habeas corpus questioning the illegality of his warrantless arrest. The writ of habeas corpus shall extend to all cases of illegal confinement or detention by which any person is deprived of liberty. Section 1, Rule 102. Distinguish from writ of amparo and habeas data. Question. What is the writ of amparo? How is it distinguished from the writ of habeas corpus? 2009 bar. Answer. The petition for a writ of amparo is a remedy available to any person whose right to life, liberty and security is violated or threatened with violation by an unlawful act or omission of a public official or employee, or of a private individual or entity. The writ shall cover extralegal killings and enforced disappearances or threats thereof. The writ of amparo differs from a writ of habeas corpus in that the latter writ is availed of as a remedy against cases of unlawful confinement or detention by which any person is deprived of his liberty, or cases by which rightful custody of any person is withheld from another who is lawfully entitled thereto. Sec 1, Rule 102. Question. What is the writ of habeas data? 2009 bar. Answer. The writ of habeas data is a remedy available to any person whose right to privacy in life, liberty or security is violated or threatened by an unlawful act or omission of a public official or employee, or of a private individual or entity engaged in the gathering, collecting or storing of data or information regarding the person, family, home and correspondence of the aggrieved party. Rules on custody of minors and writ of habeas corpus in relation to custody of minors, AM number 030404 SC. Question. While Marietta was in her place of work in Makati City, Her estranged husband Carlo barged into her house in Parañaque City, abducted their 6-year-old son, Percival, and brought the child to his hometown in Baguio City. Despite Marietta's pleas, Carlo refused to return their child. Marietta, through counsel, filed a petition for habeas corpus against Carlo in the Court of Appeals in Manila to compel him to produce their son before the court and for her to regain custody. She alleged in the petition that despite her efforts, she could no longer locate her son. In his comment, Carlo alleged that the petition was erroneously filed in the Court of Appeals as the same should have been filed in the Family Court of Baguio City which, under Republic Act No. 8369, has exclusive jurisdiction over the petition. Marietta replied that under Rule 102 of the Rules of Court, as amended, the petition may be filed in the Court of Appeals and if granted, the writ of habeas corpus shall be enforceable anywhere in the Philippines. Whose contention is correct? Explain. 2005 Bar. Answer. Marietta's contention is correct. The Court of Appeals has concurrent jurisdiction with the family courts and the Supreme Court in petitions for habeas corpus where the custody of minors is at issue, notwithstanding the provision in the Family Courts Act, Republic Act 8369, that family courts have exclusive jurisdiction in such cases. Thornton v. Thornton, General Register No. 154598, August 16, 2004. Section 20, Par. 6 of SCAM No. March 4, 2004, 2003, provides, the petition may likewise be filed with the Supreme Court, Court of Appeals, or with any of its members and, if so granted, the writ shall be enforceable anywhere in the Philippines. The writ may be made returnable to a family court or to any regular court within the region where the petitioner resides or where the minor may be found for hearing and decision on the merits. Writ of Amparo. AM number 07912 SC. Question. Mayor Ronila is a junior officer of the Armed Forces of the Philippines who claims to have personally witnessed the malversation of funds given by U.S. authorities in connection with the Balakatan exercises. Mayor Ronila alleges that as a result of her exposé, there are operatives within the military who are out to kill her. She files a petition for the issuance of a writ of amparo against, among others, the Chief of Staff but without alleging that the latter ordered that she be killed. Attorney Duro, counsel for the Chief of Staff, moves for the dismissal of the petition for failure to allege that his client issued any order to kill or harm Mayor Ronila. Rule on Attorney Duro's motion. Explain. 2010 Bar. Answer. The motion to dismiss must be denied on the ground that it is a prohibited pleading under Section 11A of the Rule on the Writ of Amparo. Moreover, said rule does not require the petition therefore to allege a complete detail of the actual or threatened violation of the victim's rights. It is sufficient that there be an allegation of real threat against petitioner's life, liberty and/or security. General A. Reason Jr. v. Tagitis, General Register No. 182498, December 03 th 2009. Question. The residents of Mount Eloy, headed by Masigasig, formed a non-governmental organization, Alianza Laban sa Minahan sa Eloy, ALMA, to protest the mining operations of Oro Negro mining in the mountain. ALMA members picketed daily at the entrance of the mining site blocking the ingress and egress of trucks and equipment of Oro Negro, hampering its operations. Masigasig had an altercation with Mapasak arising from the complaint of the mining engineer of Oro Negro that one of their trucks was destroyed by ALMA members. Mapasak is the leader of the Association of Peacekeepers of Eloy, APKA, a civilian volunteer organization serving as auxiliary force of the local police to maintain peace and order in the area. Subsequently, Masigasig disappeared. Mayumi, the wife of Masigasig, and the members of ALMA searched for Masigasig, but all their efforts proved futile. Mapag Matiag, a member of ALMA, learned from Maine, a member of APKA, During their binge drinking that Masigasig was abducted by other members of UPCA, on order of Mapasok. Mayumi and Dalma sought the assistance of the local police to search for Masigasig, but they refused to extend their cooperation. Immediately, Mayumi filed with the RTC, a petition for the issuance of the writ of amparo against Mapasok and UPCA. Alma also filed a petition for the issuance of the writ of amparo with the Court of Appeals against Mapasok and UPCA. Respondents Mapasok and UPCA, in their return filed with the RTC, raised among their defenses that they are not agents of the state, hence, cannot be pleaded as respondents in an amparo petition. A. Is their defense tenable? Answer. The defense is not tenable. The writ of amparo is a remedy available to any person whose right to life, liberty and security has been violated or is threatened with violation by an unlawful act or omission of a public officer or employee or of a private individual or entity. The writ covers extralegal killings, enforced disappearances or threats thereof. Section 1. The rule on the writ of amparo, AM number 07912 SC. Moreover, the rules do not require that the respondents should be agents of the state in order to be pleaded as respondents in an amparo petition. Secretary of National Defense vs. Manalo, General Register number 180906, October 7, 2008. B. Respondents Mapasok and UPCA, in their return filed with the Court of Appeals, raised as their defense that the petition should be dismissed on the ground that Alma cannot file the petition because of the earlier petition filed by Mayumi with the RTC. Are respondents correct in raising their defense? Answer. Yes. The respondents are correct in raising the defense. Under Section 2C of the Rules on the Writ of Amparo, the filing of a petition by Mayumi who is an immediate member of the family of the aggrieved party already suspends the right of all other authorized parties to file similar petitions. Hence, Alma cannot file the petition because of earlier petition by Mayumi with the RTC. C. Mayumi later filed separate criminal and civil actions against Mapasok. How will the cases affect the amparo petition she earlier filed? 2015 bar. Answer. When a criminal action and separate civil action are filed subsequent to a petition for a writ of amparo, the latter shall be consolidated with the criminal action. After consolidation, the procedure under rule shall continue to apply to the disposition of the reliefs in the petition. Section 1. Id. Writ of habeas data. AM number 08116 SC. Question. Ozanith, the cashier of Temptation Investments Incorporated, Temptation Incorporated, with principal offices in Cebu City, is equally hated and loved by her co-employees because she extends cash advances or sales to her colleagues whom she likes. One morning, Ozanith discovers an anonymous letter inserted under the door of her office threatening to kill her. Ozanith promptly reports the matter to her superior Joshua, who thereupon conducts an internal investigation to verify the said threat. Claiming that the threat is real, Temptation Incorporated opts to transfer Ozanith to its Palawan office, a move she resists in view of the company's refusal to disclose the results of its investigation. Decrying the move as a virtual deprivation of her employment, Ozanith files a petition for the issuance of a writ of habeas data before the Regional Trial Court, RTC, to enjoin Temptation Incorporated from transferring her on the ground that the company's refusal to provide her with a copy of the investigation results compromises her right to life, liberty and privacy. Resolve the petition. Explain. 2010 bar. Answer. Ozanith's petition for the issuance of a writ of habeas data must be dismissed as there is no showing that her right to privacy in life, liberty or security is violated or threatened by an unlawful act or omission. Neither was the company shown to be engaged in the gathering, collecting nor storing of data or information regarding the person, family, home and correspondence of the aggrieved party. Section 1, Rule on the Writ of Habeas Data. Criminal Procedure. General Matters. Question. A was charged before the Sandiganbayan with a crime of plunder, a non-bailable offense, where the court had already issued a warrant for his arrest. Without a being arrested, his lawyer filed a motion to quash arrest warrant and to fix bail, arguing that the allegations in the information did not charge the crime of plunder but a crime of malversation, a bailable offense. The court denied the motion on the ground that it had not yet acquired jurisdiction over the person of the accused and that the accused should be under the custody of the court since the crime charged was non-bailable. The accused's lawyer counter-argued that the court can rule on the motion even if the accused was at large because it had jurisdiction over the subject matter of the case. According to said lawyer, there was no need for the accused to be under the custody of the court because what was filed was a motion to quash arrest and to fix bail, not a petition for bail. A. If you are the Sandiganbayan, how will you rule on the motion? Answer: I will grant the motion to quash the warrant of arrest but I will deny the motion to fix bail. A motion to fix bail is essentially an application for bail. People v. Bukalan, General Register No. 176933, October 2, 2009. Relative thereto, bail is the security for the release of the person in the custody of the law, Section 1, Rule 114. The rules use the word custody to signify that bail is only available for someone who is under the custody of the law. Peter Paul Di Machilak v. Honorable Cezinando v. Yon, General Register No. 127107, October 12, 1998. Hence, a cannot seek any judicial relief if he does not submit his person to the jurisdiction of the Sandiganbayan. On the other hand, the Sandiganbayan may grant the motion to quash the warrant of arrest. It is well settled that adjudication of a motion to quash a warrant of arrest requires neither jurisdiction over the person of the accused nor custody of law over the body of the accused. Otherwise stated, an accused can invoke the processes of the court, even custody of the law. Jose C. Miranda v. Virgilio M. Tulliel, General Register No. 158763, March 31, 2006. Thus, Sandiganbayan may grant the motion to quash the warrant of arrest. B. If the Sandiganbayan denies the motion, what judicial remedy should the accused undertake? 2014 Bar. Answer: the accused may file a motion for reconsideration. If the same is denied, the accused may resort to a petition for certiorari under Rule 65 directly to the Supreme Court. Question: Governor Pedro Mario of Tarlac was charged with indirect bribery before the Sandiganbayan for accepting a car in exchange of the award of a series of contracts for medical supplies. The Sandiganbayan, after going over the information, found the same to be valid and ordered the suspension of Mario. The latter contested the suspension, claiming that under the law, Section 13 of Republic Act 3019, his suspension is not automatic upon filing the information, and his suspension under Section 13 of Republic Act 3019 is in conflict with Section 5 of the Decentralization Act of 1967, Republic Act 5185. The Sandiganbayan overruled Mario's contention, stating that Mario's suspension under the circumstances is mandatory. Is the court's ruling correct? Why? 2001 Bar. Answer: yes. Mario's suspension is mandatory although not automatic. Section 13 of Republic Act No. 3019 in relation to Section 5 of Decentralization Act of 1967 or Republic Act No. 5185. It is mandatory after the determination of the validity of the information in a pre-suspension hearing. Segovia v. Sandiganbayan, General Register No. 124067, March 27, 1998. The purpose of suspension is to prevent the accused public officer from frustrating or hampering his prosecution by intimidating or influencing witnesses or tampering with evidence, or from committing further acts of malfeasance while in office. Jurisdiction of criminal courts. Question: Jose A., Alberto and Romeo were charged with murder. Upon filing of the information, the RTC judge issued the warrants for their arrest. Learning of the issuance of the warrants, the three accused jointly filed a motion for reinvestigation and for the recall of the warrants of arrest. On the date set for hearing of their motion, none of the accused showed up in court for fear of being arrested. The RTC judge denied their motion because the RTC did not acquire jurisdiction over the persons of the moveds. Did the RTC rule correctly? 2008 Bar. Answer: no. The court acquired jurisdiction over the person of the accused when they filed the aforesaid motion and invoked the court's authority over the case, without raising the issue of jurisdiction over their person. Their filing the motion is tantamount to voluntary submission to the court's jurisdiction and contributes voluntary appearance. Miranda v. Tulliel, General Register No. 158763, March 31, 2006. Question: in complex crimes, how is the jurisdiction of a court determined? 2003 Bar. Answer: in a complex crime, jurisdiction over the whole complex crime must be lodged with the trial court having jurisdiction to impose the maximum and most serious penalty imposable on an offense forming part of the complex crime. QUAMTO v. Garcia, General Register No. L 46934, April 15, 1988. Question: Mariano was convicted by the RTC for raping Victoria and meted the penalty of reclusion perpetua. While serving sentence at the National Penitentiary, Mariano and Victoria were married. Mariano filed a motion in said court for his release from the penitentiary on his claim that under Republic Act No. 8353, his marriage to Victoria extinguished the criminal action against him for rape, as well as the penalty imposed on him. However, the court denied the motion on the ground that it had lost jurisdiction over the case after its decision had become final and executory. A. Is the filing of the court correct? Explain. Answer: the court can never lose jurisdiction so long as its decision has not yet been fully implemented and satisfied. Finality of a judgment cannot operate to divest a court of its jurisdiction. The court retains an interest in seeing the proper execution and implementation of its judgments, and to that extent, may issue such orders necessary and appropriate for these purposes. Echegaray v. Secretary of Justice, General Register No. 13205, January 19, 1999. B. What remedies should the counsel of Mariano take to secure his proper and most expeditious release from the National Penitentiary? Explain. 2005 Bar. Answer: to secure the proper and most expeditious release of Mariano from the National Penitentiary, his counsel should file a petition for habeas corpus for the illegal confinement of Mariano, Rule 102, or b. a motion in court which convicted him, to nullify the execution of his sentence or the order of his commitment on the ground that a supervening development had occurred. Mello v. People, General Register No. L 3580, March 22, 1950, despite the finality of the judgment. When injunction may be issued to restrain criminal prosecution. Question: will the injunction lie to restrain the commencement of a criminal action? Explain. 1999 Bar. Answer: as a general rule, injunction will not lie to restrain a criminal prosecution except 1. To afford adequate protection to the constitutional rights of the accused. 2. When necessary for the orderly administration of justice or to avoid oppression or multiplicity of actions. 3. When double jeopardy is clearly apparent. 4. Where the charges are manifestly false and motivated by the lust for vengeance, and 5. Where there is clearly no prima facie a case against the accused and a motion to quash on that ground has been denied. See cases cited in Roberts, Jr. versus Court of Appeals, General Register No. 113930, March 5, 1996 and Brock vs. Ponce in Rio, General Register No. 69863-65, December 10, 1990. Prosecution of offenses. Question: distinguish a complaint from information. 1999 bar. Answer: in criminal procedure, a complaint is a sworn written statement charging a person with an offense, subscribed by the offended party, any peace officer or other peace officer charged with the enforcement of the law violated. Section 3, Rule 110, 1985 Rules of Criminal Procedure. While an information is an accusation in writing charging a person with an offense subscribed by the prosecutor and filed with the court. Section 4, id. Question: while in his Nissan Patrol and hurrying home to Quezon City from his work in Makati, Gary figured in a vehicular mishap along that portion of EDSA within the city of Mandaluyong. He was bumped from behind by a Ford Expedition SUV driven by Horace, who was observed using his cellular phone at the time of the collision. Both vehicles, more than 5 years old, no longer carried insurance other than a compulsory third-party liability insurance. Gary suffered physical injuries while his Nissan Patrol sustained damage in excess of Ph 500,000. A. As counsel for Gary, describe the process you need to undertake starting from the point of the incident. If Gary would proceed criminally against Horace, and identify the court with jurisdiction over the case. Answer: as counsel for Gary, I will first make him medically examined in order to ascertain the gravity and extent of the injuries he sustained from the accident. Second, I will secure a police report relative to the mishap. Third, I will ask him to execute his sinampang salsay. Thereafter, I will use his sinampang salsay or prepare a complaint affidavit and file the same in the office of the city prosecutor and later on to the appropriate MTC of Mandaluyong City for the crime of reckless imprudence resulting to physical injuries and damage to property. Section 1 and 15, Rule 110. B. If Gary chooses to file an independent civil action for damages, explain briefly this type of action, its legal basis, the different approaches in pursuing this type of action, the evidence you would need, and types of defenses you could expect. 2013 bar. Answer: an independent civil action is an action which is entirely distinct and separate from the criminal action. Such civil action shall proceed independently of the criminal prosecution and shall require only a preponderance of evidence. Section 3 of Rule 111 allows the filing of an independent civil action by the offended party based on Article 33 and 2176 of the new Civil Code. The different approaches that the plaintiff can pursue in this type of action are, as follows. 1. File the independent civil action and prosecute the criminal case separately. 2. File the independent civil action without filing the criminal case. 3. File the criminal case without need of reserving the independent civil action. Aside from the testimony of Gary, the pieces of evidence that would be required in an independent civil action are the medical report and certificate regarding the injuries sustained by Gary, hospital and medical bills including receipt of payments made, police report and proof of the extent of damage sustained by his car, and the affidavit of witnesses who saw Horace using his cellular phone at the time the incident happened. I will also present proof of employment of Gary such as his pay slip in order to prove that he was gainfully employed at the time of the mishap, and as a result of the injuries he suffered, he was not able to earn his usual income thereof. I will also present the attending doctor of Gary to corroborate and authenticate the contents of the medical report and abstract thereof. The evidence required to hold defendant Horace liable is only preponderance of evidence. The types of defenses that may be raised against this action are fortuitous event, force majeure or acts of God. The defendant can also invoke contributory negligence as partial defense. Moreover, the defendant can raise the usual defenses that the plaintiff will be entitled to double compensation or recovery, and B. Defendant will be constrained to litigate twice and therefore suffer the cost of litigation twice. Question. On his way to the plug-and-play academy in Silang, Cavite on board a public transport bus as a passenger, Police Inspector Masigasig of the Valenzuela Police witnessed an ongoing armed robbery while the bus was traversing Makati. His alertness and training enabled him to foil the robbery and to subdue the malefactor. He disarmed the felon and while frisking him, discovered another handgun tucked in his waist. He seized both handguns and the malefactor was later charged with the separate crimes of robbery and illegal possession of firearm. A. Where should Police Inspector Masigasig bring the felon for criminal processing? To Silang, Cavite where he is bound, to Makati where the bus actually was when the felonies took place, or back to Valenzuela where he is stationed? Which court has jurisdiction over the criminal cases? 2013 Bar. Answer. Police Inspector Masigasig should bring the felon to the nearest police station or jail in Makati City where the bus actually was when the felonies took place. Moreover, where an offense is committed in a public vehicle while in the course of its trip, the criminal action shall be instituted and tried in the court of any municipality or territory where such vehicle passed during its trip, including the place of its departure and arrival, Section 15b, Rule 110. Consequently, the criminal case for robbery and illegal possession of firearms can be filed in Regional Trial Court of Makati City or on any of the places of departure or arrival of the bus. Question. Yvonne, a young and lonely OFW, had an intimate relationship abroad with a friend, Percy. Although Yvonne comes home to Manila every 6 months, her foreign postings still left her husband Dario lonely so that he also engaged in his own extramarital activities. In one particularly exhilarating session with his girlfriend, Dario died. Within 180 days from Dario's death, Yvonne gives birth in Manila to a baby boy. Irate relatives of Dario contemplate criminally charging Yvonne for adultery and they hire your law firm to handle the case. A. Is the contemplated criminal action a viable option to bring? Answer. Section 5 of Rule 110 provides that the crimes of adultery and concubinage shall not be prosecuted except upon complaint by the offended spouse. Since the offended party is already dead, then the criminal action for adultery as contemplated by offended party's relatives is no longer viable. B. Is a civil action to impugn the paternity of the baby boy feasible, and if so, in what proceeding may such issue be determined? 2013 Bar. Answer. Yes, under Article 171 of the Family Code, the heirs of the husband may impugn the filiation of the child in the following cases. 1. If the husband should die before the expiration of the period fixed for bringing his action. 2. If he should die after the filing of the complaint, without having desisted therefrom, or 3. If the child was born after the death of the husband. Since Dario is already dead when the baby boy was born, his heirs have the right to impugn the filiation of the child. Consequently, the heirs may impugn the filiation either by a direct action to impugn such filiation or raise the same in a special proceeding for settlement of the estate of the decedent. In the said proceeding, the probate court has the power to determine questions as to who are the heirs of the decedent. Reyes v. Sip, et al., General Register No. L7516, May 12, 1955. Jimenez v. Intermediate Appellate Court, General Register No. 75773, April 17, 1990. Incidentally, the heirs can also submit the baby boy for DNA testing, Rules on DNA Evidence, AM No. 6115 SC, or even blood test in order to determine paternity and filiation. In J. Al v. Court of Appeals, General Register No. L49162, July 28, 1987, the Supreme Court held that blood grouping tests are conclusive as to non-paternity, although inconclusive as to paternity. The fact that the blood type of the child is a possible product of the mother and alleged father does not conclusively prove that the child is born by such parents, but, if the blood type of the child is not the possible blood type when the blood of the mother and that of the alleged father are cross-matched, then the child cannot possibly be that of the alleged father. Question: Your friend Yi, an orphan, 16 years old, seeks your legal advice. She tells you that ZZ, her uncle, subjected her to acts of lasciviousness, that when she told her grandparents, they told her to just keep quiet and not to file charges against ZZ, their son. Feeling very much aggrieved, she asks you how her uncle ZZ can be made to answer for his crime. A. What would your advice be? Explain. Answer: I would advise the minor, an orphan of 16 years of age, to file the complaint herself independently of her grandparents, because she is not incompetent or incapable of doing so upon grounds other than her minority. Section 5, Rule 110. B. Suppose the crime committed against Yi by her uncle ZZ is rape, witnessed by your mutual friend 20. But this time, Yi was prevailed upon by her grandparents not to file charges. 20 asks you if she can initiate the complaint against ZZ. Would your answer be the same? Explain. 2000 bar. Answer: Since rape is now classified as a crime against persons under the Anti-Rape Law of 1997, Republic Act 8353, I would advise 20 to initiate the complaint against ZZ. Question: X was arrested, in flagranti, for robbing a bank. After an investigation, he was brought before the office of the prosecutor for inquest, but unfortunately no inquest prosecutor was available. May the bank directly file the complaint with the proper court? If in the affirmative, what document should be filed? 2012 bar. Answer: Yes, the bank may directly file the complaint with the proper court. In the absence or unavailability of an inquest prosecutor, the complaint may be filed by the offended party or a peace officer directly with the proper court on the basis of the affidavit of the offended party or arresting officer or person. Section 6, Rule 12. Designation of offense. Question: The prosecution filed an information against Jose for slight physical injuries alleging the acts constituting the offense but without any more alleging that it was committed after Jose's unlawful enter in the complainant's abode. Was the information correctly prepared by the prosecution? Why? 2001 bar. Answer: Number the aggravating circumstance of unlawful entry in the complainant's abode has to be specified in the information, otherwise, it cannot be considered as aggravating. Section 8, Rule 110. Amendment or substitution of complaint or information. Question: A, D and E were charged with homicide in one information. Before they could be arraigned, the prosecution moved to amend the information to exclude E therefrom. Can the court grant the motion to amend? Why? 2001, 2002 bar. Answer: Yes, provided notice is given to the offended party and the court states its reasons for granting the same. Section 14, Rule 110. B. On the facts above stated, suppose the prosecution, instead of filing a motion to amend, moved to withdraw the information altogether and its motion was granted. Can the prosecution refile the information although this time for murder? Explain. Answer: Yes, the prosecution can refile the information for murder and substitution of the information for homicide because no double jeopardy has yet attached. Galvez v. Court of Appeals, General Register No. 114046, October 24, 1994. Question: A was accused of homicide for the killing of B. During the trial, the public prosecutor received a copy of the marriage certificate of A and B. A. Can the public prosecutor move for the amendment of the information to charge A with the crime of parricide? Answer: Number the information cannot be amended to change the offense charged from homicide to parricide. Fiercely, The marriage is not a supervening fact arising from the act constituting the charge of homicide, Section 8, Rule 110. b. Suppose instead of moving for the amendment of the information, the public prosecutor presented in evidence the marriage certificate without objection on the part of the defense, could A be convicted of parricide? 1997 bar. Answer. Number A can be convicted only of homicide, not of parricide, which is a graver offense. The accused has the constitutional rights of due process and to be informed of the nature and the cause of the accusation against him, Section 1, 14(1), and 2, Art. 3, 1987 Constitution. Prosecution of civil action. Question. While cruising on a highway, a taxicab driven by Mans hit an electric post. As a result thereof, its passenger, Joe V., suffered serious injuries. Mans was subsequently charged before the municipal trial court with reckless imprudence resulting in serious physical injuries. Thereafter, Joe V. filed a civil action against Lord, the owner of the taxicab, for breach of contract, and Mans for quasi-delict. Lord and Mans filed a motion to dismiss the civil action on the ground of litis pendentia, that is, the pendency of the civil action impliedly instituted in the criminal action for reckless imprudence resulting in serious physical injuries. Resolve the motion with reasons. 2005 bar. Answer. The motion to dismiss should be denied. The action for breach of contract against the taxicab owner cannot be barred by the criminal action against the taxicab driver, although the taxicab owner can be held subsidiarily liable in the criminal case, if the driver is insolvent. On the other hand, the civil action for quasi-delict against the driver is an independent civil action under Article 33 of the Civil Code and Section 3, Rule 111 of the Rules of Court, which can be filed separately and can proceed independently of the criminal action and regardless of the result of the latter. Sampson v. DeWay, General Register Nos. 160,054-55, July 21, 2004. Question. Name two instances where the trial court can hold the accused civilly liable even if he is acquitted. 2002, 2010 bar. Answer. The instances where the civil liability is not extinguished despite acquittal of the accused are: 1. Where the acquittal is based on reasonable doubt. 2. Where the court expressly declares that the liability of the accused is not criminal but only civil in nature, and 3. Where the civil liability is not derived from or based on the criminal act of which the accused is acquitted. Remedias Notice AP Republic Act vs. Court of Appeals, General Register No. 128,927, September 14, 1999. Question. In an action for violation of Batas Pambansabalang 22, the court granted the accused's demurrer to evidence which he filed without leave of court. Although he was acquitted of the crime charged, he, however, was required by the court to pay the private complainant the face value of the check. The accused filed a motion of reconsideration regarding the order to pay the face value of the check on the following grounds. A. The demurrer to evidence applied only to the criminal aspect of the case, 2001 bar, and Answer. The motion for reconsideration should be denied. The ground that the demurrer to evidence applied only to the criminal aspect of the case was not correct because the criminal action for violation of Batas Pambansabalang 22 included the corresponding civil action, Section 1B, Rule 111. B. At the very least, he was entitled to adduce controverting evidence on the civil liability. Resolve the motion for reconsideration, 2003 bar. Answer. The accused was not entitled to adduce controverting evidence on the civil liability, because he filed his demurrer to evidence without leave of court, Section 23, Rule 119. Prejudicial question. Question. Allegedly sold to B a parcel of land which A later also sold to X. B. Brought a civil action for nullification of the second sale and asked that the sale made by A in his favor be declared valid. A. Theorized that he never sold the property to B and his purported signatures appearing in the first deed of sale were forgeries. Thereafter, an information for estofa was filed against A based on the same double sale that was the subject of the civil action. A. Filed a motion for suspension of action in the criminal case, contending that the resolution of the issue in civil case would necessarily be determinative of his guilt or innocence. Is the suspension of the criminal action in order? Explain. 1999, 2000 bar. Answer: yes. The suspension of the criminal action is in order because the defense of A in civil action, that he never sold the property to B and that his purported signatures in the first deed of sale were forgeries, is a prejudicial question the resolution of which is determinative of his guilt or innocence. If the first sale is null and void, there would be no double sale and A would be innocent of the offense of estofa. Rass vs. Rassel, General Register Nos. L. 50441-42 September 18, 1980. Question: Solomon and Faith got married in 2005. In 2010, Solomon contracted a second marriage with Hope. When Faith found out about the second marriage of Solomon and Hope, she filed a criminal case for bigamy before the Regional Trial Court, RTC, of Manila sometime in 2011. Meanwhile, Solomon filed a petition for declaration of nullity of his first marriage with Faith in 2012, while the case for bigamy before the RTC of Manila is ongoing. Subsequently, Solomon filed a motion to suspend the proceedings in the bigamy case on the ground of prejudicial question. He asserts that the proceedings in the criminal case should be suspended because if his first marriage with Faith will be declared null and void, it will have the effect of exculpating him from the crime of bigamy. Decide. 2014 bar. Answer: the motion filed by Solomon should be denied. The elements of prejudicial question are: 1. The previous instituted civil action involves an issue similar or intimately related to the issue determines the subsequent criminal action, and 2. The resolution of such issue determines whether or not the criminal action may proceed. In order for a prejudicial question to exist, the civil action must precede the filing of the criminal action. Dreamwork Construction Incorporated vs. Janiola, General Register Number 184861, June 30, 2009. Since the criminal case for bigamy was filed ahead of the civil action for declaration of nullity of marriage, there is no prejudicial question. At any rate, the outcome of the civil case for annulment has no bearing upon the determination of the guilt or innocence of the accused in the criminal case for bigamy because the accused has already committed the crime of bigamy when he contracted the second marriage without the first marriage having been declared null and void. Otherwise stated, he who contracts marriage during the subsistence of a previously contracted marriage runs the risk of being prosecuted for bigamy. Preliminary investigation. Question: Regional Director AG of the Department of Public Works and Highways was charged with violation of Section 3A of Republic Act No. 3019 in the Office of the Ombudsman. An administrative charge for gross misconduct arising from the transaction's subject matter of said criminal case was filed against him in the same office. The Ombudsman assigned a team composed of investigators from the Office of the Special Prosecutor and from the Office of the Deputy Ombudsman for the Military to conduct a joint investigation of the criminal case and the administrative case. The team of investigators recommended to the Ombudsman that AG be preventively suspended for a period not exceeding 6 months on its finding that the evidence of guilt is strong. The Ombudsman issued the said order as recommended by the investigators. AG moved to reconsider the order on the following grounds: A. The Office of the Special Prosecutor had exclusive authority to conduct a preliminary investigation of the criminal case. B. The order for his preventive suspension was premature because he has yet to file his answer to the administrative complaint and submit countervailing evidence. And C. He was Career Executive Service Officer, and under Presidential Decree No. 807, Civil Service Law, his preventive suspension shall be for a maximum period of 3 months. Resolved with reasons the motion of Respondent AG. 2005 bar. Answer: the motion should be denied for the following reasons. 1. The Office of the Special Prosecutor does not have exclusive authority to conduct a preliminary investigation of the criminal case, but it participated in the investigation together with the Deputy Ombudsman for the military, who can handle cases of civilians and is not limited to the military. 2. The order of preventive suspension need not wait for the answer to the administrative complaint and the submission of countervailing evidence. Garcia v. Mojica, General Register No. 13903, September 10, 1999. Question: X, an Undersecretary of DENR, was charged before the Sandiganbayan for malversation of public funds allegedly committed when he was still the mayor of a town in Rizal. After arraignment, the prosecution moved that X be preventively suspended. X opposed the motion, arguing that he was now occupying a position different from that which the information charged him, and therefore, there is no more possibility that he can intimidate witnesses and hamper the prosecution. Decide. Suppose X files a motion to quash challenging the validity of the information and the Sandiganbayan denies the same, will there still be a need to conduct a pre-suspension hearing? Explain. 2012 bar. Answer: there is no necessity for the court to conduct pre-suspension hearing. Under Section 13 of Republic Act No. 3019, an incumbent public officer against whom any criminal prosecution under a valid information for graft-related crimes such as malversation is pending in court, shall be suspended from office. The word office, from which the public officer charged shall be preventively suspended, could apply to any office which he might currently be holding and not necessarily the particular office under which he was charged. Thus, the DENR Undersecretary can be preventively suspended even though he was a mayor, when he allegedly committed malversation. Settled is the rule that where the accused files a motion to quash the information or challenges the validity thereof, a show cause order of the trial court would no longer be necessary. What is indispensable is that the trial court duly hear the parties at a hearing held for determining the validity of the information, and thereafter hand down its ruling, issuing the corresponding order of suspension should it uphold the validity of the information. Luciano v. Mariano, General Register No. L 32950, July 30, 1971. Since a pre-suspension hearing is basically a due process requirement, when an accused public official is given an adequate opportunity to be heard on his possible defenses against the mandatory suspension under Republic Act No. 3019, then an accused would have no reason to complain that no actual hearing was conducted. Miguel v. The Honorable Sandiganbayan, General Register No. 172035. July 04th 2012. In the fact given, the DENR Undersecretary was already given opportunity to question the validity of the information for malversation by filing a motion to quash, and yet, the Sandiganbayan sustained its validity. There is no necessity for the court to conduct pre-suspension hearing to determine for the second time the validity of the information for purpose of preventively suspending the accused. Question: you are the defense counsel of Angela Bituin, who has been charged under Republic Act 3019, Anti-Graft and Corrupt Practices Act, before the Sandiganbayan. While Angela has posted bail, she has yet to be arraigned. Angela revealed to you that she has not been investigated for any offense and that it was only when police officers showed up at her residence with a warrant of arrest that she learned of the pending case against her. She wonders why she has been charged before the Sandiganbayan when she is not in government service. A. What before-trial remedy would you invoke in Angela's behalf to address the fact that she had not been investigated at all, and how will you avail of this remedy? Answer: I will file a motion for the conduct of preliminary investigation or reinvestigation in the quash law or recall of the warrant of arrest in the court where the case is pending with an additional prayer to suspend the arraignment. Under Section 6, Rule 112 of the Rules of Court, after filing of the complaint or information in court without a preliminary investigation, the accused may within 5 days from the time he learns of its filing ask for a preliminary investigation with the same right to adduce evidence in his defense. Moreover, Section 26, Rule 114 of the Rules of Criminal Procedure provides that an application for admission to bail shall not bar the accused from challenging the validity of his arrest or the legality of the warrant issued therefor, or from assailing the regularity or questioning the absence of a preliminary investigation of the charge against him, provided that he raises them before entering his plea. The court shall resolve the matter as early as practicable but not later than the start of the trial of the case. B. What during trial remedy can you use to allow an early evaluation of the prosecution evidence without the need of presenting defense evidence? When and how can you avail of this remedy? 2013 Bar. Answer: I will file first a motion for leave to file a demurrer within 5 days from the time the prosecution rested its case. If the same is granted, then I will now file a demurrer to evidence within 10 days. Section 23, Rule 119. This remedy would allow the evaluation of the sufficiency of prosecution's evidence without the need of presenting defense evidence. It may be done through the court's initiative or upon motion of the accused and after the prosecution rested its case. Section 23, Rule 119. Question: On his way to the Plug-and-Play Academy in Silang, Cavite on board a public transport bus as a passenger, Police Inspector Masigasig of the Valenzuela Police witnessed an ongoing armed robbery while the bus was traversing Makati. His alertness and training enabled him to foil the robbery and to subdue the malefactor. He disarmed the felon and while frisking him, discovered another handgun tucked in his waist. He seized both handguns and the malefactor was later charged with the separate crimes of robbery and illegal possession of firearm. May the charges of robbery and illegal prosecution of firearm be filed directly by the investigating prosecutor with the appropriate court without a preliminary investigation? 2013 Bar. Answer: Yes. Since the offender was arrested in flagrante delicto without a warrant of arrest, an inquest proceeding should be conducted and thereafter a case may be filed in court even without the requisite preliminary investigation. Under Section 7, Rule 112, when a person is lawfully arrested without a warrant involving an offense which requires preliminary investigation, the complaint or information may be filed by a prosecutor without the need of such investigation provided an inquest has been conducted in accordance with existing rules. In the absence or unavailability of an inquest prosecutor, the complaint may be filed by the offended party or a peace officer directly with the proper court on the basis of the affidavit of the offended party or arresting officer or person. Arrest. Question: As Cicero was walking down a dark alley one midnight, he saw an owner-type jeepney approaching him. Sensing that the occupants of the vehicle were up to no good, he darted into a corner and ran. The occupants of the vehicle minus elements from the Western Police District minus gave chase and apprehended him. The police apprehended Cicero, frisked him and found a sachet of 0.09 gram of shabu tucked in his waist and a Swiss knife in his secret pocket, and detained him thereafter. Is the arrest and body search illegal? 2010 Bar. Answer: The arrest and the body search were not legal. Cicero's act of running does not show any reasonable ground to believe that a crime has been committed or is about to be committed for the police officers to apprehend him and conduct body search. Hence, the arrest was illegal as it does not fall under any of the circumstances for a valid warrantless arrest provided in Section 5, Rule 113 of the Rules of Criminal Procedure. Question: Axe swindled Ryan the amount $10,000 sometime in mid-2003. On the strength of the sworn statement given by Rai personally to SPO11 Ramos sometime in mid-2004, and without securing a warrant, the police officer arrested Axe. Forthwith the police officer filed with the city prosecutor of Manila a complaint for estofa supported by Rai's sworn statement and other documentary evidence. After due inquest, the prosecutor filed the requisite information with the MRTC. No preliminary investigation was conducted either before or after the filing of the information, and the accused at no time asked for such an investigation. However, before arraignment, the accused moved to quash the information on the ground that the prosecutor suffered from a want of authority to file the information because of his failure to conduct a preliminary investigation before filing the information, as required by the rules of court. A. Is the warrantless arrest of Axe valid? Answer. Number the warrantless arrest is not valid because the alleged offense has not just been committed. The crime was allegedly committed 1 year before the arrest, Section 5, B, Rule 113. B. Is he entitled to a preliminary investigation before the filing of the information? Explain. 2004 Bar. Answer. Yes. He is entitled to a preliminary investigation because he was not lawfully arrested without a warrant, see, Section 7, Rule 112. He can move for a reinvestigation. Question. A was killed by B during a quarrel over a hostess in a nightclub. 2 days after the incident, and upon complaint of the widow of A, the police arrested B without a warrant of arrest and searched his house without a search warrant. A. Can the gun used by B in shooting A, which was seized during the search of the house of B, be admitted in evidence? Answer. Number the gun seized during the search of the house of B without a search warrant is not admissible in evidence, Section 2 and 3-2, Art. 3, 1987 Constitution. Moreover, the search was not an incident to a lawful arrest of a person under Section 13. Rule 126. B. Is the arrest of B legal? Answer. Number a warrantless arrest requires that the crime has in fact just been committed and the police arresting has personal knowledge of facts that the person to be arrested has committed it, Section 5, Rule 113. Here, the crime has not just been committed since a period of 2 days had already lapsed, and the police arresting has no such personal knowledge because he was not present when the incident happened. Go vs. Court of Appeals, General Register Number 101837, February 11, 1992. C. Under the circumstances, can B be convicted of homicide? 1997 Bar. Answer. Yes. The gun is not indispensable in the conviction of A because the court may rely on testimonial or other evidence. Question. In a buy-bust operation, the police operatives arrested the accused and seized from him a sachet of shabu and an unlicensed firearm. The accused was charged in 2 informations, one for violation of the Dangerous Drug Act, as amended, and another for illegal possession of firearms. The accused filed an action for recovery of the firearm in another court against the police officers with an application for the issuance of a writ of replevin. He alleged in his complaint that he was a military informer who had been issued a written authority to carry said firearm. The police officers moved to dismiss the complaint on the ground that the subject firearm was in custodia legis. The court denied the motion and instead issued the writ of replevin. A. Was the seizure of the firearm valid? Answer. Yes. The seizure of the firearm was valid because it was seized in the course of a valid arrest in a buy-bust operation, Sections 12 and 13, Rule 126. A search warrant was not necessary, People v. Salazar, General Register Number 98060, January 27, 1997. B. Was the denial of the motion to dismiss proper? 2003 Bar. Answer. Number the denial of the motion to dismiss was not proper. The court had no authority to issue the writ of replevin whether the firearm was in custodia legis or not. The motion to recover the firearm should be filed in the court where the criminal action is pending. Question: Field goal was arrested without a warrant by policemen while he was walking in a busy street. After the preliminary investigation, he was charged with rape and the corresponding information was filed in the RTC. On arraignment, he pleaded not guilty. Trial on the merits ensued. The court rendered judgment convicting him. On appeal, Field goal claims that the judgment is void because he was illegally arrested. If you were the Solicitor General, counsel, for the people of the Philippines, how would you refute said claim? 2000 bar. Answer: Any objection to the illegality of the arrest of the accused without a warrant is deemed waived when he pleaded not guilty at the arraignment without raising the question. It is too late to complain about a warrantless arrest after trial is commenced and completed and a judgment of conviction rendered against the accused. People v. Cabals, General Register No. 112035, January 16, 1998. Question: Under Section 5, Rule 113, a warrantless arrest is allowed when an offense has just been committed and the peace officer has probable cause to believe, based on his personal knowledge of facts and circumstances, that the person to be arrested has committed it. A policeman approaches you for advice and asks you how he will execute a warrantless arrest against a murderer who escaped after killing a person. The policeman arrived 2 hours after the killing and a certain Max was allegedly the killer per information given by a witness. He asks you to clarify the following. A. How long after the commission of the crime can he still execute the warrantless arrest? B. What does personal knowledge of the facts and circumstances that the person to be arrested committed it mean? 2016 bar. Answer. A. In executing a warrantless arrest under Section 5, Rule 113, the Supreme Court held that the requirement that an offense has just been committed means that there must be a large measure of immediacy between the time the offense was committed and the time of the arrest. Joey M. Pestillos v. Moreno Generoso, General Register No. 182601, November 10, 2014. If there was an appreciable lapse of time between the arrest and the commission of the crime, a warrant of arrest must be secured. In any case, personal knowledge by the arresting officer is an indispensable requirement to the validity of a valid warrantless arrest. The exact period varies on a case-to-case basis. In People v. Gurandy, General Register No. 95847-48, March 10, 1993, the Supreme Court ruled that a warrantless arrest was validly executed upon the accused 3 hours after the commission of the crime. In People v. Donog Jr., General Register No. 94533, February 4, 1992, the Supreme Court likewise upheld the valid warrantless arrest which was executed on the same day as the commission of the crime. However, in People v. El Rosario, 365 Philippines 292, 1999, the Supreme Court held that the warrantless arrest effected a day after the commission of the crime is invalid. In Go v. Court of Appeals, General Register No. 101837, February 11, 1992, the Supreme Court also declared invalid a warrantless arrest effected 6 days after the commission of the crime. B. The phrase personal knowledge of the facts and circumstances that the person to be arrested committed it means that matters in relation to the supposed commission of the crime were within the actual perception, personal evaluation or observation of the police officer at the scene of the crime. Thus, even though the police officer has not seen someone actually fleeing, he could still make a warrantless arrest if, based on his personal evaluation of the circumstances at the scene of the crime, he could determine the existence of probable cause that the person sought to be arrested has committed the crime. However, The determination of probable cause and the gathering of facts or circumstances should be made immediately after the commission of the crime in order to comply with the element of immediacy. The arresting officer's determination of probable cause under Section 5B, Rule 113 of the Revised Rules of Criminal Procedure is based on his personal knowledge of the facts or circumstances that the person sought to be arrested has committed the crime. These facts or circumstances pertain to actual facts or raw evidence, that is, supported by circumstances sufficiently strong in themselves to create the probable cause of guilt on the person to be arrested. A reasonable suspicion therefore must be founded on probable cause, coupled with good faith on the part of the peace officers making the arrest. The probable cause to justify warrantless arrest ordinarily signifies a reasonable ground of suspicion supported by circumstances sufficiently strong in themselves to warrant a cautious man to believe that the person accused is guilty of the offense with which he is charged, or an actual belief or reasonable ground of suspicion, based on actual facts. Joey Empestilos vs. Moreno Generizzo, General Register No. 182601. November 10, 2014. Determination of probable cause and issuance of warrant of arrest. Question: An information for murder was filed against Trapido. The RTC judge, after personally evaluating the prosecutor's resolution, documents and parties' affidavits submitted by the prosecutor, found probable cause and issued a warrant of arrest. Rapido's lawyer examined the RALO of the case and found that it only contained the copy of the information, the submissions of the prosecutor and a copy of the warrant of arrest. Immediately, Rapido's counsel filed a motion to quash the arrest warrant for being void, citing as grounds: 1. The judge before issuing the warrant did not personally conduct the searching examination of the prosecution witnesses in violation of his client's constitutionally mandated rights. 2. There was no prior order finding probable cause before the judge issued the arrest warrant. May the warrant of arrest be quashed on the grounds cited by Rapido's counsel? State your reason for each ground. 2015 bar. Answer: No, the warrant of arrest may not be quashed based on the grounds cited by Rapido's counsel. In the issuance of warrant of arrest, the mandate of the Constitution is for the judge to personally determine the existence of probable cause. The words personal determination was interpreted by the Supreme Court in Sullivan v. Mackay, General Register No. 82585, November 14, 1988. As the exclusive and personal responsibility of the issuing judge to satisfy himself as to the existence of probable cause. What the law requires as personal determination on the part of a judge is that he should not rely solely on the report of the investigating prosecutor. Thus, personal examination of the complainant and his witnesses is, thus, not mandatory and indispensable in the determination of probable cause for the issuance of a warrant of arrest. People v. Joseph Jojo Gray, General Register No. 10109, July 26, 2010. At any rate, there is no law or rule that requires the judge to issue a prior order finding probable cause before the issuance of a warrant of arrest. Bail. Question: After Alma had started serving her sentence for violation of Batas Pambansabalang 22, BP 22, she filed a petition for a writ of habeas corpus, citing Vaca vs. CA where the sentence of imprisonment of a party found guilty of violation of BP 22 was reduced to a fine equal to double the amount of the check involved. She prayed that her sentence be similarly modified and that she be immediately released from detention. In the alternative, she prayed that pending determination on whether the Vaca ruling applies to her, she be allowed to post bail pursuant to Rule 102, Section 14, which provides that if a person is lawfully imprisoned or restrained on a charge of having committed an offense not punishable by death, he may be admitted to bail in the discretion of the court. Accordingly, the trial court allowed Alma to post bail and then ordered her release. In your opinion, Is the order of the trial court correct? A. Under Rule 102? Answer. Number Section 4, Rule 102 of the Rules of Court, habeas corpus, does not authorize a court to discharge by writ of habeas corpus a person charged with or convicted of an offense in the Philippines, or of a person suffering imprisonment under lawful judgment. B. Under the Rules of Criminal Procedure? 2008 Bar. Answer. Number the trial court's order releasing Alma on bail even after judgment against her has become final and in fact she has started serving sentence, is a brazen disregard of the mandate in Section 24, Revised Rules of Criminal Procedure that, in no case shall bail be allowed after the accused has commenced to serve sentence. People v. Fitzgerald, General Register No. 149723. October 27, 2006. Question. When is bail a matter of right and when is it a matter of discretion? 1999, 2006 Bar. Answer. Bail is a matter of right, a. Before or after conviction by the Metropolitan Trial Court, Municipal Trial Court in cities, or Municipal Circuit Trial Court, b. Before conviction by the Regional Trial Court of an offense not punishable by death, reclusion perpetua, or life imprisonment, Section 4, Rule 114, and, c. If the charge involves a capital offense and the evidence of guilt is not strong, Section 7, Rule 114. Bail is a matter of discretion upon conviction by the Regional Trial Court of an offense not punishable by death, reclusion perpetua, or life imprisonment, Section 5, Rule 114. Question. When the accused is entitled as a matter of right to bail, may the court refuse to grant him bail on the ground that there exists a high degree of probability that he will abscond or escape? Explain. 1999 Bar. Answer. If bail is a matter of right, it cannot be denied on the ground that there exists a high degree of probability that the accused will abscond or escape. What the court can do is to increase the amount of the bail. One of the guidelines that the judge may use in fixing a reasonable amount of bail is the probability of the accused appearing in trial, Section 9G, Rule 114, as amended by Circular No. 1294. Question. At the public attorney's office station in Taguig where you are assigned, your work requires you to act as public defender at the local regional trial court and to handle cases involving indigents. In one other case, an indigent mother seeks assistance for her 14-year-old son who has been arrested and detained for malicious mischief. Would an application for bail be the appropriate remedy or is there another remedy available? Justify your chosen remedy and outline the appropriate steps to take. 2013 Bar. Answer. Yes. An application for bail is an appropriate remedy to secure provisional remedy of the 14-year-old boy. Under the rules, bail is a matter of right before or even after conviction before the MTC which has jurisdiction over the crime of malicious mischief, Section 4, Rule 114. Consequently, bail can be posted as a matter of right. Question. A was charged with murder in the lower court. His petition for bail was denied after a summary hearing on the ground that the prosecution had established a strong evidence of guilt. No motion for reconsideration was filed from the denial of the petition for bail. During the reception of the evidence of the accused reiterated his petition for bail on the ground that the witnesses so far presented by the accused had shown that no qualifying aggravating circumstance attended the killing. The court denied the petition on the grounds that it had already ruled that, I, the evidence of guilt is strong, 2. The resolution for the petition for bail is solely based on the evidence presented by the prosecution, and, 3. No motion for reconsideration was filed from the denial of the petition for bail. A. If you are the judge, how will you resolve the incident? Answer. If I were the judge, I would grant the second petition for bail. Under Section 7, Rule 114, Rules of Court. No person charged with a capital offense, or an offense punishable by reclusion perpetua or life imprisonment, shall be admitted to bail when evidence of guilt is strong, regardless of the stage of the criminal prosecution. In this case, the evidence of guilt for the crime of murder is not strong, as shown by the prosecution's failure to prove the circumstance that will qualify the crime to, and consequently convict the accused of, murder. Accordingly, the accused should be allowed to post bail because the evidence of his guilt is no strong. Section 13, Art. 3, 1987 Constitution. Besides, it is settled that an order granting bail is merely interlocutory which cannot attain finality. Palmer v. People, G. R. No. 141805, July 8, 2015. B. Suppose the accused is convicted of the crime of homicide and the accused filed a notice of appeal. Is he entitled to bail? 2014 Bar. Answer: yes. The accused is entitled to bail subject to the discretion of the court. Under Section 5, Rule 114, Rules of Court, the appellate court may allow him to post bail because the trial court in convicting him changed the nature of the offense from non-bailable to bailable. Be that as it may, the denial of bail pending appeal is a matter of wise discretion since after conviction by the trial court, the presumption of innocence terminates and, accordingly, the constitutional right to bail ends. Jose Antonio Levist v. Court of Appeals, General Register No. 189122, March 17, 2010. Hearing application for bail in capital offenses. Question: D was charged with murder, a capital offense. After arraignment, he applied for bail. The trial court ordered the prosecution to present its evidence in full on the ground that only on the basis of such presentation could it determine whether the evidence of D's guilt was strong for purposes of bail. Is the ruling correct? Why? 2002 Bar. Answer: no. The prosecution is only required to present as much evidence as is necessary to determine whether the evidence of D's guilt is strong for purposes of bail. Section 8, Rule 114. Question: in an information charging them of murder, policemen A, B and C were convicted of homicide. A appealed from the decision but was denied. Finally, the Court of Appeals rendered a decision acquitting A on the ground that the evidence pointed to the NPA as the killers of the victim. A. Was the Court of Appeals' denial of A's application for bail proper? Answer: yes, the Court of Appeals properly denied A's application for bail. The court had the discretion to do so. Although A was convicted of homicide only, since he was charged with a capital offense, on appeal he could be convicted of the capital offense. Obosa v. Court of Appeals, General Register No. 114350, January 16, 1997. B. Can B and C be benefited by the decision of the Court of Appeals? 1998 Bar. Answer: B, who did not appeal, can be benefited by the decision of the Court of Appeals which is favorable and applicable to him. Section 11A, Rule 122. The benefit will also apply to C even if his appeal is dismissed because of his escape. Question: if an information was filed in the RTC Manila charging D with homicide and he was arrested in Quezon City, in what court or courts may he apply for bail? Explain. 2002 Bar. Answer: D may apply for bail in the RTC Manila where the information was filed or in the RTC Quezon City where he was arrested, or if no judge thereof is available, with any metropolitan trial judge, municipal trial judge or municipal circuit trial judge therein. Section 17, Rule 114. Question: in what forms may bail be given? 1999 Bar. Answer: bail may be given by a corporate surety, or through a property bond, cash deposit or recognizance. Section 1, Rule 114. Question: RP and State 20 have a subsisting extradition treaty. Pursuant thereto, RP's Secretary of Justice, SOJ, filed a petition for extradition before the MRTC alleging that Juan Quan is the subject of an arrest warrant duly issued by the proper criminal court of State 20 in connection with a criminal case for tax evasion and fraud before his return to RP as a Balikbayan. Petitioner prays that Juan be extradited and delivered to the proper authorities of State 20 for trial, and that to prevent Juan's flight in the interim, a warrant for his immediate arrest be issued. Before the RTC could act on the petition for extradition, Juan filed before it an urgent motion, in sum praying, 1. That SOJ's application for an arrest warrant be set for hearing and, 2. That Juan be allowed to post bail in the event the court would issue an arrest warrant. Should the court grant or deny Juan's prayer? Reason. 2004 bar. Answer. In this case, the court reviewed what was held in Government of United States of America v. Honorable Guillermo G. Perganin, Presiding Judge, RTC of Manila, Branch 42, and Mark B. Jimenez, a.k.a. Mario Butican Crespo, General Register No. 153675, April 2007, that the constitutional provision on bail does not apply to extradition proceedings, the same being available only in criminal proceedings. The court took cognizance of the following trends in international law. 1. The growing importance of the individual person in public international. 2. The higher value now being given to human rights. 3. The corresponding duty of countries to observe these universal human rights in fulfilling their treaty obligations, and 4. The duty of this court to balance the rights of the individual under our fundamental law, on one hand, and the law on extradition, on the other. In light of the recent developments in international law, where emphasis is given to the worth of the individual and the sanctity of human rights, the court departed from the ruling in Perganin, and held that an extraditee may be allowed to post bail. Government of Hong Kong Special Administrative Region v. Honorable Olaya, General Register No. 153675, April 19, 2007. Question. May the court require a witness to post bail? Explain your answer. 1999 bar. Answer. Yes. The court may require a witness to post bail if he is a material witness and bail is needed to secure his appearance. The rules provide that when the court is satisfied, upon proof or oath, that a material witness will not testify when required, it may, upon motion of either party, order the witness to post bail in such sum as may be deemed proper. Upon refusal to post bail, the court shall commit him to prison until he complies or is legally discharged after his testimony is taken. Section 6, Rule 119. Question. A was charged with a non-bailable offense. At the time when the warrant of arrest was issued, he was confined in the hospital and could not obtain a valid clearance to leave the hospital. He filed a petition for bail saying therein that he be considered as having placed himself under the jurisdiction of the court. May the court entertain his petition? Why or why not? 2012 bar. Answer. Yes, a person is deemed to be under the custody of the law either when he has been arrested or has surrendered himself to the jurisdiction of the court. The accused who is confined in a hospital may be deemed to be in the custody of the law if he clearly communicates his submission to the court while he is confined in a hospital. Padranga v. Court of Appeals, General Register No. 115407, August 28, 1995. Question. Paz was awakened by a commotion coming from a condo unit next to hers. Alarmed, she called up the nearby police station. PO1 Remus and PO2 Romulus proceeded to the condo unit identified by Paz. PO1 Remus knocked at the door and when a man opened the door, PO1 Remus and his companions introduced themselves as police officers. The man readily identified himself as Oasis Young and gestured to them to come in. Inside, the police officers saw a young lady with her nose bleeding and face swollen. Asked by PO2 Romulus what happened, the lady responded that she was beaten up by Oasis Young. The police officers arrested Oasis Young and brought him and the young lady back to the police station. PO1 Remus took the young lady's statement, who identified herself as AA. She narrated that she is a 16-year-old high school student, that previous to the incident, she had sexual intercourse with Oasis Young at least 5 times on different occasions, and she was paid $5,000 each time, and it was the first time that Oasis Young physically hurt her. PO2 Romulus detained Oasis Young at the station's jail. After the inquest proceeding, the public prosecutor filed an information for violation of Republic Act No. 9262, the VOC law, for physical violence, and 5 separate informations for violation of Republic Act No. 7610, the child abuse law. Oasis Young's lawyer filed a motion to be admitted to bail, but the court issued an order that approval of his bail bond shall be made only after his arraignment. A. Did the court properly impose that bail condition? Answer: No. The court did not properly impose that bail condition. The revised rules of criminal procedure do not require the arraignment of the accused as prerequisite to the conduct of hearings in the bail petition. A person is allowed to file a petition for bail as soon as he is deprived of his liberty by virtue of his arrest or voluntary surrender. An accused need not wait for his arraignment before filing the bail petition. Serapio v. Sandigan-Bayan, General Register No. 149116, January 2, 2003. Moreover, the condition that the approval of bail bonds shall be made only after arraignment would place the accused in a position where he has to choose between 1. Filing a motion to quash the information, and thus delay his release on bail, because until his motion to quash can be resolved, his arraignment cannot be held, and 2. Foregoing the filing of a motion to quash the information, so that he can be arraigned at once and thereafter be released on bail. Lavids v. Court of Appeals, General Register No. 129670, February 1, 2000. B. After his release from detention on bail, can Oasis Young still question the validity of his arrest? 2015 Bar. Answer: Yes. Oasis Young can still question the validity of his arrest even after his release from detention on bail. Under Section 26, Rule 114 of the Rules of Court, an application for or admission to bail shall not bar the accused from challenging the validity of his arrest or the legality of the warrant issued therefor, or from assailing the regularity or questioning the absence of a preliminary investigation of a charge against him, provided that he raises them before entering his plea. Rights of the accused. Question: Under Republic Act No. 8353, one may be charged with and found guilty of qualified rape if he knew on or before the commission of the crime that he is afflicted with human immunodeficiency virus, HIV/acquired immune deficiency syndrome, AIDS, or any other sexually transmissible disease, and the virus or disease is transmitted to the victim. Under Section 17A of Republic Act No. 8504, the court may compel the accused to submit himself to a blood test where blood samples would be extracted from his veins to determine whether he has HIVs. 2005, 2010 Bar. A. Are the rights of the accused to be presumed innocent of the crime charged, to privacy, and against self-incrimination violated by such compulsory testing? Explain. Answer: No. The court may compel the accused to submit himself to a blood test to determine whether he has HIV under Section 17A of Republic Act No. 8054. His rights to be presumed innocent of the crime charged, to privacy and against self-incrimination are not violated by such compulsory testing. In an action in which the physical condition of a party is in controversy, the court may order the accused to submit to a physical examination. Section 1, Rule 28, look for citation of latest cases. Indiana 2004. B. If the result of such test shows that he is HIV positive, and the prosecution offers such result in evidence to prove the qualifying circumstance under the information for qualified rape, should the court reject such result on the ground that it is the fruit of a poisonous tree? Explain. Answer: since the rights of the accused are not violated because the compulsory testing is authorized by the law, the result of the testing cannot be considered to be the fruit of a poisonous tree and can be offered in evidence to prove the qualifying circumstance under the information for qualified rape under Republic Act No. 8353. The fruit of the poisonous tree doctrine refers to that rule of evidence that excludes any evidence which may have been derived or acquired from a tainted or polluted source. Such evidence is inadmissible for having emanated from spurious origins. The doctrine, however, does not apply to the results obtained pursuant to Section 1, Rule 28, 1997 Rules of Civil Procedure, as it does not contemplate a search within the meaning of the law. People v. Monta, General Register No. 123872, January 30, 1998. Question: X was arrested for the alleged murder of a 6-year-old lad. He was read his Miranda rights immediately upon being apprehended. In the course of his detention, X was subjected to 3 hours of non-stop interrogation. He remained quiet until, on the 3rd hour, he answered yes to the question of whether he prayed for forgiveness for shooting down the boy. The trial court, interpreting X's answer as an admission of guilt, convicted him. On appeal, X's counsel faulted the trial court in its interpretation of his client's answer, arguing that X invoked his Miranda rights when he remained quiet for the first 2 hours of questioning. Rule on the Assignment of Error. 2002, 2010 Bar. Answer: the assignment of error invoked by X's counsel is impressed with merit since there has been no express waiver of X's Miranda rights. In order to have a valid waiver of the Miranda rights, the same must be in writing and made in the presence of his counsel. The uncounseled extrajudicial confession of X being without a valid waiver of his Miranda rights, is inadmissible, as well as any information derived therefrom. Question: Pedro, the principal witness in a criminal case, testified and completed his testimony on direct examination in 2015. Due to several postponements by the accused, grounded on his recurring illness, which were all granted by the judge, the cross-examination of Pedro was finally set on October 15, 2016. Before the said date, Pedro died. The accused moved to expunge Pedro's testimony on the ground that it violates his right of confrontation and the right to cross-examine the witness. The prosecution opposed the motion and asked Pedro's testimony on direct examination be admitted as evidence. Is the motion meritorious? 2016 Bar. Answer: the motion is meritorious. The cross-examination of a witness is an absolute right, not a mere privilege, of the party against whom he is called. With regard to the accused, it is a right guaranteed by the fundamental law as part of due process. Article 3, Section 14(2) of the 1987 Constitution specifically mandates that the accused shall enjoy the right to meet the witnesses face to face, and Rule 115, Section 1F of the 2000 Rules of Criminal Procedure enjoins that in all criminal prosecutions the accused shall be entitled to confront and cross-examine the witnesses against him at the trial. Accordingly, the testimony of a witness given on direct examination should be stricken off the record where there was not adequate opportunity for cross-examination. People v. Fernando Monge Rosario, General Register No. 146689, September 27, 2002. In People v. Manchetti, General Register No. L48883, August 6, 1980, the Supreme Court also held that if a party is deprived of the opportunity of cross-examination without fault on his part, as in case of the illness and death of a witness after direct examination, he is entitled to have the direct testimony stricken from the records. Since the accused was deprived of his opportunity to cross-examine the witness without folly on his part, the motion to expunge is meritorious. Alternative answer: the motion is not meritorious. The right of a party to confront and cross-examine opposing witnesses in a judicial litigation is a personal one which may be waived, expressly or impliedly, by conduct amounting to a renunciation of the right of cross-examination. Where a party has had the opportunity to cross-examine a witness but failed to avail himself of it, he necessarily forfeits the right to cross-examine, and the testimony given on direct examination of the witness will be received or allowed to remain in the record. The conduct of a party which may be construed as an implied waiver of the right to cross-examine may take various forms. The common basic principle underlying the application of the rule on implied waiver is that the party was given the opportunity to confront and cross-examine an opposing witness but failed to take advantage of it for reasons attributable to himself alone. People v. Bit Yao, General Register No. 139456, July 7, 2004. Under the doctrine of incomplete testimony, the direct testimony of a witness who dies before conclusion of the cross-examination can be stricken only insofar as not covered by the cross-examination. Curtis v. West, Tunis 507, 5047, affirmed 24 NE 1099, 121 NY 696, and that a referee has no power to strike the examination of a witness on his failure to appear for cross-examination where a good excuse is given. People v. Honorable Alberto v. Senaris, General Register No. L 48883, August 6, 1980. At any rate, the accused may be deemed to have waived his right to confront and cross-examine the witness when he asked the postponement of the hearing for several times. Therefore, the direct testimony of a witness who dies before the conclusion of the cross-examination should not be expunged from the records. Arraignment and plea. Question: D was charged with theft of an article worth 15,000 pesos. Upon being arraigned, he pleaded not guilty to the offense charged. Thereafter, before trial commenced, he asked the court to allow him to change his plea of not guilty to a plea of guilty, but only to a estafa involving 5,000 pesos. Can the court allow D to change his plea? Why? 2002 bar. Answer: no, because a plea of guilty to a lesser offense may be allowed if the lesser offense is necessarily included in the offense charged. Section 2, Rule 116. Estafa involving 5,000.00 is not necessarily included in theft of an article worth 15,000.00. Motion to quash. Question: a criminal information is filed in court charging Anselmo with homicide. Anselmo files a motion to quash the information on the ground that no preliminary investigation was conducted. Will the motion be granted? Why or why not? 2009 bar. Answer: no, the motion to quash will not be granted. The lack of preliminary investigation is not a ground for a motion to quash. Preliminary investigation is only a statutory right and can be waived. The accused should instead file a motion for reinvestigation within 5 days after he learn of the filing in court of the case against him. Section 6, Rule 112, as amended. Question: Pedrito and Thomas, Mayor and Treasurer, respectively, of the Municipality of San Miguel, Leyte, are charged before the Sandigan for violation of Section 3E, Republic Act No. 3019, Anti-Graft and Corrupt Practices Act. The information alleges, among others, that the two conspired in the purchase of several units of computer through personal canvass instead of a public bidding, causing undue injury to the municipality. Before arraignment, the accused moved for reinvestigation of the charge, which the court granted. After reinvestigation, the Office of the Special Prosecutor filed an amended information duly signed and approved by the Special Prosecutor, alleging the same delictual facts, but with an additional allegation that the accused gave unwarranted benefits to SB Enterprises owned by Samuel. Samuel was also indicted under the amended information. Before Samuel was arraigned, he moved to quash the amended information on the ground that the officer who filed the same had no authority to do so. Resolve the motion to quash with reasons. 2009 Bar. Answer: the motion to quash filed Samuel should be granted. Under Republic Act No. 6770, also known as the Ombudsman Act of 1989, the special prosecutor has the power and authority, under the supervision and control of the Ombudsman, to conduct preliminary investigation and prosecute criminal cases before the Sandiganbayan and perform such other duties assigned to him by the Ombudsman. Callingan vs. Desierto, General Register Nos. 145,743-89, August 10, 2007. Absent a clear delegation of authority from the Ombudsman to the special prosecutor to file the information, the latter would have no authority to file the same. The special prosecutor cannot be considered an alter ego of the Ombudsman, as the doctrine of qualified political agency does not apply to the office of the Ombudsman. Perez vs. Sandiganbayan, General Register No. 166,062, September 26, 2006. Question: BC is charged with illegal possession of firearms under an information signed by a provincial prosecutor. After arraignment but before pretrial, BC found out that the provincial prosecutor had no authority to sign the information, as it was the city prosecutor who has such authority. During the pretrial, BC moves that the case against him be dismissed on the ground that the information is defective because the officer signing it lacked the authority to do so. The provincial prosecutor opposes the motion on the ground of estoppel, as BC did not move to quash the information before arraignment. If you are counsel for BC, what is your argument to refute the opposition of the provincial prosecutor? 2000 Bar. Answer: I would argue that since the provincial prosecutor had no authority to file the information, the court did not acquire jurisdiction over the person of the accused and over the subject matter of the offense charged. Cudia vs. Court of Appeals, General Register No. 110,315, January 16, 1998. Hence, this ground is not waived if not raised in a motion to quash, and could be raised at the pretrial. Section 9, Rule 117. Question: Rodolfo is charged with possession of unlicensed firearms in an information filed in the RTC. It was alleged therein that Rodolfo was in possession of two unlicensed firearms, a .45 caliber and a .32 caliber. Under Republic Act No. 8294, possession of an unlicensed .45 caliber gun is punishable by prison mayor in its minimum period and a fine of 30,000 pesos, while possession of an unlicensed .32 caliber gun is punishable by prison correctional in its maximum period and a fine of not less than 15,000 pesos. As counsel of the accused, you intend to file a motion to quash the information. What ground or grounds should you invoke? Explain. 2005 Bar. Answer: the ground for the motion to quash is that more than one offense is charged in the information. Section 3F, Rule 117. Likewise, the RTC has no jurisdiction over the second offense of possession of an unlicensed .32 caliber gun, punishable by prison correctional in its maximum period and a fine of not less than 15,000 pesos. It is the MTC that has exclusive and original jurisdiction over all offenses punishable by imprisonment not exceeding 6 years. Sec. 2, Republic Act No. 7691 amending but is Pambansabalang 129. Question: give two grounds to quash an information. 1998 Bar. Answer: two grounds to quash an information are: 1. That the facts charged do not constitute an offense, and 2. that the court trying the case has no jurisdiction over the offense charged or the person of the accused. Note, the other grounds are: 3. That the officer who filed the information had no authority to do so. 4. That it does not conform substantially to the prescribed form. 5. That more than one offense is charged except in those cases in which existing laws prescribe a single punishment for various offenses. 6. That the criminal action or liability has been extinguished. 7. That it contains arguments which, if true, would constitute a legal excuse or justification, and 8. That the accused has been previously convicted or in jeopardy of being convicted, or acquitted of the offense charged. Section 3, Rule 117. Question: if the information is not accompanied by a certification that a preliminary investigation has been conducted, is the information void? 1998 bar. Answer: Number the certification which is provided in Section 4, Rule 112, Rules of Criminal Procedure, is not an indispensable part of the information. People v. Lipora, General Register No. 94494, March 15, 1996. Question: the information against Roger Alindogan for the crime of acts of lasciviousness under Article 336 of the Revised Penal Code avers that on or about 10:30 o'clock in the evening of February 1, 2010 at Brangame Talaba, Imus, Cavite and within the jurisdiction of this honorable court, the above-named accused, with lewd and unchaste design, through force and intimidation, did then and there, willfully, unlawfully and feloniously commit sexual abuse on his daughter, Rose Domingo, a minor of 11 years old, either by raping her or committing acts of lasciviousness on her, against her will and consent to her damage and prejudice. Acts contrary to law. The accused wants to have the case dismissed because he believes that the charge is confusing and the information is defective. What ground or grounds can he raise in moving for the quashula of the information? Explain. 2016 bar. Answer: the accused may move to quash the information based on any of the following grounds: a. That the facts charged do not constitute an offense; b. That it does not conform substantially to the prescribed form; and c. That more than one offense is charged except when a single punishment for various offenses is prescribed by law. Section 3, Rule 117, Rules of Criminal Procedure. In People v. Stella Cruz, General Register Nos. 135,554-56, June 21, 2002, the Supreme Court ruled that the phrase "by either raping her or committing acts of lasciviousness" does not constitute an offense since it does not cite which among the numerous sections or subsections of Republic Act No. 7610 has been violated by accused appellant. Moreover, it does not state the acts and omissions constituting the offense, or any special or aggravating circumstances attending the same, as required under the rules of criminal procedure. These are conclusions of law, and not facts. Thus, the information violated accused's constitutional right to be informed of the nature and cause of the accusation against him and therefore should be quashed on the ground that the information charges acts that do not constitute an offense. Double jeopardy. Question: SP01CNC filed with the MTC in Quezon City, MTCQC, a sworn written statement duly subscribed by him, charging RGR, an actual resident of Cebu City, with the offense of slight physical injuries allegedly inflicted on SPS, an actual resident of Quezon City. The judge of the branch to which the case was referred thereupon issued an order declaring that the case shall be governed by the rule on summary procedure in criminal cases. Soon thereafter, the judge ordered the dismissal of the case for the reason that it was not commenced by information, as required by said rule. Sometime later, based on the same facts giving rise to the slight physical injuries case, The city prosecutor filed with the same ETCQC an information for attempted homicide against the same RGR. In due time, before arraignment, RGR moved to quash the information on the ground of double jeopardy, and after due hearing, the judge granted his motion. A. Was the dismissal of the complaint for slight physical injuries proper? Answer: yes. The dismissal of the complaint for slight physical injuries is proper because in metropolitan Manila and in chartered cities, the case has to be commenced only by information, Section 11, Revised Rule on Summary Procedure. B. Was the grant of the motion to quash the attempted homicide information correct? 2004 bar. Answer: no. The grant of the motion to quash the attempted homicide information on the ground of double jeopardy was not correct, because there was no valid prosecution for slight physical injuries. Question: D was charged with slight physical injuries in the MTC. He pleaded not guilty and went to trial. After the prosecution had presented its evidence, the trial court set the continuation of the hearing on another date. On the date scheduled for hearing, the prosecutor failed to appear, whereupon the court, on motion of D, dismissed the case. A few minutes later, the prosecutor arrived and opposed the dismissal of the case. The court reconsidered its order and directed D to present his evidence. Before the next date of trial came, however, D moved that the last order be set aside on the ground that the reinstatement of the case had placed him twice in jeopardy. Acceding to this motion, the court again dismissed the case. The prosecutor then filed an information in the RTC, charging D with direct assault based on the same facts alleged in the information for slight physical injuries, but with the added allegation that D inflicted the injuries out of resentment for what the complainant had done in the performance of his duties as chairman of the Board of Election Inspectors. D moved to quash the second information on the ground that its filing had placed him in double jeopardy. How should D's motion to quash be resolved? 2002 bar. Answer: D's motion to quash should be granted on the ground of double jeopardy because the first offense charged is necessarily included in the second offense charged. Draculan v. Donato, General Register No. L 44079. December 19, 1985. Question: for the multiple stab wounds sustained by the victim, Noel was charged with frustrated homicide in the RTC. Upon arraignment, he entered a plea of guilty to said crime. Neither the court nor the prosecution was aware that the victim had died 2 days earlier on account of his stab wounds. Because of his guilty plea, Noel was convicted of frustrated homicide and meted the corresponding penalty. When the prosecution learned of the victim's death, it filed within 15 days therefrom a motion to amend the information to upgrade the charge from frustrated homicide to consummated homicide. Noel opposed the motion, claiming that the admission of the amended information would place him in double jeopardy. Resolve the motion with reasons. 2005 bar. Answer: the amended information to consummated homicide from frustrated homicide does not place the accused in double jeopardy. As provided in the second paragraph of Section 7, Rule 117, 2000 Rules of Criminal Procedure, the conviction of the accused shall not be a bar to another prosecution for an offense which necessarily includes the offense charged in the former complaint or information when a. the graver offense developed due to supervening facts arising from the same act or omission constituting the former charge, or b. the facts constituting the graver charge became known or were discovered only after a plea was entered in the former complaint or information. Here, when the plea to frustrated homicide was made, neither the court nor the prosecution was aware that the victim had died 2 days earlier on account of his stab wounds. Question: Mgjali is a troublemaker of sorts, always getting into brushes with the law. In one incident, he drove his Humvee recklessly, hitting a pedicab which sent its driver and passengers in different directions. The pedicab driver died, while two of the passengers suffered slight physical injuries. 2 informations were then filed against Mgjali. 1. for reckless imprudence resulting in homicide and damage to property, and 2, for reckless imprudence resulting in slight physical injuries. The latter case was scheduled for arraignment earlier, on which occasion Mkhitaryan immediately pleaded guilty. He was meted out the penalty of public censure. A month later, the case for reckless imprudence resulting in homicide was also set for arraignment. Instead of pleading, Mkhitaryan interposed the defense of double jeopardy. Resolve. 2014 Bar. Answer: Mkhitaryan correctly interposed the defense of double jeopardy. Reckless imprudence under Article 365 is a quasi-offense by itself and not merely a means to commit other crimes, such that conviction or acquittal of such quasi-offense already bars subsequent prosecution for the same quasi-offense, regardless of its various resulting acts. Ivler v. Hahn, Modesto San Pedro, General Register No. 172716, November 17, 2010. Provisional dismissal. Question: in a prosecution for robbery against D., the prosecutor moved for the postponement of the first scheduled hearing on the ground that he had lost his records of the case. The court granted the motion, but, when the new date of trial arrived, the prosecutor, alleging that he could not locate his witnesses, moved for the dismissal of the case. If D's counsel does not object, may the court grant the motion of the prosecutor? Why? 2002 Bar. Answer: no, because a case cannot be provisionally dismissed except upon the express consent of the accused and with notice to the offended party. Section 8, Rule 117. Single larceny rule. Question: Paz was awakened by a commotion coming from a condo unit next to hers. Alarmed, she called up the nearby police station. PO1 Remus and PO2 Romulus proceeded to the condo unit identified by Paz. PO1 Remus knocked at the door, and when a man opened the door, PO1 Remus and his companions introduced themselves as police officers. The man readily identified himself as Oasis Young and gestured to them to come in. Inside, the police officers saw a young lady with her nose bleeding and face swollen. Asked by PO2 Romulus what happened, the lady responded that she was beaten up by Oasis Young. The police officers arrested Oasis Young and brought him and the young lady back to the police station. PO1 Remus took the young lady's statement, who identified herself as AA. She narrated that she is a 16-year-old high school student, that previous to the incident, she had sexual intercourse with Oasis Young at least 5 times on different occasions, and she was paid $5,000 each time, and it was the first time that Oasis Young physically hurt her. PO2 Romulus detained Oasis Young at the station's jail. After the inquest proceeding, the public prosecutor filed an information for violation of Republic Act No. 9262, the VOC law, for physical violence, and 5 separate informations for violation of Republic Act No. 7610, the child abuse law. Oasis Young's lawyer filed a motion to be admitted to bail, but the court issued an order that approval of his bail bond shall be made only after his arraignment. Before arraignment, Oasis Young's lawyer moved to quash the other 4 separate informations for violation of the child abuse law, invoking the single larceny rule. Should the motion to quash be granted? 2015 Bar. Answer: no, the court should not grant the motion to quash, because the single larceny rule does not find application where the charges involve violations of Republic Act 9262, the VOC law, and Republic Act 7610, the child abuse law, considering that each criminal act is based on a different criminal impulse and intent. In Santiago v. Carcaterina, General Register No. 109266, December 2, 1993, the Supreme Court explained that the single larceny doctrine applies only to criminal crimes committed delicto continuado, which exists if there should be plurality of acts performed during a period of time, unity of penal provision violated, and unity of criminal intent or purpose, which means that two or more violations of the same penal provisions are united in one and same instant or resolution leading to the perpetration of the same criminal purpose or aim. The said rule applies in theft cases, where the taking of several things, whether belonging to the same or different owners, at the same time and place constitutes but one larceny, id. Pretrial. Question: Lilio filed a complaint in the MTC of Lanusa for the recovery of a sum of money against Juan. The latter filed his answer to the complaint serving a copy thereof on Lilio. After the filing of the answer of Juan, whose duty is it to have the case set for pretrial? Y. 2001 bar. Answer: After the filing of the answer of Juan, the plaintiff has the duty to promptly move ex parte that the case be set for pretrial, Section 1, Rule 18. The reason is that it is the plaintiff who knows when the last pleading has been filed and it is the plaintiff who has the duty to prosecute. Pretrial agreement question: Mayor Trademark was charged of malversation through falsification of official documents. Assisted by attorney Op as counseled the party during pretrial, he signed together with Ombudsman Prosecutor TG a joint stipulation of facts and documents, which was presented to the Sandiganbayan. Before the court could issue a pretrial order, but after some delay caused by attorney Op, he was substituted by attorney QR as defense counsel. Attorney QR forthwith filed a motion to withdraw the joint stipulation, alleging that it is prejudicial to the accused because it contains, inter alia, the statement that the defense admitted all the documentary evidence of the prosecution, thus leaving the accused little or no room to defend himself, and violating his right against self-incrimination. Should the court grant or deny QR's motion? Reason: 2004 bar. Answer: The court should deny QR motion. If in the pretrial agreement signed by the accused and his counsel, the accused admits the documentary evidence of the prosecution, it does not violate his right against self-incrimination. His lawyer cannot file a motion to withdraw. A pretrial order is not needed. Baez v. Sandiganbayan, General Register Nos. 143,689-91, November 12, 2002. The admission of such documentary evidence is allowed by the rule, Section 2, Rule 118, People v. Hernandez, General Register No. 108,028, July 30, 1996. Trial. Question: Enumerate the requisites of a trial in absentia and a promulgation of judgment in absentia, 1997, 1998, 2010 bar. Answer: The requisites of a valid trial in absentia are, 1. Accused's arraignment, 2. His due notification of the trial, and, 3. His unjustifiable failure to appear during trial. Bimarto v. People, General Register No. 166,980, April 4, 2007. The requisites for a valid promulgation of judgment in absentia are: a. A valid notice of promulgation of judgment. b. Said notice was duly furnished to the accused, personally or through counsel. c. Accused failed to appear on the scheduled date of promulgation of judgment despite due notice. d. Such judgment be recorded in the criminal docket, and e. Copy of said judgment had been duly served upon the accused or his counsel. Question: If an accused who is sentenced to death escapes, is there still a legal necessity for the Supreme Court to review the decision of conviction? 1998 bar. Answer: Yes. There is still a legal necessity for the Supreme Court to review the decision of conviction sentencing the accused to death, because he is entitled to an automatic review of the death sentence, Sections 3E and 10, Rule 122, People v. Esparras, General Register No. 120,034, August 20, 1996. Remedy when accused is not brought to trial within the prescribed period. Question: At the public attorney's office station in Taguig where you are assigned, Your work requires you to act as public defender at the local regional trial court and to handle cases involving indigents. A. In one criminal action for qualified theft where you are the defense attorney, you learn that the woman accused has been in detention for 6 months, yet she has not been to a courtroom nor seen a judge. What remedy would you undertake to address the situation, and what forum would you use to invoke this relief? Answer. Section 7, Rule 119 provides, if the public attorney assigned to defend a person charged with a crime knows that the latter is preventively detained, either because he is charged with bailable crime but has no means to post bail, or is charged with a non-bailable crime, or is serving a term of imprisonment in any penal institution, it shall be his duty to do the following. 1. Shall promptly undertake to obtain the presence of the prisoner for trial or cause a notice to be served on the person having custody of the prisoner requiring such person to so advise the prisoner of his right to demand trial. 2. Upon receipt of that notice, the custodian of the prisoner shall promptly advise the prisoner of the charge and of his right to demand trial. If at any time thereafter the prisoner informs his custodian that he demands such trial, the latter shall cause notice to that effect to send promptly to the public attorney. Moreover, Section 1(e), Rule 116 provides, when the accused is under a preventive detention, his case shall be raffled and its records transmitted to the judge to whom the case was raffled within 3 days from the filing of the information or complaint. The accused shall be arraigned within 10 days from the date of the raffle. The pretrial conference of his case shall be held within 10 days after arraignment. On the other hand, if the accused is not under preventive detention, the arraignment shall be held within 30 days from the date the court acquires jurisdiction over the person of the accused. Section 1(g), Rule 116. Since the accused has not been brought for arraignment within the limit required in the aforementioned rule, the information may be dismissed upon motion of the accused invoking his right to speedy trial, Section 9, Rule 119, or to a speedy disposition of cases, Section 16, Art. 3, 1987 Constitution. B. In another case, also for qualified theft, the detained young domestic helper has been brought to court 5 times in the last 6 months, but the prosecution has yet to commence the presentation of its evidence. You find that the reason for this is the continued absence of the employer complainant who is working overseas. What remedy is appropriate and before which forum would you invoke this relief? 2013 Bar. Answer. I will file a motion to dismiss the information in the court where the case is pending on the ground of denial of the accused right to speedy trial, Section 9, Rule 119, Dan v. People, General Register No. 173637, April 21, 2009. This remedy can be invoked, at any time, before trial and if granted will result to an acquittal. Since the accused has been brought to court 5 times and in each instance it was postponed, it is clear that her right to a speedy trial has been violated. Moreover, I may request the court to issue subpoena duces tecum and ad testificandum to the witness, so in case he disobeys same, he may be cited in contempt. I may also file a motion to order the witness employer complainant to post bail to secure his appearance in court, Section 14. Rule 119. I can also move for provisional dismissal of the case, Section 8, Rule 117. Demurrer to evidence. Question. After the prosecution had rested and made its formal offer of evidence, with the court admitting all of the prosecution evidence, the accused filed a demurrer to evidence with leave of court. The prosecution was allowed to comment thereon. Thereafter, the court granted the demurrer, finding that the accused could not have committed the offense charged. If the prosecution files a motion for reconsideration on the ground that the court order granting the demurrer was not in accord with the law and jurisprudence, will the motion prosper? Explain your answer. 2009 Bar. Answer. No, the motion will not prosper. With the granting of the demurrer, the case shall be dismissed and the legal effect is the acquittal of the accused. A judgment of acquittal is immediately executory and no appeal can be made therefrom. Otherwise the constitutional protection against double jeopardy would be violated. Question: Facing a charge of murder, X filed a petition for bail. The petition was opposed by the prosecution, but after hearing the court granted bail to X. On the first scheduled hearing the merits, the prosecution manifested that it was not adducing additional evidence and that it was resting its case. X filed a demurrer to evidence without leave of court, but it was denied by the court. A. Did the court have the discretion to deny the demurrer to evidence under the circumstances mentioned above? Answer: Yes. The court had the discretion to deny the demurrer to the evidence, because although the evidence presented by the prosecution at the hearing for bail was not strong, without any evidence for the defense, it could be sufficient for conviction. B. If the answer to the preceding question is in the affirmative, can X adduce evidence in his defense after the denial of his demurrer to evidence? Answer: No, because he filed the demurrer to the evidence without leave. Section 15, Rule 119. However, the trial court should inquire as to why the accused filed the demurrer without leave and whether his lawyer knew that the effect of filing it without leave is to waive the presentation of the evidence for the accused. People v. Fors, General Register 106581, March 3, 1997. C. Without further proceeding and on the sole basis of the evidence of the prosecution, can the court legally convict X for murder? 1998 bar. Answer: Yes. Without any evidence from the accused, the prima facie evidence of the prosecution has been converted to proof beyond reasonable doubt. Question: The information for illegal possession of firearm filed against the accused specifically alleged that he had no license or permit to possess the caliber .45 pistol mentioned therein. In its evidence in chief, the prosecution established the fact that the subject firearm was lawfully seized by the police from the possession of the accused, that is, while the pistol was tucked at his waist in plain view, without the accused being able to present any license or permit to possess the firearm. The prosecution on such evidence rested its case, and within a period of 5 days therefrom, the accused filed a demurrer to evidence, in sum contending that the prosecution evidence has not established the guilt of the accused beyond reasonable doubt, and so prayed that he be acquitted of the offense charged. The trial court denied the demurrer to evidence and deemed the accused as having waived his right to present evidence and submitted the case for judgment on the basis of the prosecution evidence. In due time, the court rendered judgment finding the accused guilty of the offense charged beyond reasonable doubt and accordingly imposing on him the penalty prescribed therefor. Is the judgment of the trial court valid and proper? Reason: 2001, 2004 bar. Answer: Yes. The judgment of the trial court is valid. The accused did not ask for leave to file the demurrer to evidence. He is deemed to have waived his right to present evidence. Section 23, Rule 119, People v. Flores, General Register 106581, March 3, 1997. However, the judgment is not proper or is erroneous because there was no showing from the proper office that the accused has a permit to own or possess the firearm, which is fatal to the conviction of the accused. Mallory v. Court of Appeals, General Register No. 110569, December 9, 1996. Question: A 12-year-old girl, while walking alone met BB, a teenage boy who befriended her. Later, BB brought AA to a nearby shanty where he raped her. The information for rape filed against BB states: on or about October 30, 2015, in the city of SP and within the jurisdiction of this honorable court, the accused, a minor, 15 years old, with lewd design and by means of force, violence and intimidation, did then and there, willfully, unlawfully and feloniously had sexual intercourse with a minor, 12 years old against the latter's will and consent. At the trial, the prosecutor called to the witness stand a as his first witness and manifested that he be allowed to ask leading questions in conducting his direct examination pursuant to the rule on the examination of a child witness. BB's counsel objected on the ground that the prosecutor has not conducted a competency examination on the witness, a requirement before the rule cited can be applied in the case. XXX. After the prosecution had rested its case, BB's counsel filed with leave a demurrer to evidence, seeking the dismissal of the case on the ground that the prosecutor failed to present any evidence on BB's minority as alleged in the information. Should the court grant the demurrer? 2015 bar. Answer: no, the court should not grant the demurrer. While it was alleged in the information that BB was a minor at the time of the commission of the offense, the failure of the prosecutor to present evidence to prove his minority is not a basis for the granting of the demurrer, because minority of the accused is not an element of the crime of rape. Be that as it may, the court should not consider minority in rendering the decision. After all, the failure of the prosecutor to prove the minority of a may only affect the imposable penalty but may not absolve him from criminal liability. Judgment. Question: when a criminal case is dismissed on nolle prosequi, can it later be refilled? 2003 bar. Answer: as a general rule, when a criminal case is dismissed on nolle prosequi before the accused is placed on trial and before he is called on to plead, this is not equivalent to an acquittal and does not bar a subsequent prosecution for the same offense. Galvez v. Court of Appeals, General Register No. 114046, October 24, 1994. Question: before the arraignment for the crime of murder, the private complainant executed an affidavit of desistance stating that she was not sure if the accused was the man who killed her husband. The public prosecutor filed a motion to quash the information on the ground that with private complainant's desistance, he did not have evidence sufficient to convict the accused. On January 2, 2001, the court without further proceedings granted the motion and provisionally dismissed the case. The accused gave his express consent to the provisional dismissal of the case. The offended party was notified of the dismissal but she refused to give her consent. Subsequently, the private complainant urged the public prosecutor to refile the murder charge because the accused failed to pay the consideration which he had promised for the execution of the affidavit of desistance. The public prosecutor obliged and refiled the murder charge against the accused on February 1, 2003. The accused filed a motion to quash the information on the ground that the provisional dismissal of the case had already become permanent. A. Was the provisional dismissal of the case proper? Answer: the provisional dismissal of the case was proper because the accused gave his express consent thereto and the offended party was notified. It was not necessary for the offended party to give her consent thereto. Section 8, Rule 117. B. Resolve the motion to quash. 2003 bar. Answer: the motion to quash the information should be denied because, while the provisional dismissal had already become permanent, the prescriptive period for filing the murder charge had not prescribed. There was no double jeopardy because the first case was dismissed before the accused had pleaded to the charge. Section 7, Rule 117. Question: X. The accused in a homicide case before the RTC, Dagupan City, was personally notified of the promulgation of judgment in his case set for December 10, 1996. On said date, X was not present as he had to attend to the trial of another criminal case against him in Tarlac. The trial court denied the motion of the counsel of X to postpone the promulgation. Can the trial court also order the arrest of X? 1997 bar. Answer: no. The trial court cannot order the arrest of X if the judgment is one of acquittal and, in any event, His failure to appear was with justifiable cause since he had to attend to another criminal case against him. Question: X was charged before the ERTC with theft of jewelry valued at 20,000 pesos, punishable with imprisonment of up to 10 years of prison under the revised penal code. After trial, he was convicted of the offense charged, notwithstanding that the material facts duly established during the trial showed that the offense committed was estafa, punishable by imprisonment of up to 8 years of prison under the said code. No appeal having been taken therefrom, said judgment of conviction became final. Is the judgment of conviction valid? Is the said judgment reviewable through a special civil action for certiorari? Reason: 2004 Answer: yes, the judgment of conviction for theft upon information for theft is valid because the court had jurisdiction to render judgment. However, the judgment was grossly and blatantly erroneous. The variance between the evidence and the judgment of conviction is substantial since the evidence is one for estafa while the judgment is one for theft. The elements of the two crimes are not the same. Laura Santos vs. People, General Register No. 77429, January 29, 1990. One offense does not necessarily include or is included in the other. Section 5, Rule 120. The judgment of conviction is reviewable by certiorari even if no appeal had been taken, because the judge committed a grave abuse of discretion tantamount to lack or excess of his jurisdiction in convicting the accused of theft and in violating due process and his right to be informed of the nature and the cause of the accusation against him, which make the judgment void. With a mistake in charging the proper offense, the judge should have directed the filing of the proper information and thereafter dismissed the original information. Section 19, Rule 119. Promulgation of judgment, instances of judgment in absentia. Question: Ludong, Balatong, and Labong were charged with murder. After trial, the court announced that the case was considered submitted for decision. Subsequently, the clerk of court issued the notices of promulgation of judgment which were duly received. On promulgation day, Ludong and his lawyer appeared. The lawyers of Balatong and Labong appeared but without their clients and failed to satisfactorily explain their absence when queried by the court. Thus, the judge ordered that the judgment be entered in the criminal docket and copies be furnished their lawyers. The lawyers of Ludong, Balatong, and Labong filed within the reglementary period of joint motion for reconsideration. The court favorably granted the motion of Ludong downgrading his conviction from murder to homicide but denied the motion as regards Balatong and Labong. A. Was the court correct in taking cognizance of the joint motion for reconsideration? Answer: No. The court is not correct in taking cognizance of the joint motion for reconsideration. Section 6, Rule 120 of the Rules of Court provides that if the judgment is for conviction and the failure of the accused to appear was without justifiable cause, he shall lose the remedies available against the judgment and the court shall order his arrest. Henceforth, the court erred when it entertained the joint motion for reconsideration with respect to accused Balatong and Labong who were not present during the promulgation of the judgment. The court should have merely considered the joint motion as a motion for reconsideration that was solely filed by Ludong. People v. De Grano, General Register No. 167710, June 5, 2009. B. Can Balatong and Labong appeal their conviction in case Ludong accepts his conviction for homicide? 2014 Bar. Answer: No. Balatong and Labong cannot appeal their conviction because they lost their right to appeal during the promulgation of judgment. Be that as it may, if they surrendered and filed a motion for leave to avail of their post-judgment remedies within 15 days from promulgation of judgment, and they have proven that their absence at the scheduled promulgation was for a justifiable cause, they may be allowed to avail of said remedies within 15 days from notice thereof. People v. De Grano, General Register Number 167710, June 5, 2009. Search and seizure. Question: UPDIA asset. Informant tipped the UPDIA director Shabanat that a Shabu laboratory was operating in a house at Sda. Cruz, Laguna, rented by two Chinese nationals, Ho Pia and Xiao Pao. UPDIA director Shabanat wants to apply for a search warrant, but he is worried that if he applies for a search warrant in any Laguna court, their plan might leak out. A. Where can he file an application for search warrant? Answer: UPDIA director may file an application for search warrant in any court within the judicial region where the crime was committed, Section 2B, Rule 126. B. What documents should he prepare in his application for search warrant? Answer: he should prepare a petition for issuance of a search warrant and attach therein sworn statements and affidavits. C. Describe the procedure that should be taken by the judge on the application. Answer: the judge must, before issuing the warrant, examine personally in the form of searching questions and answers, in writing and under oath, the complainant and the witnesses he may produce on facts personally known to them and attach to the record their sworn statements, together with the affidavits submitted, Section 5, Rule 126. If the judge is satisfied of the existence of facts upon which the application is based or that there is probable cause to believe that they exist, he shall issue the warrant, which must be substantially in the form prescribed by the rules, Section 6, Rule 126. Suppose the judge issues the search warrant worded in this way. People of the Philippines Plaintiff versus Ho Pia and Xiao Pao, accused. Criminal case number 007 for violation of Republic Act 9165. To any peace officer. Greetings. It appearing to the satisfaction of the undersigned after examining under oath UPDIA Director Shabanat that there is probable cause to believe that violations of Section 18 and 16 of Republic Act 9165 have been committed and that there are good and sufficient reasons to believe that Ho Pia and Xiao Pao have in their possession or control, in a two-door apartment with an iron gate located at Jupiter Street, Sda. Cruz, Laguna, undetermined amount of shabu and drug manufacturing implements and paraphernalia which should be seized and brought to the undersigned. You are hereby commanded to make an immediate search, at any time in the day or night, of the premise above described and forthwith seize and take possession of the above-mentioned personal property, and bring said property to the undersigned to be dealt with as the law directs. Witness my hand this first day of March, 2012. Signed. Judge Ziz. Cite, enumerate the defects, if any, of the search warrant. Answer. 1. The search warrant failed to particularly describe the place to be searched and the things to be seized, Section 4, Rule 126. 2. The search warrant commanded the immediate search, at any time in the day or night. The general rule is that a search warrant must be served in the daytime, Section 8, Rule 126, or that portion of the 24 hours in which a man's person and countenance are distinguishable, 17 CJ 1134. By way of exception, a search warrant may be made at night when it is positively asserted in the affidavit that the property is on the person or in the place ordered to be searched. Alvarez v. CFI of Tayabas, General Register Number L45358, January 29, 1937. There is no showing that the exception applies. Suppose the search warrant was served on March 15, 2012 and the search yielded the described contraband and a case was filed against the accused in RTC, Sda. Cruz, Laguna and you are the lawyer of Xiao Pao and Ho Pia, what will you do? Answer. If I were the lawyer of Xiao Pao and Ho Pia, I would file a motion to quash the search warrant for having been served beyond its period of validity, Section 14, Rule 126. A search warrant shall be valid only for 10 days from its date. Thereafter, it shall be void. Section 10, Rule 126. Suppose an unlicensed armalite was found in plain view by the searchers and the warrant was ordered quashed. Should the court order the return of the same to the Chinese nationals? 2012 Bar. Answer: no, the court should not order the return of the unlicensed armalite because it is contraband or illegal per se. Dia versus Badit, General Register Number 196390, September 28, 2011. The possession of an unlicensed armalite found in plain view is mala prohibita. The same be kept in custodia legis. Particularity of place to be searched and things to be seized, plain view situation. Question: the search warrant authorized the seizure of undetermined quantity of shabu. During the service of the search warrant, the raiding team also recovered a kilo of dried marijuana leaves wrapped in newsprint. The accused moved to suppress the marijuana leaves as evidence for the violation of Section 11 of the Comprehensive Dangerous Drugs Act of 2002 since they were not covered by the search warrant. The state justified the seizure of the marijuana leaves under the plain view doctrine. There was no indication of whether the marijuana leaves were discovered and seized before or after the seizure of the shabu. If you are the judge, how would you rule on the motion to suppress? 2008 Bar. Answer: the motion to suppress filed by the accused should be granted. The search warrant violates the constitutional and statutory requirement that it should particularly describe the person or things to be seized. Section 2, Art. 3, 1987. Constitution, Section 2, Rule 126. The plain view doctrine cannot be invoked because the marijuana leaves were wrapped in newsprint. Besides, the marijuana leaves are not the subject of the search warrant. Question: police operatives of Western Police District, Philippine National Police, applied for a search warrant in the RTC for the search of the house of Juan Santos and the seizure of an undetermined amount of shabu. The team arrived at the house of Santos but failed to find him there. Instead, the team found Roberto Company. The team conducted a search in the house of Santos in the presence of Roberto Co. and barangay official and found 10 grams of shabu. Roberto Co. was charged in court with illegal possession of 10 grams of shabu. Before his arraignment, Roberto Co. filed a motion to quash the warrant on the following grounds: A. It was not the accused named in the search warrant, and B. The warrant does not prescribe the article to be seized with sufficient particularity. Resolve the motion with reasons. 2005 Bar. Answer: the motion to quash should be denied. The name of the person in the search warrant is not important. It is not even necessary that a particular person be implicated. Mantering vs. Roman, AM number RTJ 93904. February 28, 1996, so long as the search is conducted in the place where the search warrant will be served. Moreover, describing the shabu in an undetermined amount is sufficiently particular. People vs. T, General Register Nos. 140,546-47, January 20, 2003. Question: a search warrant was issued for the purpose of looking for unlicensed firearms in the house of Assassin, a notorious gun for hire. When the police served the warrant, they also sought the assistance of brigadiers who were assigned to look at other portions of the premises around the house. In a nipa hut 30 meters away from the house of Assassin, a brigadier came upon a kilo of marijuana that was wrapped in newsprint. He took it, and this was later used by the authorities to charge Assassin with illegal possession of marijuana. Assassin objected to the introduction of such evidence, claiming that it was illegally seized. Is the objection of Assassin valid? 2014 Bar. Answer: the objection is valid. The search warrant specifically designates or describes the house as the place to be searched. Incidentally, The marijuana was seized by the brigadiers 30 meters away from the house of the accused. Since the confiscated items were found in a place other than the one described in the search warrant, it can be considered as fruits of an invalid warrantless search, the presentation of which as an evidence is a violation of petitioner's constitutional guarantee against unreasonable searches and seizure. Ruben del Castillo vs. People of the Philippines, General Register No. 185128, January 30, 2012. Besides, the search is also illegal because the marijuana confiscated in the Nipa hut was wrapped in a newsprint. Therefore, the same cannot be considered validly seized in plain view. Abraham Maclad vs. People of the Philippines, General Register No. 176077, August 31, 2011. Remedies from unlawful search and seizure. Question: Hercules was walking near a police station when a police officer signaled for him to approach. As soon as Hercules came near, the police officer frisked him, but the latter found no contraband. The police officer told Hercules to get inside the police station. Inside the police station, Hercules asked the police officer, "Sir, may problema po ba?" Instead of replying, the police officer locked up Hercules inside the police station jail. A. If Hercules filed with the Ombudsman a complaint for warrantless search, as counsel for the police officer, what defense will you raise for the dismissal of the complaint? Answer: As counsel of policemen, I will raise the defense of presumption of regularity in the performance of duty. I can also raise the defense that the police officer has the duty to search Hercules under the stop and frisk rule. A stop and frisk situation must precede a warrantless arrest, be limited to the person's outer clothing, and should be grounded upon a genuine reason, in the light of the police officer's experience and surrounding conditions, to warrant the belief that the person detained has weapons concealed about him. Valdez vs. People, General Register No. 170180, November 23, 2007. The stop and frisk search should be used when dealing with a rapidly unfolding and potentially criminal situation in the city streets where unarguably there is no time to secure a search warrant. Stop and frisk searches, sometimes referred to as Terry searches, are necessary for law enforcement. That is, law enforcers should be given the legal arsenal to prevent the commission of the offenses. This should be balanced, however, with the need to protect the privacy of citizens in accordance with Article 3, Section 2 of the Constitution. People of the Philippines vs. Victor Cogat, General Register No. 200334, July 30, 2014. B. If Hercules opts to file a civil action against the police officer, will he have a cause of action? 2015 Bar. Answer: Yes. Hercules has a cause of action to file civil action against the police officer under Article 32(4) in relation to Article 2219 6 and 10 of the new Civil Code, which provides that a police officer may be liable for damages when the right to be secure in one's person, house, papers and effects against unreasonable searches and seizures is impaired. The indemnity includes moral damages. Exemplary damages may also be adjudicated. Galván vs. Casimiro, General Register No. 162808, April 22, 2008. Evidence. General Principles. Question: Legislative facts and adjudicative facts. 2004 Bar. Answer: Legislative facts refer to facts mentioned in a statute or in an explanatory note, while adjudicative facts are facts found in a court decision. Question: Give the reasons underlying the adoption of the following rules of evidence. A. Dead man rule. If death has closed the lips of one party, the policy of the law is to close the lips of the other. Goni vs. Court of Appeals, L. 77434, September 23, 1986. This is to prevent the temptation to perjury because death has already sealed the lips of the party. B. Parole evidence rule. It is designed to give certainty to a transaction which has been reduced to writing, because written evidence is much more certain and accurate than that which rests on fleeting memory only. Francisco, Revised Rules of Court, Volume 7, Part 1. Page 154. C. Best Evidence Rule. This rule is adopted for the prevention of fraud and is declared to be essential to the pure administration of justice. Moran, Volume 5, page 12. If a party is in possession of such evidence and withholds it, the presumption naturally arises that the better evidence is withheld for fraudulent purposes. Francisco, Revised Rules of Court Volume 7, Part 1, pages 121,122. D. The rule against the admission of illegally obtained extrajudicial confession. An illegally obtained extrajudicial confession nullifies the intrinsic validity of the confession and renders it unreliable as evidence of the truth. Moran, Volume 5. Page 257. It is the fruit of a poisonous tree. E. The rule against the admission of an offer of compromise in civil cases, 1997 bar. The reason for the rule against the admission of an offer of compromise in civil case as an admission of any liability is that parties are encouraged to enter into compromises. Courts should endeavor to persuade the litigants in a civil case to agree upon some fair compromise. Article 2029, NCC. During pretrial, courts should direct the parties to consider the possibility of an amicable settlement. Section 2A, Rule 18. Admissibility of evidence. Question: The Barangay captain reported to the police that X was illegally keeping in his house in the barangay an arm-allied M16 rifle. On the strength of that information, the police conducted a search of the house of X and indeed found said rifle. The police raiders seized the rifle and brought X to the police station. During the investigation, he voluntarily signed a sworn statement that he was possessing said rifle without license or authority to possess, and a waiver of right to counsel. Individually rule on the admissibility and evidence of the A. Rifle. Answer: The rifle is not admissible in evidence because it was seized without a proper search warrant. A warrantless search is not justified. There was time to secure a search warrant. People v. Ensacada General Register No. 116720, October 2, 1997. B. Sworn Statement, 2008 bar, and. Answer: The sworn statement is not admissible in evidence because it was taken without informing him of his custodial rights and without the assistance of counsel, which should be independent and competent and preferably of the choice of the accused. People v. Januario, General Register No. 98252, February 7, 1997. C. Waiver of right to counsel of X. 1998 bar. Answer: The waiver of his right to counsel is not admissible because it was made without the assistance of counsel of his choice. People v. Gomez, General Register No. 101817. March 26, 1997. Question: Dominique was accused of committing a violation of the Human Security Act. He was detained incommunicado, deprived of sleep, and subjected to water torture. He later allegedly confessed his guilt via an affidavit. After trial, he was acquitted on the ground that his confession was obtained through torture, hence, inadmissible as evidence. In a subsequent criminal case for torture against those who deprived him of sleep and subjected him to water torture, Dominique was asked to testify and to, among other things, identify his above-said affidavit of confession. As he was about to identify the affidavit, the defense counsel objected on the ground that the affidavit is a fruit of a poisonous tree. Can the objection be sustained? Explain. 2010 bar. Answer: No, the objection may not be sustained on the ground stated, because the affiant was only to identify the affidavit which is not yet being offered in evidence. The doctrine of the fruit of the poisonous tree can only be invoked by Domingo as his defense in the crime of violation of Human Security Act filed against him, but not by the accused in a torture case filed by him. In the instant case, the presentation of the affidavit cannot be objected to by the defense counsel on the ground that it is a fruit of the poisonous tree because the same is used in Domingo's favor. Question: Sergeant Gr of WPD arrested two NPA suspects, Max and Brix, both aged 22, in the act of robbing a grocery in Ermita. As he handcuffed them, he noted a pistol tucked in Max's waist and a dagger hidden under Brix's shirt, which he promptly confiscated. At the police investigation room, Max and Brix orally waived their right to counsel and to remain silent. Then under oath, they freely answered questions asked by the police desk officer. Thereafter they signed their sworn statements before the police captain, a lawyer. Max admitted his part in the robbery, his possession of a pistol and his ownership of the packet of shabu found in his pocket. Brix admitted his role in the robbery and his possession of a dagger. But they deny being NPA hitmen. In due course, proper charges were filed by the city prosecutor against both arrestees before the MRTC. May the written statements signed and sworn to by Max and Brix be admitted by the trial court as evidence for the prosecution? Reason: 2004 bar. Answer: The sworn written statements of Max and Brix may not be admitted in evidence, because they were not assisted by counsel, even if the police captain before whom they signed the statements was a lawyer, nor can he be considered as an independent counsel. Waiver of the right to a lawyer must be done in writing and in the presence of independent counsel. People v. Mahoney, General Register No. 122485, February 1, 1999, People v. Espiritu, General Register No. 128287, February 2, 1999. Question: Defendant was declared in default by the RTC. Plaintiff was allowed to present evidence in support of his complaint. Photocopies of official receipts and original copies of affidavits were presented in court, identified by plaintiff on the witness stand and marked as exhibits. Said documents were offered by plaintiff and admitted in evidence by the court, on the basis of which the RTC rendered judgment in favor of the plaintiff, pursuant to the relief prayed for. Upon receipt of judgment, defendant appeals to the Court of Appeals claiming that the judgment is not valid because the RTC based its judgment on mere photocopies and affidavits of persons not presented in court. Is the claim valid? Explain. 2000 bar. Answer: the claim of defendant is valid, because the court received evidence which it can order in its own discretion, in which case the evidence of the plaintiff must pass the basic requirements of admissibility. Burden of proof and burden of evidence. Question: distinguish burden of proof and burden of evidence. 2004 bar. Answer: burden of proof is the duty of a party to present evidence on the facts and issue necessary to establish his claim or defense by the amount of evidence required by law, Section 1. Rule 131, while burden of evidence is the duty of a party to go forward with the evidence to overthrow prima facie evidence established against him. See Bautista vs. Sarmiento, General Register No. L 45137, September 23, 1985. Quantum of proof. Question: distinguish preponderance of the evidence from substantial evidence. 2003 bar. Answer: preponderance of evidence means that the evidence as a whole adduced by one side is superior to that of the other. This is applicable in civil cases, Section 1, Rule 133, Municipality of Moncada vs. Cajuigan, General Register No. L 7048, January 12, 1912. Substantial evidence is that amount of relevant evidence which a reasonable mind might accept as adequate to justify a conclusion. This is applicable in cases filed before administrative or quasi-judicial bodies. Section 5, Rule 133. Judicial notice and judicial admissions. Judicial notice of foreign laws, law of nations and municipal ordinance. Question: give 3 instances when a Philippine court can take judicial notice of a foreign law. 1997 bar. Answer: the 3 instances when a Philippine court can take judicial notice of a foreign law are: 1. When the Philippine courts are evidently familiar with the foreign law, Moran. 1980. 2. When the foreign law refers to the law of nations. Section 1, Rule 129, and 3. When it refers to a published treatise, periodical or pamphlet on the subject of law. If the court takes judicial notice of the fact that the writer thereof is recognized in his profession or calling as expert on the subject. Section 4-5, Rule 130. Question: how do you prove a written foreign law? 1997 bar. Answer: a written foreign law may be evidenced by an official publication thereof or by a copy attested by the officer having the legal custody of the record, or by his deputy, and accompanied, if the record is not kept in the Philippines, with a certificate that such officer has the custody. If the office in which the record is kept is in a foreign country, the certificate may be made by a secretary of the embassy or legation, consul general, consul, vice-consul, or consular agent, or by any officer in the foreign service of the Philippines stationed in the foreign country in which the record is kept, and authenticated by the seal of his office. Section 24, Rule 132. Zillamia v. Court of Appeals, General Register No. 104235, November 18, 1993. Question: suppose a foreign law was pleaded as part of the defense of defendant but no evidence was presented to prove the existence of said law. What is the presumption to be taken by the court as to the wordings of said law? 1997 bar. Answer: the presumption is that the wordings of the foreign law are the same as the local law. Northwest Orient Airlines vs. Court of Appeals, General Register No. 112573, February 9, 1995, Moran. 1980, Lim v. Collector of Customs, General Register No. L11759, March 16, 1917. This is known as the processual presumption. Object: REAL, evidence. Chain of custody, in relation to Section 21 of the Comprehensive Dangerous Drugs Act of 2002. Question: at the trial of Ace for violation of the Dangerous Drugs Act, the prosecution offers in evidence a photocopy of the marked 100.00 pesos bills used in the buy-bust operation. Ace objects to the introduction of the photocopy on the ground that the best evidence rule prohibits the introduction of secondary evidence in lieu of the original. A. Is the photocopy real, object, evidence or documentary evidence? Answer: the photocopy of the marked bills is real, object, evidence. Not documentary evidence, because the marked bills are real evidence. B. Is the photocopy admissible in evidence? 1994 bar. Answer: yes, the photocopy is admissible in evidence, because the best evidence rule does not apply to object or real evidence. People v. Tandoy, General Register No. 0505, December 4, 1990. Question: discuss the chain of custody principle with respect to evidence seized under Republic Act 9165 or the Comprehensive Dangerous Drugs Act of 2002. 2012. Bar. Answer: in prosecutions involving narcotics and other illegal substances, the substance itself constitutes part of the corpus delicti of the offense, and the fact of its existence is vital to sustain a judgment of conviction beyond reasonable doubt. The chain of custody requirement is essential to ensure that doubts regarding the identity of the evidence are removed. Through the monitoring and tracking of the movements of the seized drugs from the accused, to the police, to the forensic chemist, and finally to the court, People v. Sitco, General Register. Number 178202, May 14, 2010. Ergo, the existence of the dangerous drug is a condition sine qua non for conviction. People v. de Guzman y Danzel, General Register Number 186498, March 26, 2010. The failure to establish, through convincing proof, that the integrity of the seized items has been adequately preserved through an unbroken chain of custody is enough to engender reasonable doubt on the guilt of an accused, id. Nonetheless, non-compliance with the procedure shall not render void and invalid the seizure and custody of the drugs. When, 1. Such non-compliance is attended by justifiable grounds, and, 2. The integrity and the evidentiary value of the seized items are properly preserved by the apprehending team. There must be proof that these two requirements were met before such non-compliance may be said to fall within the scope of the proviso. People v. Dela Cruz, General Register Number 177222, October 29, 2008. Rule on DNA Evidence, AM number 06115 SC. Question: in a prosecution for rape, the defense relied on deoxyribonucleic acid, DNA, evidence showing that the semen found in the private part of the victim was not identical with that of the accused. As private prosecutor, how will you dispute the veracity and accuracy of the results of the DNA evidence? 2010 Bar. Answer: as private prosecutor, I shall try to discredit the results of the DNA test by questioning and possibly impugning the integrity of the DNA profile by showing a flaw, error in obtaining the biological sample, or in the chain of custody of the biological sample obtained, the testing methodology employed, the scientific standard observed, the forensic DNA laboratory which conducted the test, and the qualification, training and experience of the forensic laboratory personnel who conducted the DNA testing. Question: at the public attorney's office station in Taguig where you are assigned, your work requires you to act as public defender at the local regional trial court and to handle cases involving indigents. Still in another case, this time for illegal possession of dangerous drugs, the prosecution has rested, but you saw from the records that the illegal substance allegedly involved has not been identified by any of the prosecution witnesses, nor has it been the subject of any stipulation. Should you now proceed post haste to the presentation of defense evidence or consider some other remedy? Explain the remedial steps you propose to undertake. 2013 Bar. Answer: I will first file a motion for leave to file demurrer to evidence within 5 days from the time the prosecution rested its case. If the same is granted, then I will file a demurrer to evidence within 10 days from notice on the ground of insufficiency of evidence of the prosecution. Section 23, Rule 119. In People v. de Guzman, General Register Number 186498, March 26, 2010, the Supreme Court held that in prosecution for violation of the Dangerous Drugs Act, the existence of the dangerous drug is a condition sine qua non for conviction. The dangerous drug is the very corpus delicti of the crime. The identity of the prohibited drug must be established with moral certainty. Apart from the showing that the elements of possession or sale are present, the fact that the substance illegally possessed and sold in the first place is the same substance offered in court as exhibit must likewise be established with the same degree of certitude as that needed to sustain a guilty verdict. The corpus delicti should be identified with unwavering exactitude. Similarly, in People v. Sitco, General Register No. 178202, May 14, 2010, the High Court held that in prosecutions involving narcotics and other illegal substances, the substance itself constitute part of the corpus delicti of the offense and the fact of its existence is vital to sustain a judgment of conviction beyond reasonable doubt. Of chief concern in drug cases then is the requirement that the prosecution prove that what was seized by police officers is the same item presented in court. This identification must be established with moral certainty and is a function of the rule of chain of custody. The chain of custody requirement is essential to ensure that doubts regarding the identity of the evidence are removed through the monitoring and tracking of the movements of the seized drugs from the accused, to the police, to the forensic chemist, and finally to the court. Documentary evidence. Question: may a private document be offered and admitted in evidence both as documentary evidence and as object evidence? Explain. 2005 Bar. Answer: yes. A private document may be offered and admitted in evidence both as documentary evidence and as object evidence. A document can also be considered as an object for purposes of the case. Objects as evidence are those addressed to the senses of the court. Section 1, Rule 130. Documentary evidence consists of writings or any material containing letters, words, numbers, figures, symbols or other modes of written expressions, offered as proof of their contents. Section 2, Rule 130. A tombstone may be offered in evidence to prove what is written on it, and if the same tombstone is found on a tomb, then it is object evidence. It can be considered as both documentary and object evidence. C. Pitt, Jr., 1989. Best evidence rule. Question: if the photocopies of official receipts and photocopies of affidavits were attached to the position paper submitted by plaintiff in an action for unlawful detainer, filed with municipal trial court, on which basis the court rendered judgment in favor of plaintiff? Explain. 2000. Bar. Answer: the claim of defendant is valid, because although summary procedure requires merely the submission of position papers, the evidence submitted with the position paper must be admissible in evidence. Section 9, Revised Rule of Summary Procedure. Photocopies of official receipts and affidavits are not admissible without proof of loss of the original. Section 3, Rule 130. Question: when a loaned a sum of money to be typed a single copy of the promissory note, which they both signed, a. made two Xeroxed copies of the promissory note, giving one copy to B and retaining the other copy, A entrusted the typewritten copy to his counsel for safekeeping. The copy with A's counsel was destroyed when the law office was burned. A. in an action to collect on the promissory note, which is deemed to be the original copy for the purpose of the best evidence rule? Answer: the copy that was signed and lost is the only original copy for purposes of the best evidence rule. Section 4, b, Rule 130. b. Can the photocopies in the hands of the parties be considered duplicate original copies? Answer: no, they are not duplicate original copies because there are photocopies which were not signed. Mahalam vs. Court of Appeals, General Register Number L 17970, June 30, 1966. They constitute secondary evidence. Section 5, Rule 130. c. As counsel for A, how will you prove the loan given to A and B? 1997 bar. Answer: the loan given by A to B may be proved by secondary evidence through the Xeroxed copies of the promissory note. The rules provide that when the original document is lost or destroyed, or cannot be produced in court, the offerer, upon proof of its execution or existence and the cause of its unavailability without bad faith on his part, may prove its contents by a copy, or by a recital of its contents in some authentic document, or by the testimony of witnesses in the order stated. Section 5, Rule 130. Rules on Electronic Evidence, AM number 01701 SC. Question: state the rule on the admissibility of an electronic evidence. 2003 bar. Answer: whenever a rule of evidence refers to the term writing, document, record, instrument, memorandum, or any other form of writing, such term shall be deemed to include an electronic document as defined in the rules. Section 1, Rule 3, Rules on Electronic Evidence. An electronic document is admissible in evidence if it complies with the rules on admissibility prescribed by the rules of court and related laws and is authenticated in the manner prescribed by the rules. Section 2, Rule 3, id. The authenticity of any private electronic document must be proved by evidence that it had been digitally signed and other appropriate security measures have been applied. Section 2, Rule 5, id. Question: when is an electronic evidence regarded as being the equivalent of an original document under the best evidence rule? 2003 bar. Answer: an electronic document shall be regarded as the equivalent of an original document under the best evidence rule if it is a printout or output readable by sight or other means, shown to reflect the data accurately. Section 1, Rule 4, id. Parole evidence rule. Question: Pedro filed a complaint against Lucio for the recovery of a sum of money based on a promissory note executed by Lucio. In his complaint, Pedro alleged that although the promissory note says that it is payable within 120 days, the truth is that the note is payable immediately after 90 days, but that if Pedro is willing, he may upon request of Lucio give the latter up to 120 days to pay the note. During the hearing, Pedro testified that the truth is that the agreement between him and Lucio is for the latter to pay immediately after 90 days' time. Also, since the original note was with Lucio and the latter would not surrender to Pedro the original note which Lucio kept in a place about 1 day's trip from where he received the notice to produce the note, and in spite of such notice to produce the same within 6 hours from receipt of such notice, Lucio failed to do so. Pedro presented a copy of such the note which was executed at the same time as the original and with identical contents. A. Over the objection of Lucio, will Pedro be allowed to testify as to the true agreement or contents of the promissory note? Why? Answer: yes, because Pedro has alleged in his complaint that the promissory note does not express the true intent and agreement of the parties. This is an exception to the parole evidence rule, Section 9b, Rule 130. b. Over the objection of Lucio, can Pedro present a copy of promissory note and have it admitted as valid evidence in his favor? Why? 2001 bar. Answer: yes, the copy in the possession of Pedro is a duplicate, original and with identical contents, Section 4b, Rule 130. Moreover, the failure of Lucio to produce the original of the note is excusable because he was not given reasonable notice, as requirement under the rules before secondary evidence may be presented, Section 6 Rule 130. Authentication and proof of documents. Question: X states on direct examination that he once knew the facts being asked but he cannot recall them now. When handed a written record of the facts he testifies that the facts are correctly stated, but that he has never seen the writing before. Is the writing admissible as past recollection recorded? Explain. 1996 bar. Answer: no, because for the written record to be admissible as past recollection recorded, it must have been written or recorded by X or under his direction at the time when the fact occurred, or immediately thereafter, or at any other time when the fact was fresh in his memory and he knew that the same was correctly written or recorded, Section 16, Rule 132. But in this case, X has never seen the writing before. Testimonial evidence. Question: for over a year, Nenita had been estranged from her husband Walter because of the latter's suspicion that she was having an affair with Vladimir, a barangay Kagawad who lived in nearby Mandaluyong. Nenita lived in the meantime with her sister in Makati. One day, the house of Nenita's sister inexplicably burned almost to the ground. Nenita and her sister were caught inside the house, but Nenita survived as she fled in time, while her sister tried to save belongings and was caught inside. When the house collapsed, as she was running away from the burning house, Nenita was surprised to see her husband also running away from the scene. Dr. Carlos, Walter's psychiatrist who lived near the burned house, and whom Walter medically consulted after the fire, also saw Walter in the vicinity some minutes before the fire. Coincidentally, Father Platino, the parish priest who regularly hears Walter's confession and who heard it after the fire, also encountered him not too far away from the burned house. Walter was charged with arson, and at his trial, the prosecution moved to introduce the testimonies of Nenita, the doctor and the priest confessor, who all saw Walter at the vicinity of the fire at about the time of the fire. 2006, 2013 bar. A. May the testimony of Nenita be allowed over the objection of Walter? Answer: Number Nenita may not be allowed to testify against Walter under the marital disqualification rule. During their marriage, neither the husband nor the wife may testify for or against the other without the consent of the affected spouse, except in a civil case by one against the other, or in a criminal case for a crime committed by one against the other or the latter's direct descendants or ascendants, Section 22, Rule 130. The foregoing exceptions cannot apply since it only extends to a criminal case of one spouse against the other or the latter's direct ascendants or descendants. Clearly, Nenita is not the offended party and her sister is not her direct ascendant or descendant for her to fall within the exception. B. May the testimony of Dr. Carlos Walters, psychiatrist, be allowed over Walters' objection? Answer: yes. The testimony of Walters' psychiatrist may be allowed. The privileged communication contemplated under Section 24, c. Rule 130 of the Rules on Evidence involves only persons authorized to practice medicine, surgery or obstetrics. It does not include a psychiatrist. Moreover, the privileged communication applies only in civil cases and not in a criminal case for arson. Besides, the subject of the testimony of Dr. Carlos was not in connection with the advice or treatment given by him to Walter, or any information he acquired in attending to Walter in a professional capacity. The testimony of Dr. Carlos is limited only to what he perceived at the vicinity of the fire and at about the time of the fire. C. May the testimony of Father Platino, the priest-confessor, be allowed over Walter's objection? Answer: yes. The priest can testify over the objection of Walter. The disqualification requires that the same were made pursuant to a religious duty enjoined in the course of discipline of the sect or denomination to which they belong, and must be confidential and penitential in character, for example, under the seal of confession, Section 24, d. Rule 130. Here, the testimony of Father Platino was not previously subject of a confession of Walter or an advice given by him to Walter. In his professional character, the testimony was merely limited to what Father Platino perceived at the vicinity of the fire and at about the time of the fire. Hence, Father Platino may be allowed to testify. Competency versus credibility of a witness. Question: distinguish competency of the witness and credibility of the witness. 2004 bar. Answer: competency of the witness refers to a witness who can perceive and perceiving, can make known his perception to others. Section 20, Rule 130, while credibility of the witness refers to a witness whose testimony is believable. Disqualifications of witnesses by reason of marriage. Question: Adi sued spouses Caesar and Baby for a sum of money and damages. At the trial, Adi called Baby as his first witness. Baby objected, joined by Caesar, on the ground that she may not be compelled to testify against her husband. Adi insisted and contended that after all, she would just be questioned about a conference they had with the Brangay captain, a matter which is not confidential in nature. The trial court ruled in favor of Adi. Was the ruling proper? Will your answer be the same if the matters to be testified on were known to Baby or acquired by her prior to her marriage to Caesar? Explain. 1998, 2000, 2004 bar. Answer: number under the rules on evidence, a wife cannot be examined for or against her husband without his consent, except in civil cases by one against the other, or in a criminal case for a crime committed by one against the other. Since the case was filed by Adi against the spouses Caesar and Baby, Baby cannot be compelled to testify against Caesar without his consent. Lezama vs. Rodriguez, General Register Number L25643, June 27, 1968. Question: on March 12, 2008, Mabini was charged with murder for fatally stabbing Emilio. To prove the qualifying circumstance of evident premeditation, the prosecution introduced on December 11, 2009 a text message, which Mabini's estranged wife Gregoria had sent to Emilio on the eve of his death. Reading: Honey, Patute and Uni. Mabini. Mtglen Nyang Plano I2. Mg Ngachub Kamatsugi. K. A subpoena ad testificandum was served on Gregoria for her to be presented for the purpose of identifying her cell phone and a text message. Mabini objected to her presentation on the ground of marital privilege. Resolve. Answer: the objection should be sustained on the ground of the Marital Disqualification Rule, Section 22, Rule 130, not on the ground of the Marital Privilege Communication Rule, Section 24, Rule 130. The marriage between Mabini and Georgia is still subsisting and the situation at bar does not come under the exceptions to the disqualification by reason of marriage. B. Suppose Mabini's objection in question A was sustained. The prosecution thereupon announced that it would be presenting Emilio's wife Gracena to identify Emilio's cell phone bearing Gregoria's text message. Mabini objected again. Rule on the objection. Answer: the objection should be overruled. The testimony of Gracena is not covered by the said marital disqualification rule because she is not the wife of Mabini. Besides, Gracena will identify only the cell phone as that of her husband Emilio, not the messages therein which to her are hearsay. C. If Mabini's objection in question B was overruled, can he object to the presentation of the text message on the ground that it is hearsay? Answer: no. Gregoria's text message in Emilio's cell phone is not covered by the hearsay rule because it is regarded in the rules of evidence as independently relevant statement. The text message is not to prove the truth of the fact alleged therein but only as to the circumstances of whether or not premeditation exists. D. Suppose that shortly before he expired, Emilio was able to send a text message to his wife Gracena. Reading Nazikskiko. D. Nami Mikahina. C. Mabiniang Magawani 2. Is this text message admissible as a dying declaration? Explain. 2010. Bar. Answer: yes, the text message is admissible as a dying declaration, since the same came from the victim who shortly expired, and it is in respect of the cause and circumstance of his death. The decisive factor that the message was made and sent under consciousness of an impending death is evidently attendant from the victim's statement, Dinami Makakanga, and the fact that he died shortly after he sent the message. However, cell phone messages are regarded as electronic evidence, and in a recent case, Ang vs. Court of Appeals et al., General Register No. 182835, April 20, 2010, the Supreme Court ruled that the rules on electronic evidence applies only to civil actions, quasi-judicial proceedings and administrative proceeding, not to criminal actions. Question: on August 15, 2008, Edgardo committed estafa against Petroniello in the amount of $3 million. Petroniello brought his complaint to the National Bureau of Investigation, which found that Edgardo had visited his lawyer twice, the first time on August 14, 2008 and the second on August 16, 2008, and that both visits concerned the swindling of Petroniello. During the trial of Edgardo, the RTC issued a subpoena ad testificandum to Edgardo's lawyer for him to testify on the conversations during their first and second meetings. May the subpoena be quashed on the ground of privileged communication? Explain fully. 2008 Bar. Answer: no, the subpoena may not be simply quashed on the Allegation that the testimony to be elicited constitutes privileged communication. It may be noted that the accused committed the crime of swindling on August 15, 2008, whereas he first visited his lawyers on August 14, 2008 or before he committed the swindling. Clearly the conversations the accused had with his lawyer during such first visit, before he committed the swindling, cannot be protected by the privilege between attorney and client, because the crime had not been committed yet and it is no part of the lawyer's professional duty to assist or aid in the commission of the crime, hence not in the course of professional employment. The second visit by accused Edgardo to his lawyer the next day, August 16, 2008, after the swindling was committed, may also suffer from the same infirmity as the conversations had during their first meeting, inasmuch as there could not be complaint made immediately after the estofa was committed. The privilege covering a lawyer-client relation under Section 24b, Rule 130, may not be invoked, as it is not a ground for quashal of a subpoena ad testificandum under Section 4, Rule 21 of the Rules of Court. Although the subpoena ad testificandum may not be quashed, the privilege covers conversations with a view to professional employment. It can be invoked at the trial but not quash the subpoena. Question: C is the child of the spouses H and W. H sued his wife W for judicial declaration of nullity of marriage under Article 36 of the Family Code. In the trial, the following testified over the objection of W, C, H and D, a doctor of medicine who used to treat W. Rule on W's objections, which are the following. A. H cannot testify against her because of the rule on marital privilege. Answer: the rule of marital privilege cannot be invoked in the annulment case under Article 36 of the Family Code because it is a civil case filed by one against the other, Section 22, Rule 130. B. C cannot testify against her because of the doctrine on parental privilege. Answer: the doctrine of parental privilege cannot likewise be invoked by W as against the testimony of C, their child. C may not be compelled to testify but free to testify against her, Section 25, Rule 130, Art. 215 F.C. C. D cannot testify against her because of the doctrine of privileged communication between patient and physician, 1998. Answer: D, as doctor who used to treat W, is disqualified to testify against W over her objection as to any advice or treatment given by him or any information which he may have acquired in his professional capacity, Section 24C, Rule 130. Question: Vida and Romeo are legally married. Romeo is charged in court with the crime of serious physical injuries committed against Selmo, son of Vida, stepson of Romeo. Vida witnessed the infliction of the injuries on Selmo by Romeo. The public prosecutor called Vida to the witness stand and offered her testimony as an eyewitness. Counsel for Romeo objected on the ground of the marital disqualification rule under the rules of court. A. Is the objection valid? Answer: while neither the husband nor the wife may testify for or against the other without the consent of the affected spouse. One exception is if the testimony of the spouse is in a criminal case for a crime committed by one against the other, or the latter's direct descendants or ascendants, Section 22, Rule 130. The case falls under this exception because Selma is the direct descendant of the spouse Vida. B. Will your answer be the same if Vida's testimony is offered in a civil case for recovery of personal property filed by Selma against Romeo? 2000 bar. Answer: Number. The marital disqualification rule applies this time. The exception provided by the rules is in a civil case by one spouse against the other. The case here involves a case by Selma for the recovery of personal property against Vida's spouse, Romeo. Question: Ziz, an alien, was criminally charged of promoting and facilitating child prostitution and other sexual abuses under Rep. Act No. 7610. The principal witness against him was his Filipino wife, ABC. Earlier, she had complained that Ziz's hotel was being used as a center for sex tourism and child trafficking. The defense counsel for Ziz objected to the testimony of ABC at the trial of the child prostitution case and the introduction of the affidavits she executed against her husband as a violation of espousal confidentiality and marital privilege rule. It turned out that Def, the minor daughter of ABC by her first husband who was a Filipino, was molested by Ziz earlier. Thus, ABC had filed for legal separation from Ziz since last year. May the court admit the testimony and affidavits of the wife, ABC, against her husband, Ziz, in the criminal case involving child prostitution? Reason: 2004 bar. Answer: Yes. The court may admit the testimony and affidavits of the wife against her husband in the criminal case where it involves child prostitution of the wife's daughter. It is not covered by the marital privilege rule. One exception thereof is where the crime is committed by one against the other or the latter's direct descendants or ascendants. Section 22, Rule 130. A crime by the husband against the daughter is a crime against the wife and directly attacks or vitally impairs the conjugal relation. Ortano v. Dickwigan, General Register No. L 39012. January 31, 1975. Question: John filed a petition for declaration of nullity of his marriage to Anne on the ground of psychological incapacity under Art. 36 of the Family Code. He obtained a copy of the confidential psychiatric evaluation report on his wife from the secretary of the psychiatrist. Can he testify on the said report without offending the rule on privileged communication? 2016 bar. Answer: Yes, John can testify. Under the rule on privileged communication, the husband or the wife, during or after the marriage, cannot be examined without the consent of the other as to any communication received in confidence by one from the other during the marriage except in a civil case filed by one against the other, or in a criminal case for a crime committed by one against the other or the latter's direct descendants or ascendants. Rule 130, Section 24A, Rules of Court. In this case, Anne cannot prevent John from testifying against her since the petition for a declaration of nullity is a civil case filed by one spouse against the other. Hence, the rule on privileged communication between the spouses does not apply. John could testify on the confidential psychiatric evaluation report of his wife that he obtained from the secretary of the psychiatrist, without offending the rule on privileged communication. Examination of a witness. Judicial Affidavit, AM No. 1288 SC. Question: What are the contents of a judicial affidavit? 2016 bar. Answer: A judicial affidavit shall be prepared in a language known to the witness and, if not in English or Filipino, accompanied by a translation in English or Filipino, and shall contain the following: a. The name, age, residence or business address, and occupation of the witness. b. The name and address of the lawyer who conducts or supervises the examination of the witness and the place where the examination is being held. c. A statement that the witness is answering the questions asked of him, fully conscious that he does so under oath, and that he may face criminal liability for false testimony or perjury. d. Questions asked of the witness and his corresponding answers, consecutively numbered, that 1. Show the circumstances under which the witness acquired the facts upon which he testifies. 2. Elicit from him those facts which are relevant to the issues that the case presents, and 3. Identify the attached documentary and object evidence and establish their authenticity in accordance with the rules of court. e. The signature of the witness over his printed name, and f. A jurat with the signature of the notary public who administers the oath or an officer who is authorized by law to administer the same. Section 3, AM number 1288 SC. Judicial Affidavit Rule. Question: Pedro was charged with theft for stealing Juan's cell phone worth 20,000 pesos. Prosecutor Mary Lag at the pretrial submitted the judicial affidavit of Juan, attaching the receipt for the purchase of the cell phone to prove civil liability. She also submitted the judicial affidavit of Mario, an eyewitness who narrated therein how Pedro stole Juan's cell phone. At the trial, Pedro's lawyer objected to the prosecution's use of judicial affidavits of her witnesses considering the imposable penalty on the offense with which his client was charged. 2015. A. Is Pedro's lawyer correct in objecting to the judicial affidavit of Mario? Answer: yes, Pedro's lawyer is correct in objecting to the judicial affidavit of Mario. The judicial affidavit rule shall apply only to criminal actions where the maximum of the imposable penalty does not exceed 6 years. Section 9A, 1, AM number 1289 SC or the judicial affidavit rule. Here, the maximum imposable penalty for the crime of theft of a cell phone worth 20,000 is prison mayor in its minimum to medium periods, or 6 years and 1 day to 8 years and 1 day. Thus, Pedro's lawyer is correct in objecting to the judicial affidavit of Mario. B. Is Pedro's lawyer correct in objecting to the judicial affidavit of Juan? Answer: number Pedro's lawyer is not correct in objecting to the judicial affidavit of Juan because the judicial affidavit rules apply with respect to the civil aspect of the actions, regardless of the penalties involved. Section 9, AM number 1288 SC or the judicial affidavit rule. Here the judicial affidavit of Juan was offered to prove the civil liability of Pedro. Thus, the objection of Pedro's lawyer to the judicial affidavit of Juan is not correct. C. At the conclusion of the prosecution's presentation of evidence, Prosecutor Mario Lagorlia offered the receipt attached to Juan's judicial affidavit, which the court admitted over the objection of Pedro's lawyer. After Pedro's presentation of his evidence, the court rendered judgment finding him guilty as charged and holding him civilly liable for 20,000 pesos. Pedro's lawyer seasonably filed a motion for reconsideration of the decision asserting that the court erred in awarding the civil liability on The basis of one's judicial affidavit, documentary evidence which prosecutor Marilag failed to orally offer. Is the motion for reconsideration meritorious? 2015 bar. Answer: The motion for reconsideration is not meritorious. The judicial affidavit is not required to be orally offered as separate documentary evidence, because it is filed in lieu of the direct testimony of the witness. It is offered at the time the witness is called to testify, and any objection to it should have been made at the time the witness was presented. Section 6 and 8, AM number 1288 SC or the judicial affidavit. Rule: since the receipt attached to the judicial affidavit was orally offered, there was enough basis for the court to award civil liability. Question: aside from asking a witness to explain and supplement his answer in the cross-examination, can the proponent ask in redirect examination questions on matters not dealt with during cross-examination? 1997 bar. Answer: yes. On redirect examination, questions on matters not dealt with during the cross-examination may be allowed by the court in its discretion. Section 7, Rule 132. Question: aside from asking the witness on matters stated in his redirect examination, can the opponent in his recross examination ask questions on matters not dealt with during the redirect? 1997 bar. Answer: yes. The opponent in his recross examination may also ask questions on such other matters as may be allowed by the court in its discretion. Section 8, Rule 132. Question: after plaintiff has formally submitted his evidence, he realized that he had forgotten to present what is considered an important evidence. Can he recall a witness? 1997 bar. Answer: yes. After formally submitting his evidence, the plaintiff can recall a witness with leave of court. The court may grant or withhold leave in its discretion as the interests of justice may require. Section 9, Rule 132. Question: as counsel of an accused charged with homicide, you are convinced that he can be utilized as a state witness. What procedure will you take? 2006 bar. Answer: as counsel for the accused, I will advise my client to ask for a reinvestigation and convince the prosecutor for him to move for the discharge of my client as a state witness, or the accused can apply as a state witness with the Department of Justice pursuant to Republic Act No. 6981, the Witness Protection, Security and Benefit Act. The right to prosecute vests the prosecutor with a wide range of discretion, including what and whom to charge. Soberano v. People, General Register No. 154629. October 5, 2005. Admissions and confessions. Question: A was accused of having raped X. Rule on the admissibility of the following pieces of evidence. A. An offer of A to marry X, and answer: A's offer to marry X is admissible in evidence and implied admission of guilt because rape cases are not allowed to be compromised. Section 27, Rule 130, People v. Domingo, General Register No. 97921, September 8, 1993. B. A pair of short pants allegedly left by A at the crime, which the court, over the objection of A, required him to put on, and when he did, it fit him well. 1998. Bar. Answer: the pair of short pants, which fit the accused well, is circumstantial evidence of his guilt, although standing alone It cannot be the basis of conviction. The accused cannot object to the court requiring him to put the short pants on. It is not part of his right against self-incrimination because it is a mere physical act. Question: A. While driving his car, ran over B. A. Visited B at the hospital and offered to pay for his hospitalization expenses after the filing of the criminal case against A. For serious physical injuries through reckless imprudence, A's insurance carrier offered to pay for the injuries and damages suffered by B. The offer was rejected because B considered the amount offered was inadequate. A. Is the offer by A to pay hospitalization expenses of B admissible in evidence? Answer: the offer by A to pay the hospitalization expenses of B is not admissible in evidence to prove his guilt in both civil and criminal cases. Section 27(4), Rule 130. B. Is the offer by A's insurance carrier to pay for injuries and damages of B admissible in evidence? 1997 bar. Answer: It is irrelevant. The obligation of the insurance company is based on the contract of insurance and is not admissible in evidence against the accused because it was not offered by the accused but by the insurance company, which is not his agent. Res inter alios acta rule. Question: Bimble was charged with rape. Bimble's father, Ramil, approached Ardman, the victim's father, during the preliminary investigation and offered $1 million to Ardman to settle the case. Ardman refused the offer. A. During trial, the prosecution presented Ardman to testify on Ramil's offer and thereby establish an implied admission of guilt. Is Ramil's offer to settle admissible in evidence? Answer: The offer to settle not being made by the accused or with his participation is not admissible against him under the rule of res inter alios acta. No implied admission of guilt can be drawn from efforts to settle a criminal case out of court, where the accused had no participation in such negotiation. People v. Godoy, General Register Nos. 115908-09, December 6, 1995. B. During the pre-trial, Bimble personally offered to settle the case for $1 million to the private prosecutor, who immediately put the offer on record in the presence of the trial judge. Is Bimble's offer a judicial admission of his guilt? 2008 bar. Answer: The offer is not a judicial admission of guilt because it has not been reduced in writing or signed by the accused. The rule on pre-trial and criminal cases, Section 2, Rule 118, requires that all agreements or admissions made or entered during the pre-trial conference shall be reduced in writing and signed by the accused and counsel, otherwise, they cannot be used against the accused. Question: What are the requirements in order that an admission of guilt of an accused during a custodial investigation be admitted in evidence? 2006 bar. Answer: An admission of guilt during a custodial investigation is a confession. To be admissible in evidence, the requirements are: 1. The confession must be voluntary. 2. The confession must be made with the assistance of competent and independent counsel. 3. The confession must be express. And 4. The confession must be in writing. People v. Principe. General Register No. 135862, May 2, 2002. Question: If the accused on the witness stand repeats his earlier uncounseled extrajudicial confession implicating his co-accused in the crime charged, is that testimony admissible in evidence against the latter? 1998 bar. Answer: yes. The accused can testify by repeating his earlier uncounseled extrajudicial confession, because he can be subjected to cross-examination. Question: what is the probative value of a witness affidavit of recantation? 1998 bar. Answer: on the probative value of an affidavit of recantation, courts look with disfavor upon recantations because they can easily be secured from witnesses, usually through intimidation or for a monetary consideration. Recanted testimony is exceedingly unreliable. There is always the probability that it will be repudiated. Molina vs. People, General Register Nos. 70,168-69, July 24, 1996. Question: X and Y were charged with murder. Upon application of the prosecution, Y was discharged from the information to be utilized as a state witness. The prosecutor presented Y as witness but forgot to state the purpose of his testimony, much less offer it in evidence. Y testified that he and X conspired to kill the victim, but it was X who actually shot the victim. The testimony of Y was the only material evidence establishing the guilt of X. Y was thoroughly cross-examined by the defense counsel. After the prosecution rested its case, the defense filed a motion for demurrer to evidence based on the following grounds. 1. The testimony of Y should be excluded because its purpose was not initially stated and it was not formally offered in evidence as required by Section 34, Rule 132 of Rules of Evidence, and 2. Y's testimony is not admissible against X pursuant to the Rule on Reasonter alios acta. Rule on the motion for demurrer to evidence on the above grounds. 2003 bar. Answer: the demurrer to the evidence should be denied because 1. The testimony of Y should not be excluded because the defense counsel did not object to his testimony despite the fact that the prosecutor forgot to state its purpose or offer it in evidence. Moreover, the defense counsel thoroughly cross-examined Y and thus waived the objection. 2. The Reasonter alios acta rule does not apply because Y testified in open court and was subjected to cross-examination. Question: arrested in a buy-bust operation, Edmund was brought to the police station where he was informed of his constitutional rights. During the investigation, Edmund refused to give any statement. However, the arresting officer asked Edmund to acknowledge in writing that six sachets of shabu were confiscated from him. Edmund consented and also signed a receipt for the amount of 3,000 pesos, allegedly representing the purchase price of the shabu. At the trial, the arresting officer testified and identified the documents executed and signed by Edmund. Edmund's lawyer did not object to the testimony. After the presentation of the testimonial evidence, the prosecutor made a formal offer of evidence which included the documents signed by Edmund. Edmund's lawyer objected to the admissibility of the documents for being the fruit of the poison tree. Resolve the objection with reasons. 2009 bar. Answer: the objection to the admissibility of the documents which the arresting officer asked Edmund to sign without the benefit of counsel is well taken. Said documents having been signed by the accused while under custodial investigation imply an admission without the benefit of counsel that the shabu came from him and that the 3,000 was received by him pursuant to the illegal selling of the drugs. Thus, it was obtained by the arresting officer in clear violation of Section 12(3), Article 3 of the 1987 Constitution, particularly the right to be assisted by the counsel during custodial investigation. Moreover, the objection to the admissibility of the evidence was timely made, that is, when the same is formally offered. Hearsay rule. Exceptions. Question. Distinguish clearly but briefly between hearsay evidence and opinion evidence. 2004 bar. Answer. Hearsay evidence consists of testimony that is not based on personal knowledge of the person testifying. See Section 36. Rule 130, while opinion evidence is expert evidence based on the personal knowledge, skill, experience or training of the person testifying. Section 49, id, and evidence of an ordinary witness on limited matters. Section 50, id. Question. What are the exceptions to hearsay rule? 1999 bar. Answer. The exceptions to the hearsay rule are, dying declaration, declaration against interest, act or declaration about pedigree, family reputation or tradition regarding pedigree, common reputation, part of the res gesti, entries in the course of business, entries in official records, commercial lists and the like, learned treatises, and testimony or deposition at a former proceeding. Sections 37 to 47, Rule 130. Question. A foreign dog trained to sniff dangerous drugs from packages was hired by FTP Corporation, a door-to-door forwarder company, to sniff packages in their depot at the international airport. In one of the itinerary inspections of packages waiting to be sent to the United States of America, USA, the dog sat beside one of the packages, a signal that the package contained dangerous drugs. Thereafter, the guards opened the package and found 2 kilograms of cocaine. The owner objected of the package was arrested and charges were filed against him. During the trial, the prosecution, through the trainer who was present during the incident and an expert in this kind of field, testified that the dog was highly trained to sniff packages to determine if the contents were dangerous drugs, and the sniffing technique of their highly trained dogs was accepted worldwide and had been successful in dangerous drugs operations. The prosecution moved to admit this evidence to justify the opening of the package. The accused objected on the grounds that, the guards had no personal knowledge of the contents of the package before it was opened. 2. The testimony of the trainer of the dog is hearsay, and 3. The accused could not cross-examine the dog. Decide. 2014 bar. Answer. The objections of the accused should be overruled. Evidence is admissible when it is relevant to the issue and is not excluded by the law or the rules. Section 3, Rule 128. Under Section 36, Rules 130 of the Rules of Court, a witness can testify only to those which he knows of his personal knowledge and derived from his own perception. The contention that the guards had no personal knowledge of the contents of the package before it was opened is without merit. The guards can testify as to the facts surround the opening of the package, since they have personal knowledge of the circumstances thereof, being physically present at the time of its discovery. On the other hand, the testimony of the trainer of the dog is not hearsay based on the following grounds. A. He has personal knowledge of the facts and issue, having witnessed the same. B. Hearsay merely contemplates an out-of-court declaration of a person which is being offered to prove the truthfulness and veracity of the facts asserted therein. c. He is an expert witness, hence, his testimony may constitute an exception to the hearsay rule. d. The accused has the opportunity to cross-examine him. And e. Testimony of a witness as to statements made by non-human declarants does not violate the rule against hearsay. The law permits the so-called non-human evidence on the ground that machines and animals, unlike humans, lack a conscious motivation to tell falsehoods, and because the workings of machines can be explained by human witnesses who are then subject to cross-examination by opposing counsel. City of Webster Groves vs. Quick. 323 SW2D 386, Mo. 1959, Buck. vs. State, 138 p. 2D 115, Oklahoma 1943, Herrera, 1999. Conversely, the accused may not argue that he cannot cross-examine the dog as the constitutional right to confrontation refers only to witnesses, as alluded, the human witnesses, who have explained the workings of the non-human evidence is the one that should be cross-examined. Hence, the contention of the accused that he could not cross-examine the dog is misplaced. Ergo, there is no doubt that the evidence of the prosecution is admissible for being relevant and competent. Dying declaration. Question: Requisites of dying declaration, 1998 bar. Answer: The requisites for the admissibility of a dying declaration are: a. The declaration is made by the deceased under the consciousness of his impending death. b. The deceased was at the time competent as a witness. c. The declaration concerns the cause and surrounding circumstances of the declarant's death, and d. The declaration is offered in a criminal case wherein the declarant's death is the subject of inquiry. People v. Santos, General Register No. 94545, April 4, 1997. Question: Romeo is sued for damages for injuries suffered by the plaintiff in a vehicular accident. Ulita, a witness in court, testifies that Romeo told her, Ulita, that he, Romeo, heard Antonio, a witness to the accident, give an excited account of the accident immediately after its occurrence. Is Ulita's testimony admissible against Romeo over proper and timely objection? Why? 2002. Bar. Answer: No, Ulita's testimony is not admissible against Romeo, because while the excited account of Antonio, a witness to the accident, was told to Romeo, it was only Romeo who told Ulita about it, which makes it hearsay. Question: Maximo filed an action against Pedro, the administrator of the estate of deceased Juan, for the recovery of a car which is a part of the latter's estate. During the trial, Maximo presented witness Mariano, who testified that he was present when Maximo and Juan agreed that the latter would pay a rental of $20,000 for the use of Maximo's car for 1 month, after which Juan should immediately return the car to Maximo. Pedro objected to the admission of Mariano's testimony. If you were the judge, would you sustain Pedro's objection? Why? Answer: No, the testimony is admissible in evidence because witness Mariano, who testified as to what Maximo and Juan, the deceased person, agreed upon, is not disqualified to testify on the agreement. Those disqualified are parties or assigners of the parties to a case, or persons in whose behalf a case is prosecuted, against the administrator or Juan's estate, upon a claim or demand against his estate as to any Matter of fact occurring before one's death, Section 23, Rule 130. Question: the accused was charged with robbery and homicide. The victim suffered several stab wounds. It appears that 11 hours after the crime, while the victim was being brought to the hospital in a jeep, with his brother and a policeman as companions, the victim was asked certain questions which he answered, pointing to the accused as his assailant. His answers were put down in writing, but since he was in a critical condition, his brother and a policeman signed the statement. Is the statement admissible as a dying declaration? 1999 bar. Answer: yes. The statement is admissible as a dying declaration of the victim subsequently dies and his answers were made under the consciousness of impending death, Section 37, Rule 130. The fact that he did not sign the statement point to the accused as his assailant, because he was in critical condition, does not affect its admissibility as a dying declaration. A dying declaration need not be in writing. People v. Viocenti. General Register No. 118707, February 2, 1998. Family reputation or tradition regarding pedigree. Question: Linda and spouses Arnulfo and Regina Sears were cooners of a parcel of land. Linda died intestate and without any issue. 10 persons headed by Jocelyn, claiming to be the collateral relatives of the deceased Linda, filed an action for partition with the RTC praying for the segregation of Linda's half-share, submitting in support for their petition the baptismal certificates of 7 of the petitioners, a family Bible belonging to Linda in which the names of the petitioners have been entered, a photocopy of the birth certificate of Jocelyn, and a certification of the local civil registrar that its office had been completely razed by fire. The spouses Sears refused partition on the following grounds: 1. The baptismal certificates of the parish priest are evidence only of the administration of the sacrament of baptism, and they do not prove filiation of the alleged collateral relatives of the deceased. 2. Entry in the family Bible is hearsay. 3. The certification of the registrar on non-availability of the records of birth does not prove filiation. 4. In partition case where filiation to the deceased is in dispute, prior and separate judicial declaration of heirship and a settlement of estate proceedings is necessary. And 5. There is need for publication as real property is involved. As counsel for Jocelyn and her co-petitioners argue against the objections of the spouses Sears so as to convince the court to allow the partition. Discuss each of the five arguments briefly but completely. 2000 bar. Answer: 1. The baptismal certificate can show the filiation or prove pedigree. It is one of the other means allowed under the rules of court and special laws to show pedigree. Trinidad v. Court of Appeals, General Register No. 118904, April 20, 1998, heirs of Ignacio Conti v. Court of Appeals, General Register No. 118464, December 21, 1998. 2. Entries in the family Bible may be received as evidence of pedigree, Section 40, Rule 130. 3. The certification by the civil registrar of the non-availability of records is needed to justify the presentation of secondary evidence, which is the photocopy of the birth certificate of Jocelyn, heirs of Ignacio Conti v. Court of Appeals, Supra. 4. Declaration of heirship in a settlement proceeding is not necessary. It can be made in the ordinary action for partition wherein the heirs are exercising the right pertaining to the decedent, their predecessor in interest, to ask for partition as co-owners, id. 5. Even if real property is involved, no publication is necessary, because what is sought is the mere segregation of Linda's share in the property, Section 1, Rule 69, id. Part of the res gesti. Question: Densho barged into the house of Marcella, tied her to a chair and robbed her of assorted pieces of jewelry and money. Densho then brought Candida, Marcella's maid, to a bedroom where he raped her. Marcella could hear Candida crying and pleading, "Huwag Mawakasa." Akin. After raping Candida, Densho fled from the house with loot. Candida then untied Marcella and rushed to the police station about a kilometer away and told police officer Roberto Mawa that Densho had barged into the house of Marcella, tied the latter to a chair and robbed her of her jewelry and money. Candida also related to the police officer that despite her pleas, Densho had raped her. The policeman noticed that Candida was hysterical and on the verge of collapse. Densho was charged with robbery with rape. During the trial, Candida can no longer be located. A. If the prosecutor presents police officer Roberto Mawa to testify on what Candida had told him, would such testimony of the policeman be hearsay? Explain. 1999, 2009 bar. Answer: The testimony of the policeman is not hearsay. It is part of the res gesti. It is also an independently relevant statement. The police officer testified his own personal knowledge, not to the truth of Candida's statement, that is, that she told him, despite her pleas, Densho has raped her. People vs. Caddy, General Register No. 74065, February 27, 1989. B. If the police officer will testify that he noticed Candida to be hysterical and on the verge of collapse, would such testimony be considered as opinion? Hence, inadmissible? Explain. 2005 bar. Answer: It cannot be considered as an opinion, because he was testifying on what he actually observed. The last paragraph of Section 50, Rule 130, Revised Rules of Evidence, expressly provides that a witness may testify on his impressions of the emotion, behavior, condition or appearance of a person. Question: While passing by a dark uninhabited part of their barangay, P.O.2 Asintado observed shadows and heard screams from a distance. P.O.2 Asintado hid himself behind the bushes and saw a man beating a woman, whom he recognized as his neighbor, Kulasa. When Kulasa was already in agony, the man stabbed her and she fell on the ground. The man hurriedly left thereafter. P.O.2 Asintado immediately went to Kulasa's rescue. Kulasa, who was then in a state of hysteria, kept mentioning to P.O.2 Asintado si Rene, gusto akong patain. Sinax Kniako. When P.O.2 Asintado was about to carry her, Kulasa refused and said Kaya ko mababalang to Hambilan mo si Rene. The following day, Rene learned of Kulasa's death and, bothered by his conscience, surrendered to the authorities with his counsel. As his surrender was broadcasted all over media, Rene opted to release his statement to the press, which goes: I believe that I am entitled to the presumption of innocence until my guilt is proven beyond reasonable doubt. Although I admit that I performed acts that may take one's life away, I hope and pray that justice will be served in the right way. God bless us all. Signed, Renee. The trial court convicted Renee of homicide on the basis of P.O.2 Asentato's testimony, Koulas's statements, and Renee's statement to the press. On appeal, Renee raises the following errors. A. The trial court erred in giving weight to P.O.2 Asentato's testimony, as the latter did not have personal knowledge of the facts and issue, and violated Renee's right to due process when it considered Koulas's statements despite lack of opportunity for her cross-examination. Answer: the trial court did not err in giving weight to P.O.2 Asentato's testimony. While a witness can only testify as to those facts which he has personal knowledge, the rules provide that a statement made under the influence of a startling event witnessed by the person who made the declaration before he had time to think and make up a story, or to concoct or contrive a falsehood, or to fabricate an account, and without any undue influence in obtaining it, aside from referring to the event in question or its immediate attending circumstances, is an exception being part of res gesti, Belbis Jr., versus People, General Register. Number 181052, November 14, 2012. In the case, the statements made by P.O.2 Asentato constitutes part of res gesti since the same were made without any opportunity to fabricate and while a startling occurrence was actually taking place. In addition, the statement of P.O.2 Asentato may fall within the purview of the doctrine of independent relevant statement, where only the fact that such statements were made is relevant, and the truth and falsity thereof is immaterial. People vs. Byron, General Register Number 178301, April 24, 2009. On the other hand, Koulas's statements are also admissible as part of res gesti since the same were made under the influence of a startling event and without any opportunity to concoct or devise a falsehood. B. The trial court erred in holding that Renee's statement to the press was a confession which, standing alone, would be sufficient to warrant a conviction. Resolve. 2014 Bar. Answer: the trial court did not err in holding that Renee's statement to the press is a confession. Renee's confessions to the media were properly admitted because statements spontaneously made by a suspect to news reporters on a televised interview are deemed voluntary and are admissible in evidence. People vs. Hipona, General Register Number 185709, February 18, 2010. Entries in official records. Question: X was charged with robbery. On the strength of a warrant of arrest issued by the court, X was arrested by police operatives. They seized from his person a handgun. A charge for illegal possession of firearm was also filed against him. In a press conference called by the police, X admitted that he had robbed the victim of jewelry valued at 500,000 pesos. The robbery and illegal possession of firearm cases were tried jointly. The prosecution presented in evidence a newspaper clipping of the report to the reporter who was present during the press conference stating that X admitted the robbery. It likewise presented a certification of the plug-and-play firearms and explosive office attesting that the accused had no license to carry any firearm. The certifying officer, however, was not presented as a witness. Both pieces of evidence were objected to by the defense. A. Is the newspaper clipping admissible in evidence against X? Answer: yes, The newspaper clipping is admissible in evidence against text regardless of the truth or falsity of a statement. The hearsay rule does not apply and the statement may be shown where the fact that it is made relevant evidence as to making of such statement is not secondary but primary, for the statement itself may constitute a fact an issue or be circumstantially relevant as to the existence of such fact. Gotesco Investment Corporation vs. Chado, General Register Number L 87584. June 16, 1992. B. Is the certification of the plug-and-play firearm and explosive office without the certifying officer testifying on it admissible in evidence against X? 2003 bar. Answer: yes, the certification is admissible in evidence against X because a written statement signed by an officer having the custody of an official record or by his deputy that after diligent search no record or entry of a specified tenor is found to exist in the records of his office, accompanied by a certificate as above provided, is admissible as evidence that the records of his office contain no such record of entry. Section 28, Rule 132. Opinion Rule. Question: at Nolan's trial for possession and use of the prohibited drugs, known as shabu, his girlfriend Kim testified that on a particular day, she would see Nolan very prim and proper, alert and sharp, but that 3 days after, he would appear haggard, tired and overly nervous at the slightest sound he would hear. Nolan objects to the admissibility of Kim's testimony on the ground that Kim merely stated her opinion without having been first qualified as expert witness. Should you, as a judge, exclude the testimony of Kim? 1994 bar. Answer: no, the testimony of Kim should not be excluded. Even though Kim is not an expert witness, Kim may testify on her impressions of the emotion, behavior, condition or appearance of a person. Section 50, last part, Rule 130. Character evidence. Question: D was prosecuted for homicide for allegedly beating up V to death with an iron pipe. A. May the prosecution introduce evidence that V had a good reputation for peacefulness and nonviolence? Why? Answer: the prosecution may introduce evidence of the good or even bad moral character of the victim if it tends to establish in any reasonable degree the probability or improbability of the offense charged. Section 51(3), Rule 130. In this case, the evidence is not relevant. B. May D introduce evidence of specific violent acts by V? Why? 2002 bar. Answer: yes, D may introduce evidence of specific violent acts by versus evidence that one did or did not do a certain thing at one time is not admissible to prove that he did or did not do the same or a similar thing at another time, but it may be received to prove a specific intent or knowledge, identity, plan, system, scheme, habit, custom or usage, and the like. Section 34, Rule 130. Question: in a prosecution for murder, the prosecutor asks accused Darwin if he had been previously arrested for violation of the Anti-Graft and Corrupt Practices Act. As defense counsel, you object. The trial court asks you on what ground. S. Respond. 2010 bar. Answer: the objection is on the ground that the facts sought to be elicited by the prosecution is irrelevant and immaterial to the offense under prosecution and trial. Moreover, the rules do not allow the prosecution to adduce evidence of bad moral character of the accused pertinent to the offense charged, except on rebuttal and only if it involves a prior conviction by final judgment. Section 51, Rule 130. Offer and objection. Question: what are the two kinds of objections? Explain each. Briefly. Give example each. 1997 bar. Answer: two kinds of objections are, 1. The evidence being presented is not relevant to the issue, and, 2. The evidence is incompetent or excluded by the law or the rules. Section 3, Rule 138. An example of the first is when the prosecution offers as evidence the alleged offer of an insurance company to pay for the damages suffered by the victim in a homicide case. Examples of the second are evidence obtained in violation of the constitutional prohibition against unreasonable searches and seizures and confessions and admissions in violation of the rights of a person under custodial investigation. Question: a trial court cannot take into consideration in deciding a case an evidence that has not been formally offered. When are the following pieces of evidence formally offered? 1994, 1997 bar. A. Testimonial evidence. Answer: testimonial evidence is formally offered at the time the witness is called to testify. Section 35. First par, Rule 132. B. Documentary evidence. Documentary evidence is formally offered after the presentation of the testimonial evidence. Section 35, second part. Rule 132. C. Object evidence. Answer: the same is true with object evidence. It is also offered after the presentation of the testimonial evidence. Question: counsel objected to a question posed by opposing counsel B on the grounds that it was hearsay and it assumed a fact not yet established. The judge banged his gavel and ruled by saying objection sustained. Can counsel 8 ask for a reconsideration of the ruling? Why? 2012 bar. Answer: yes, counsel B may ask the judge to specify the ground S relied upon for sustaining the objection and thereafter move its reconsideration thereof. Section 38, Rule 132. Revised Rules on Summary Procedure. Prohibited pleadings and motions. Question: charged with the offense of slight physical injuries under an information duly filed with the METC in Manila, which in the meantime had duly issued an order declaring that the case shall be governed by the revised rule on summary procedure, the accused filed with said court a motion to quash on the sole ground that the officer who filed the information had no authority to do so. The METC denied the motion on the ground that it is a prohibited motion under the said rule. The accused thereupon filed with the RTC in Manila a petition for certiorari in summa sailing and seeking the nullification of the METC denial of his motion to quash. The RTC in due time issued an order on the ground that it is not allowed by the said rule. The accused forthwith filed with said RTC a motion for reconsideration of its said order. The RTC in time denied said motion for reconsideration on the ground that the same is also a prohibited motion under the said rule. Were the RTC's orders denying due course to the petition as well as denying the motion for reconsideration correct? Reason: 2004 bar. Answer: the RTC's orders denying due course to the petition for certiorari as well as denying the motion for reconsideration are both not correct. The petition for certiorari is a prohibited pleading under Section 19G of the revised rule on summary procedure, and the motion for reconsideration, while it is not prohibited motion, Lucas vs. Fabros, AM number MTJ 99-1226, January 31, 2000, citing Javan vs. Court of Appeals, General Register number 80739, August 20, 1992, should be denied. Because the petition for certiorari is a prohibited pleading. Rules of Procedure for Environmental Cases. AM number 0968 SC. Question: what do you understand about the precautionary principle under the Rules of Procedure for Environmental Cases? 2012 Bar. Answer: precautionary principle states that when human activities may lead to threats of serious and irreversible damage to the environment that is scientifically plausible but uncertain, action shall be taken to avoid or diminish that threat. In its essence, the precautionary principle calls for the exercise of caution in the face of risk and uncertainty. Section 4, F, Rule 1. Part 1, and Rule 20, AM number 0968 SC, Rules of Procedure for Environmental Cases. Writ of Continuing Mandamus. Question: Hannibal, Donna, Florence, and Joel, concerned residents of Laguna de Bay, filed a complaint of mandamus against the Laguna Lake Development Authority, the Department of Environment and Natural Resources, the Department of Public Works and Highways, Department of Interior and Local Government, Department of Agriculture, Department of Budget and Philippine National Police before the RTC of Laguna, alleging that the continued neglect of defendants in performing their duties has resulted in serious deterioration of the water quality of the lake and the degradation of the marine life in the lake. The plaintiffs prayed that said government agencies be ordered to clean up Laguna de Bay and restore its water quality to Class C waters as prescribed by Presidential Decree 1151, otherwise known as the Philippine Environment Code. Defendants raised the defense that the cleanup of the lake is not a ministerial function and they cannot be compelled by mandamus to perform the same. The RTC of Laguna rendered a decision declaring that it is the duty of the agency to clean up Laguna de Bay and issued a permanent writ of mandamus ordering said agencies to perform their duties prescribed by law relating to the cleanup of Laguna de Bay. D. Is the RTC correct in issuing the writ of mandamus? Explain. E. What is the writ of continuing mandamus? 2016. Bar. Answer. A. Yes, the RTC is correct in issuing the writ of mandamus. Generally, the writ of mandamus lies to require the execution of a ministerial duty, while the implementation of the government agency's mandated tasks may entail a decision-making process, the enforcement of the law, or the very act of doing what the law exacts to be done is ministerial in nature and may be compelled by mandamus. Here, the duty to clean up Laguna Lake and restore its water quality to Class C is required not only by Presidential Decree No. 1152, otherwise known as the Philippine Environment Code, but also in its charter. It is, thus, ministerial in nature and can be compelled by mandamus. Accordingly, the RTC may issue a writ of continuing mandamus directing any agency or instrumentality of the government or officer thereof to perform an act or series of acts decreed by final judgment which shall remain effective until the judgment is fully satisfied. Metropolitan Manila Development Authority vs. Concerned Residents of Manila Bay, General Register Numbers 171,947-48. December 18, 2008. B. A writ of continuing mandamus is a writ issued when any agency or instrumentality of the government or officer thereof unlawfully neglects the performance of an act which the law specifically enjoins as a duty resulting from an office, trust or station in connection with the enforcement or violation of an environmental law, rule, or regulation or a right therein, or unlawfully excludes another from the use or enjoyment of such right, and there is no other plain, speedy and adequate remedy in the ordinary course of law, the person aggrieved thereby may file a verified petition in the proper court, alleging the facts with certainty, attaching thereto supporting evidence, specifying that the petition concerns an environmental law, rule or regulation, and praying that judgment be rendered commanding the respondent to do an act or series of acts until the judgment is fully satisfied, and to pay damages sustained by the petitioner by reason of malicious neglect to perform the duties of the respondent, under the law, rules or regulations. The petition shall also contain a sworn certification of non-forum shopping. AM number 0968 SC, also known as Rules of Procedure for Environmental Cases. A writ of continuing mandamus is a writ issued by a court in an environmental case directing any agency or instrumentality of the government or officer thereof to perform an act or series of acts decreed by final judgment, which shall remain effective until judgment is fully satisfied. Section 7, Rule 8, AM number 0968 SC, also known as Rules of Procedure for Environmental Cases. Writ of Calicus. Question: the officers of Ankaplagiranayalugan, Incorporated, engaged your services to file an action against ABC Mining Corporation, which is engaged in mining operations in Sda, Cruz, Marinjek. ABC used highly toxic chemicals in extracting gold. ABC's toxic mine tailings were accidentally released from its storage dams and were discharged into the rivers of said town. The mine tailings found their way to Kalankan Bay, allegedly to the waters of nearby Ramblin and Quezon. The damage to the crops and loss of earnings were estimated at 1 billion. Damage to the environment is estimated at 1 billion. As a lawyer for the organization, you are requested to explain the advantages derived from a petition for writ of Calicus before the Supreme Court over a complaint for damages before the RTC of Marinjek or vice versa. What action will you recommend? Explain. 2016 Bar. Answer: as a lawyer for the organization, I would recommend the filing of a petition for issuance of a writ of Calicus. The writ of Calicus is a remedy available to a natural or juridical person, entity authorized by law, people's organization, non-governmental organization, or any public interest group accredited by or registered with any government agency, on behalf of persons whose constitutional right to a balanced and healthful ecology is violated, or threatened with violation by an unlawful act or omission of a public official or employee, or private individual or entity, involving environmental damage of such magnitude as to prejudice the life, health or property of inhabitants in 2 or more cities or provinces. Section 1 of Rule 7, AM number 0968 SC, also known as Rules of Procedure for Environmental Case. The following reliefs may be included under the writ of Calicus. A. Directing respondent to permanently cease and desist from committing acts or neglecting the performance of duty in violation of environmental laws resulting in environmental destruction or damage. b. Directing the respondent public official, government, agency, private person or entity to protect, preserve, rehabilitate or restore the environment. C. Directing the respondent public official, government, agency, private person or entity to monitor strict compliance with the decision and orders of the court. D. Directing the respondent public official, government, agency, or private person or entity to make periodic reports on the execution of the final judgment, and e. Such other reliefs which relate to the right of the people to a balanced and healthful ecology or to the protection, preservation, rehabilitation or restoration of the environment, except the award of damages to individual petitioner. Section 15, Rule 7, Ibid. The rules also provide interim reliefs in favor of the petitioner upon filing a verified motion, namely, a. Ocular inspection, b. Production or inspection of documents or things. Section 12, Rule 7, Ibid. Additionally, the petition for writ of qualification is more advantageous compared to a complaint for damages before the RTC because it may be filed directly with the Supreme Court or with any of the stations of the Court of Appeals. Unlike a complaint for damages before the RTC which only be filed by a real party in interest as defined in Rule 3.2 of the Rules of Court, the rule on locus standi is relaxed in petitions for writ of qualification which allows the petition to be filed by parties as citizen suit. In addition, any of the following may file a petition for writ of qualification: a. Natural or juridical person, b. Entity authorized by law, or c. POs, NGOs, or any public interest group accredited by or registered with any government agency on behalf of persons whose constitutional right to a balanced and healthful ecology is violated. Section 1, Rule 7. Ibid. Besides, the petition for writ of qualification is exempted from the payment of docket fees. From the foregoing, it is clear that filing a petition for writ of qualification would be the best remedy to address all the environmental problems caused by the release of the toxic waste to the waters of Ramblin and Quezon without the burden of paying docket fees. After all, the filing of a petition for the issuance of writ of qualification shall not preclude the filing of separate civil, criminal, or administrative actions. Thus, the organization can later file a complaint for damages with a regional trial court, should they desire to do so. At any rate, the rules provide that judgment must be rendered within 60 days from the time the petition is submitted for decision, which expedites the proceedings, significantly considering the urgency of situation in the instant case. As lawyer for the organization, I would recommend, therefore, the filing of a petition for a writ of qualification with the Supreme Court.